All right, good morning, everyone. My name is Joaquin Escobar, Chair of the State Water Resources Control Board. Today is Tuesday, August 5th. It is 9:05 a.m., and I'd like to call this meeting to order. I'll begin by introducing my fellow board colleagues. Joining me this morning is Vice Chair Doreen Diadamo, Board Member Sean McGuire, and Board Member Laurel Firestone. We're also joined by our Executive Director, Eric Oppenheimer, our two Chief Deputies, Karen Mogus and Eric Ekdahl, our Chief Counsel, Michael Loffer, our Clerk of the Board is Courtney Tyler, and assisting her this morning is Margie Argel and Susan Reyes. As you can see, this is actually a hybrid meeting with both in-person and virtual components. If you're joining us virtually, you should be viewing us through our traditional webcast on the YouTube live website or the Cali PA website. But if you intend on commenting on any of today's items, you need to be on the Zoom platform. There is a link at the top of the agenda, a form to fill out, and instructions how to get onto the platform. But if you're having any challenges getting onto the platform, please do just email the clerk of the board at board.clerk@waterboards.ca.gov, and she can help get you on the platform. Once you are on the platform, your camera will be off. You will be on mute until it's your turn to speak on the item you've indicated. For everyone here in the room, good morning. Good to see everyone. We're here in Sacramento in the California Environmental Protection Agency building. A few announcements for us as well. Please do observe the exits. If we happen to have an emergency, we'll calmly file out to Cesar Chavez Plaza and await further directions. Also, if you intend on commenting on any of today's items, there is a QR code and a laptop at the side of the room to sign up. If you're having any challenges, though, please do just speak to the clerk of the board and we can get you signed up. Once you are at the mic, please, if you feel comfortable, introduce yourself, any affiliation you are with. And please, lastly, silence any phones just so we have an uninterrupted discussion and meeting this morning. This morning, we're kicking off our meeting with a Superior Accomplishment Award and would like to call up Robert Cervantes from the Division of Water Rights to present the award. And I'm not seeing Mr. Cervantes in the room. And so if there is someone else from the Division of Water Rights who would like to set up, Mr. Ekdahl.
So unfortunately, I am unaware of this accomplishments award unless I can steal something, at which point I will totally okay. I'll go from this crib sheet. So this is related to the establishment of a drone program in the Division of Water Rights related to enforcement. And it's a process that took a couple of years. There was a pretty substantial set of administrative requirements to make sure that, one, the drone program was fully compliant with state and federal law. Two, that the use of drones for enforcement followed adequate legal protections for privacy and Fourth Amendment unreasonable search and seizure. The Office of Enforcement was heavily engaged. Office of Chief Counsel was heavily engaged, reviewing the different workloads. The Division of Administrative Services was engaged, reviewing some of the work that we had put together. But ultimately, it relied on a core set of key staff that were responsible for identifying the drones, doing kind of the procurement process, identifying which ones worked best, making sure that we had the resources to purchase them. You have to learn how to fly them. You have to learn how to do the data analysis that goes with it. But the long and short of it is that now we have a number of certified drone pilots that can be used for enforcement actions. It was really piloted in the cannabis enforcement section. What staff found was that by going out into some of these very remote places, it's not easy necessarily to go through the woods, into ravines, through very complicated terrain that could be booby-trapped and have kind of some significant safety concerns. And so having a drone that could go up and take these pictures would be really critical. And so with that, I'd like to let's see, I don't have the certificates with me, but if staff can perhaps come up and stand along the edge, as I call their name, Scott Shiranaka. Come on up. And Scott really took leadership in developing the drone program. A lot of the work was directly under Scott's purview, and huge thank you, huge congratulations. This is a really significant accomplishment and something to be pretty excited about. Lane King. Jennifer Timmons. Chris Bymus, Chris Van de Wingard, Jordan Baser, Anessa Rodriguez, from the Department of Information Technology, Jeff Capellas, and Carson Capps. That's the team. So with that, thank you. And Robert Cervantes in the back, you can come on up too. And I don't know, Robert, if you have any additional words you'd want to add.
What microphone should I grab?
Okay.
Apologies for my tardiness. I got caught up on light rail.
Yep.
Do I have time to just run through a couple of paragraphs? I mean, they
course.
did such good work. It was amazing. So my name is Robert Cervantes. I work for the Division of Water Rights, and it is my honor today to recognize a remarkable team of professionals from across multiple business units who led the development of the first ever unmanned aerial vehicle program at the State Water Board. For those of you following at home, UAVs are drones. From February 2023 through April of 2025, this team researched federal aviation requirements for state-operated drone programs, coordinated with multiple board divisions and partner state agencies, and conducted extensive drone and software evaluations. Their efforts culminated in a comprehensive operations manual and guidance document that ensures safe, effective, and legally defensible drone use throughout the division and the state board. The division's UAV program is now fully operational and is already being used to collect high-quality spatial data, monitor and document remote areas, and support formal enforcement actions, including compliance inspections, cannabis investigations, and compliance response activities. This was a ground-up initiative that not only brought innovation to the division, but also set a precedent for responsible technology integration across the water boards. The team's work reflects outstanding interagency collaboration, technical leadership, and a forward-thinking approach to environmental protection. Please join me in congratulating this outstanding team for their vision, dedication, and trailblazing contributions. Once again, thanks, everybody. Great job.
Just huge congratulations and thanks. You know, the ability for us to innovate, incorporate new technologies, to be able to do more with always, not an over-resourced agency is just really critical. So thank you all. Thanks for the leadership and really here ensuring that we're able to use a tool that we're going to need to see more of ultimately when it comes to be able to have eyes on the ground, be able to reflect and respond to what are a lot of challenging conditions in our watersheds. But with new technologies, I think that we can continue to make sure we're improving that work. So just thanks, a huge vote of confidence here from us, and a lot of congratulations. Many, many thanks. Thank you all. Yeah, let's do a quick photo, and I see Karen has her phone ready. Huge thanks again and congratulations. And thanks everyone for the opportunity to make sure we're able to elevate and highlight the folks that actually get the work done here within the agency. So thank you. All right, that moves us now on to public forum, and I believe we have about 3 public forum speakers as I get my tablet back up and awake. And Tyler, as my list refreshes here, do you mind reminding me who we have first? Isaiah Williams will be our first commenter in public forum, be followed by Ray Tahir, J.C. Dean, and then Walter Lamb.
Hi, I'm not Isaiah, but I know that he meant to sign up for an agenda item.
Oh,
so,
okay.
Yeah.
Well, thank you for that. No
Yeah.
problem in the least. Okay. Well, we'll bring Isaiah's comment probably down to the intended use plan. I think that's where some folks are probably are. All right. Well, next I'd like to call up Ray Tahir, be followed by J.C. Dean, and then Walter Lamb.
Okay, the subject of today's public forum is Particle Loan 13287 must be rescinded. Next slide, please. At the last board meeting, I pointed out that OCC essentially tricked cities into believing that SB 965 lifted the ex parte prohibition on MS4 and other stormwater permits. And as you recall, I showed a League of California Cities update that said that. You know what it is, so I'm going to skip over that. Office of Chiefs Counsel had no response except to say, in this case, 13287 says otherwise, despite legislative intent using the disclosure model he contrived. This tricky, deceptive device undermines SB 965's intent and the will of local governments to lift the prohibition on ex parte communication relative to the MS4 and other permits. This board, with your apparent approval, supported this move. Next slide, please. Here's the rub. The disclosure model was written in such a cryptic manner that it was not understood that 13287 only exempted MS4 and other stormwater permittees from the prohibition on ex parte communication if they are not identified as discharges. The problem is that nowhere in 13287 or anywhere else are discharges identified. So how could local governments, Senate Committee on Environmental Quality, and Legislative Council know this? They had no choice but to trust the Office of Chiefs Counsel that MS4s and other stormwater permittees were not subject to the prohibition on ex parte communication. Beyond this, the disclosure model is vague and is not enforceable, which needs to be eliminated. Next slide, please. What really destroys Particle Loan 13287 is that it is legally invalid. It contains the following introductory language that is not in 13287 that was signed into law on September 25th, 2012. And here's what it says. It mentions that definitions, ex parte communications for general orders, disclosure requirements, and remedies. Next slide, please. Compare this with 13287 version that was signed by Governor Brown into law on September 25th, 2012. It says Chapter 4.1, commencing with Section 13287, is added to Division 7 of the Water Code to read Chapter 4.4, ex parte communications. Note, there is no reference to definitions, ex parte communications for certain general orders, disclosure requirements, and remedies, as is the case in the Particle Loan version. The consequence of this disparity is clear. General orders and disclosure requirements do not legally exist and are nowhere to be found in the 13287 version signed by the governor. Therefore, Particle Loan 13287 is defective and must be amended. When this happens, it will be made clear that the amendment will need to align with SB 965's purpose. Also, OCC's so-called negotiated amendment to PC 13287 was an egregious error. Whether unintentional or not, OCC is responsible. Had a city attorney revised an ordinance, city ordinance, after adopted by city council and was published as code, that person would have been fired. Next slide, please. A word about Chair Escobel's comment that I didn't understand the legislative process, which involves amendments, and that in the end, it is the law, not legislative intent that counts. I disagree. It is generally known fact that legislative intent drives a bill into being a law. And by the way, I've been involved in legislative analysis since I worked for cities in the mid-'80s, starting with Byron Shure and Elaine Easton's statutes concerning landfills. In any case, the matter is moot because PC 13287 is not legally valid. Lastly, I would like Mr. Loppert to explain one thing right now. Why did he oppose lifting the prohibition on ex parte communication relative to MS4 and other stormwater permits? And I would like any documentation from this office to the League, Senate Committee on Environmental Quality, and or the Legislative Council, informing them that 13287 did not exempt MS4 and other stormwater permits. Next slide, please. Here's something for some history for Mr. Esquivel. You may not know this, but I went to Belmont High School. And in early March of 1968, I walked out along with East LA schools, Roosevelt, Garfield, Lincoln, and Wilson. The walkouts, which students call blowouts, protested LA Unified School District's discriminatory policies against Latinos and other people of color. I also blew out and also got my ass kicked by LAPD. I am sharing this with you so that you know I have no problem being confrontational for a just cause. And that's it. Thank you very much.
Mr. Tahir, I think I said what I need to say to you at our last public forum. I don't believe at this point this is at all productive. And to the extent that you feel that the board has, and its chief counsel have somehow, misstepped, I think you should go to the legislature and find some remedy. But the law is clear as it is. We've gone over this. We've offered you to meet with Mr. Lawfer. You haven't decided to do so, and we keep having this exchange at forum. Again, I really, public forum we have here as an important opportunity for the public to be able to address the board on new or other issues that are needing to be flagged for us, and would hate to have to see adjustments to public forum because of its abuse. So just.
Well, it
Mr.
can be
Tahir,
abusive. You need to read Bagley King, Mr. Chair.
Thank you, Mr.
It says
Tahir.
that, you guys
Mr.
are
Tahir,
public
I'm not going
servants. You're not masters.
we're not going to entertain a back and forth here, Mr. Tahir. This is public forum. You've said your piece, and it's appreciated. Again, I think your remedy at this point maybe with the legislature.
I agree. Thank you very much.
Thank you. Next, I'd like to call up J.C. Dean, who will be followed by Walter Lamb. Ms. Dean, good morning. Good to see you.
Good morning, Chair Esquivel and members of the board. My name is JC Dean, as it says on my screen. I'm an attorney at Stoll Reeves LLP. I'm here on behalf of our client, Analytical Environmental Labs, regarding their still pending application for initial lab accreditation through ELAP. As I mentioned at the last public forum, AAL submitted its application in January of this year. It paid a $15,000 fee and completed all baseline requirements. So more than 7 months have passed. There's still no certification, no approval, no denial, and no timeline, and kind of no explanation. On July 1st, there was an on-site audit of the facility. There were no significant findings, and the auditor offered positive feedback, commending the quality of the lab and the technical expertise of the owner. AAL expected that this audit would move the process forward. Instead, it has been met with continued silence. AAL has also learned that 2 other labs, which I believe submitted applications after AAL, have already been certified. This raises concerns for my client about consistency and fairness in the review process. The delay is, however, not just kind of a bureaucratic issue, it's an economic one. AAL remains unable to operate or generate income despite having invested tens of thousands of dollars, including personal retirement funds. The lab is ready to serve the San Diego region, which needs local access to timely, high-quality environmental testing, but cannot do so without certification. This kind of highlights a broader problem. ELAP appears to be operating without a time frame for action. The current legal structure provides no avenue for a lab to petition the board when ELAP fails to act. We believe this is a due process gap, one that does not exist in other water board programs, which are typically subject to deadlines and available appeal rights. Thank you for your time and attention. AEL has done everything required of it. We simply ask that ELAP be held to a similar standard and at least a process for appealing if there's inaction. So thank you very much for your time today.
Thank you, Ms. Dean. I do appreciate you elevating this to the board. I'm looking to Mr. Lawfer in case he has any response.
Yes, when I saw Ms. Dean on the public forum list, I did reach out to the ELAP folks this morning. And I think the board had heard last go around when we heard Ms. Dean in public forum that one of the issues had simply been getting the scheduling for the certifying entity to come out on site. As you heard from Ms. Dean, that's now happened. And my understanding from the ELAP staff is that a letter is going through the final review process and they hope to have it out within the next week.
Thank you for that update, Mr. Lawfer. And thank you, Ms. Dean, for elevating this to the board. Next, I'd like to call up Walter Lamb.
Thank you, Chair Esquivel and board members. Walter Lamb, representing the Bino Wetlands Land Trust. Just wanted to circle back. Have not heard anything in response to comments I've raised, I think, a few times now. And the concern for us is that the longer it takes to get a response, the less valuable the response will be. We're trying to understand, as you know from my previous comments, really not the judgment of what happened, but just the facts of what happened with the way the State Water Resources Control Board staff guided the Santa Monica Bay Restoration Commission through its process. Again, not asking you to second guess the Santa Monica Bay Restoration Commission's decision. We are asking for information about how it came to pass that water board employees, knowing that there was relevant written guidance regarding a decision on things like climate change, ocean acidification, environmental justice, did not secure that written guidance, did not provide that written guidance to the commission. The commission can't make independent decisions if they're not given, all the relevant information that's in play. And just one other quick point. I know it was raised last time that, it's really harmless because the commission's still doing the same work. They just use different words to describe it. I would just throw out there to everybody that you can't fight climate change without using the words climate change. So I would just sort of fundamentally disagree right there. But there's also some other concrete examples of where the commission is not doing things that it did in the past with regard to some of those issues. So really just looking for, maybe a timeline of when I might get a response and hoping that response will be very fact-based, candid, and objective, and just kind of lay out what happened so that the public understands. Thank you for that.
Thank you as well, Mr. Lamb. I don't know if we have a timeline at this point, but I know that folks are busy, so we'll be responding to you as soon as we can here and appreciate your concerns. So thank you.
Thank you.
All right. That concludes public forum commenters, I believe. Thank you. And so just again, appreciate everyone that addressed the board this morning. All right, our first order of board business is consideration of the board meeting minutes from the previous board meeting. Looking to fellow board colleagues if there's any adjustment, and then otherwise ready for a motion, I believe.
Move to adopt the minutes.
I'll second.
Thank you both. Ms. Tyler, can you please call a roll call vote?
Board Member McGuire,
Aye.
Board Member Firestone,
Aye.
Vice Chair Diadamo,
Aye.
and Chair Esquivel.
Aye.
Thank you.
Thank you as well. Board meeting minutes are adopted. That now brings us to item number 2, which is our informational item on current hydrologic conditions and response. And I'd like to welcome folks up. I believe Ms. Ragazzi will present. Good to see you today.
Good
Good
morning.
to see you.
Good morning, Chair Esquivel and members of the board. Erin Ragazzi with the Division of Water Rights. We're going to have a more focused hydrologic conditions update today, and I'm going to focus on an update of the Scott and Shasta watersheds. So next slide, please. So I'm going to cover some background information on the status of both of the watersheds, including the hydrologic conditions and curtailment status. Then I'm going to get into a little bit of specific information on each of the watersheds in the Shasta, covering a flow study that's happening this summer and the potential for a flow modification this summer during the under the provisions of the regulation. And on the Scott, I'm going to talk a little bit about some of the challenges associated with flows associated with the accuracy of the gauge at Fort Jones, and then how we're planning to tackle that moving forward. And finally, just some upcoming updates on the Scott and Shasta. Next slide, please. So you're very familiar with this graph, I think, at this point in time. It shows the hydrologic conditions in the Shasta since the beginning of the 2023 water year through the end of July. As you can see, conditions have remained pretty steady above the minimum flow requirements, with the implementation of curtailments at times. And I'll note that flows have been mainly above the flow requirement of 50 CFS throughout the month of July. Next slide, please. So conditional curtailments were put in place on July 27th for the Shasta River watershed. Those conditional curtailments provide for coordination among the diverters. So instead of a strict curtailment in order of priority, in this case, folks are able to work with the water master to coordinate their diversions in a manner that still meets the minimum flow requirement, but also provides flexibility. There are exceptions to curtailments, including the minimum health and safety, which provides for diversions for firefighting or maintenance of water supplies for firefighting. Next slide, please. So this is a specific Shasta item. This summer, there is a flow study that's going on. Applied River Sciences is performing the flow study. It's of the Shasta Canyon, and the purpose of the study is to have an improved understanding of how in-stream flows support salmonid habitat during late spring to early fall. So that's the May through October period. And specifically, they're looking at how those flows influence the quantity of rearing habitat and juvenile growth potential in the lower Shasta, as well as water temperatures and thermal refugia. One of the specific items they're looking at is the pool stratification and the temperature variance that occurs during the summer. Next slide, please. So as you may recall, when the board readopted the emergency regulation back in January, there was a new provision that was added. That new provision provided for the California Department of Fish and Wildlife in coordination with the National Marine Fisheries Service to propose alternative flows at the Wairika gauge. That would be to gather temperature and other information that would help evaluate whether alternative flows can provide equal or better protection. In order for those flows to be implemented, the deputy director would be able to approve that once CDFW recommends such a change. It would be for that temporary change to flows, and any higher flows would need to be with the agreement of affected water rights holders. So CDFW has been in discussions with folks in the Shasta watershed regarding the potential for use of this provision. And they're looking at a range of flows down to 40 CFS and up to 60 CFS. Again, the flow requirement is 50 CFS. I expect we may hear something from CDFW later this week or early next week. And if it is implemented, it would be later in August. Next slide, please. Moving to the Scott River. Again, showing the hydrologic conditions over the last about water year and a half. As you can see, flows remain above the minimum flow requirement. The flow requirement dropped from 50 to 30 CFS in August. Next slide, please. So this shows some of the similar hydrographs associated with the Scott River. Along the bottom, I just want to point out you've got the shortfall period, so that's when flows in similar water years have dropped below that flow requirement. You also see various lines representing different years. So for each year, you'll see the year followed by the snow water equivalent as of May 1st. So you can see the black line represents this year. In most years, flows, most similar years, flows do drop below the minimum flow requirement at some point in time. We do have 1 year here with a snow water equivalent of 138 where flows remained above. So we'll have to see how things shake out this summer, but we're looking in a really good position relative to other similar years at this point in time. Next slide, please. So recent Scott curtailment actions. As you know, staff monitor flows closely, especially during the summer or as flows begin to approach the minimum flow requirements. Flows at the Fort Jones gauge have shown a continuous decline, which is consistent with every year. And staff sent an email noting that the flows were declining and the potential for curtailment on July 10th. Curtailment was issued on July 20th when flows dropped below the minimum flow requirement. USGS had taken a measurement at the Fort Jones gauge on July 9th, which was 11 days before the curtailment was issued, and had made no adjustments at that point in time. The day after the curtailments were issued, local water users noted that there seemed to be higher flows. They visually looked and said, we don't think it's 50, we think it's higher. And the water master went out and took a measurement and sent that to USGS. We're very fortunate to have a water master that mainly works in the Shasta, but does work in a couple of watersheds in the Scott as well. And the water master has a very good relationship with USGS and is able to share information. So USGS updated their rating curve based upon that, and the board suspended curtailments as of the following morning. So for a little over a day, one evening to one morning, curtailments were in place. The water master took a second measurement on the 23rd, and USGS also took a measurement on July 25th, and these were consistent with what the water master noted on the July 21st measurement. So no additional updates were made to the rating curve at that time. Next slide, please. So following the reinstatement of curtailments, staff received emails from multiple parties related to the accuracy of the Fort Jones gauge and the imposition of curtailments. In this instance, after discussions with USGS and the water master, it was determined that the Fort Jones gauge was having inaccurate readings due to channel morphology and the movement of gravels and sands that are in that area. This highlighted the need for multiple flow measurements as flows decline. Even though we had that measurement on July 9th, obviously conditions changed and the flows were not accurate at the Fort Jones gauge as they declined further. Next slide. So moving forward, how do we plan to handle this year and in future years should we continue to have a regulation in place? The flows are currently above the flow requirement of 30 CFS. As shown in the previous slide, we see an overall declining trend and flows may drop below the flow requirement. The timing of that is uncertain due to a variety of conditions in the watershed. But when flows are within 10 CFS of the flow requirement, we plan to work with USGS or the water master and have an additional flow measurement taken. At that point in time, if appropriate, we'll send a notification, again, alerting folks that we see a declining trend in the potential for curtailments. And this would be something that we would propose to do, moving forward. Staff will continue, I have shared this with the water master, I've shared this with the Farm Bureau, I've shared this with a variety of different parties in the county in discussions or emails, and they all appreciate the fact that the board responded quickly, wish that we had made a measurement ahead of time, and think this would be a good process moving forward. Staff are also going to continue monitoring wildfires in Siskiyou County this year. So far, things have looked pretty good, and I hope they remain that way and that we don't end up with any issues this year, but we will continue to monitor those as well. Next slide, please.
Just want to say, a note of thanks as well to folks in the watershed for just engaging with us and the water master, obviously, and USGS and flagging it. I think it was it's certainly a lesson learned on our part, and I appreciate the process improvements moving forward as well. But just appreciate the folks were there to work with us, flag the issue, and able to respond to it quickly. So just thanks to everyone involved. Vice Chair.
I agree. Thank you very much. And also thanks to the folks in the watershed for the good communication. The other area that has come up on more than one occasion is concerns by some of the agricultural diverters regarding a buffer, that there may be a buffer in place just in case the gauge is slightly off or the diversions are slightly off, just to make sure that we hit that target. So could you talk a little bit about that and anything that the division is doing to improve communications with the stakeholders so that they better understand what's going on with the issue of a buffer?
Yeah. So this is a topic I think that came up last year as well, and we had some communication about it. The two watersheds are slightly different. In the Shasta, we have the conditional curtailments in place. The conditional curtailments provide for folks to turn off, the most junior folks to turn off when we start to see a decline in flows, and we are at 55 CFS, and we are going to see a continuing decline in flows so that we will not dip below and then rise back above. So they have to look at upstream gauges. They have to coordinate with the water master. If things are looking good, they can turn back on. It does require additional reporting, so we know who's on and who's off, and that they work with the water master. In the Scott, in the past, we have implemented curtailments early because there's no rebound effect really in the Scott. Once flows start to decline, they continue to decline. If you issue curtailments after they have declined, you might come up for a little bit, and then you will continue to decline. So I would not call that a buffer. I would call that trying to maintain the minimum flows throughout for as long as possible in those instances. We'll continue to have conversations with folks about why decisions are being made and what the provisions are in those curtailment notices. We're happy to have those conversations to explain what the background is and support is for those, and to adapt over time as well. In this instance, we implemented the curtailment once flows had already dropped below 50. Obviously, it wasn't really 50. So then we corrected and went back and suspended the curtailments.
Yeah, I think on that, and that all makes sense, but I would hope that with further communication that it would make sense, for the folks on the ground. And so they're using the term buffer. Maybe if you could, think through a certain term that could be used so it doesn't look like it's a buffer, but in fact it's intended to hit the number that's in the regulation.
Correct. Thank you. We'll continue to try and improve terminology. I know different terms mean different things to different people and have different hot buttons. So we'll look to always try and find better words that people like and can understand. So where are we moving from here? As you know, we had a board meeting in October. The board adopted resolution 240036. That directs staff to come back and discuss the long-term efforts related to the baseline minimum flow efforts. So we're targeting the November 4th board meeting at this point in time. We'll be providing updates related to the initiation of efforts on the scientific basis report, economic analysis, and ongoing modeling efforts, and the timing associated with all of those. And that's the last slide, I believe.
Great, many thanks. Much appreciation, Ms. Regazi. We don't have any commenters, so just we're off the steam of whatever anyone at the dais would like to question, comment on. And if not seeing anything further, I think we're set. So thank you, Ms. Regazi. Really appreciate it. Thank you. All right, that concludes item number 2, our informational item. Brings us to our next item, a presentation on the revision of water measurement and reporting regulations. I'd like to call up Lindsay Camamere and her team. Good morning. Good to see you.
Good morning. Good to see you as well. Let me just figure out the microphone here. Good morning, Chair Esquivel, members of the board. My name is Lindsay Camire, Senior Water Resource Control Engineer with the Division of Water Rights, Drought Planning Unit. Today, I am joined by my colleagues, Pablo Ortiz and Sierra Kennison of the division. Additionally, we have Samantha Olson from our Office of Chief Counsel with us today. Today, we are presenting staff's proposed changes to the Water Measurement and Reporting Regulation, sometimes referred to as SB 88. Today, we are asking you to adopt the draft resolution that has been circulated, which approves the proposed regulation text and allows staff to submit the rulemaking package to the Office of Administrative Law. The division officially started this rulemaking process this past February when we were last before the board for an informational item. As noted during that presentation, our unit has been doing public engagement on the measurement regulation for over 2 years. While today might feel like the culmination of our efforts, this is really one more step towards better data that will help us implement the water rights system, manage public trust resources, and provide better data to the public. Next slide, please. Focusing on the draft resolution and proposed regulation revisions before you today, first we'll cover background and describe why the revisions are needed. Then we'll describe the proposed changes and the public comments received. Next, we'll talk about the regulatory process. And finally, we'll describe the timeline and next steps. Next slide, please. To discuss the existing regulations and the need to update, I'll pass it to my colleague, Pablo.
Thanks, Lindsay, and good morning, board members. My name is Pablo Ortiz. I'm an environmental scientist with the Division of Water Rights. First, I'll provide some background about the existing regulations and why a regulation update is needed. Next slide. Our existing diversion measurement regulations originate from legislation passed during the historic 2012 to 2016 drought. This legislation directed the board to adopt these requirements by emergency regulation. The measurement and reporting regulations, often referred to as SB 88 after the original legislation, have been in effect since 2016. Essentially, anyone authorized to divert or that does divert more than 10 acre-feet of water per year is required to measure and report their diversions and submit their data as an attachment to their annual reports. More granular and timely data can improve the board's and diverters' ability to forecast and prepare for limited water supplies, facilitate things like water transfers, petitions, and new applications, and flood recharge permits, and protect senior water rights holders and the public trust. Unfortunately, to properly do this, we need data from diverters, and a few years of implementation of the regulation have revealed persistent compliance issues. Next slide, please. More than 5 years of reporting with the measurement regulations in effect has provided valuable information about implementation. Firstly, we aren't receiving data files from many diverters, which may point to a lack of clarity among diverters about what is required. As you can see from the chart on the green bar at the bottom, if our goal is to get measurement data from everyone subject to the regulation, we've only received that for around 20% of water rights each year. Fortunately, larger water rights have a higher data file submission rate, so files that we do receive account for more than 30% of the total allocated water that is subject to the regulation. What this data also shows is that many people are making or taking actions related to compliance, even if they do fall short of submitting a data file. And there are also many diverters that may not divert water under a given water right in a year, and so they're not sending us data for those water rights because they're not measuring any water. The regulations could be more clear regarding data file submission requirements, and expectations for when no water was diverted could be more properly accounted for. Next slide, please. Another significant issue is that the existing regulations don't specify the format in which a data file must be submitted to the board, just that it be accessible through Microsoft Excel or Microsoft Access. As you can imagine, there are an infinite number of ways to format a data file. And so, as you can see on the right here, we receive data in a multitude of different formats of varying qualities. Some files may have graphs, some might have pictures of handwritten data that were submitted in an Excel file. This results in information that's difficult to interpret and really impossible to incorporate into a single database that can be used for water management decisions and analysis. The value of data lies in its usability, and more standardized measurements would lead to more effective water management, and this could be reflected in the regulation. Next slide, please. Related to data quality, the division is currently in the process of transitioning its reporting and data infrastructure to the new CalWaters platform. That stands for California Water Accounting, Tracking, and Reporting System. The new platform will have more sophisticated data analysis, database management, and case management tools that will result in more usable measurement data. This allows the division to effectively leverage standardized data, emphasis on standardized, and offers an opportunity to align the regulations to improve diversion data quality statewide. Also, beginning in October 2025, email addresses will be required for registering for CalWaters and reporting measurement data and reporting annual reports. This is not currently reflected in regulation, but it is a small but crucial component of the proposed regulations brought forth today. So between lagging compliance, data quality issues, and the opportunity presented by CalWaters, an update to our measurement regulations is a necessary and timely endeavor. Now I'll pass it to Sierra to provide more detail about the proposed changes.
Thank you, Pablo, and good morning, board members. My name is Sierra Kennison, and I'm a Water Resource Control Engineer with the Division of Water Rights. Next slide, please. In this section, I'll briefly describe the rulemaking and proposed regulation changes. Next slide, please. The official rulemaking process began in February of this year on the 28th when we submitted the Notice of Proposed Action and released it to the public. At this time, we also released a draft of the proposed regulation text, as well as an initial statement of reasons explaining the changes and the expected economic impact. On this date, it initiated the initial public comment period, which lasted from February 28th until April 23rd, a total of 54 days. On April 16th, we held a public hearing in accordance with the Administrative Procedure Act, where we explained the regulation to the public and offered an opportunity for public comments to be received orally. In response to comments received, we revised the regulation 2 more times, each time followed by a 15-day comment period to receive additional changes on the text. Now we're in August, and pending adoption of the proposed resolution and regulations today, we are prepared to submit it to the Office of Administrative Law with an expected effective date of October of this year. Next slide, please. So before continuing, I'd like to point out that the regulatory and associated supplementary materials are posted on our measurement rulemaking webpage. The URL and QR code shown here will take you to our page that has a chronological listing of documents for each phase of the rulemaking process, including those described on this slide. The website will continue to be updated with additional regulatory documents, including the final statement of reasons, which will contain a response to every comment received during the comment periods. Next slide, please. We want to thank everyone who has engaged with us during the rulemaking process and who has submitted public comments. As I mentioned earlier, we had 3 public comment periods through which we received a total of 71 written comments and 17 oral commenters during our public hearing on April 16th. Most of these comments were provided by the general public, including small farmers and individual diverters. Roughly a third represented water agencies, utility companies, and government agencies. And then about 12% represented other groups, including consultants, law firms, and educational institutions. Included in these letters and oral comments were over 350 individual remarks and suggestions, all of which division staff reviewed, and in many cases, staff made changes to the proposed regulation revisions based on these comments. Before I get into the overview of the proposed changes to the regulation, I would like to point out some of the changes that are attributed to the many helpful comments that we received. Next slide, please. First, the updated proposed regulation postpones the initially proposed effective dates for the new data submission processes. This includes dates by which diverters must use data file templates and comply with the large diversion submission requirements. The updated proposed regulation also postpones the dates for submitting measurement methodologies and alternative compliance plans, often referred to as ACPs. Another change is the expansion of instructional course options for qualified individuals, such that any approved course can make diverters eligible to be qualified individuals, not just the existing course offered by the University of California Cooperative Extension. The updated proposed regulation also simplifies and clarifies large diversion requirements, including which parameters diverters must measure. It also clarifies eligibility requirements and review processes for alternative compliance plans. And finally, changes made in response to comments generally improved the wording and formatting of the proposed regulation for clarity. As mentioned before, all proposed comments will be included in our final statement of reasons, which will be posted to our website. Next slide, please. So this slide summarizes the proposed revisions to the regulation in addition to those changes that I just described in response to public comment. I'll go over each of these in more detail in the upcoming slides. But to start, the first and most obvious change is to the structure of the regulation. Looking at it initially, it's entirely unrecognizable from the existing regulations. All of the text has been struck out and rewritten. We added paragraphs, deleted paragraphs, moved them around. So it does seem daunting at first, but it's intended to improve clarity, and the bulk of the what's required is the same. Second on this list is refined key terms. So we added definitions and refined existing definitions so that everyone's on the same page about what important words mean in the regulation. Number 3, wherever possible, we tried to simplify requirements for diverters. 4, we added flexibility and adaptability wherever possible, including streamlining the ability to adjust and reduce requirements in response to watershed-specific conditions, offering temporary exemptions from measurement under certain circumstances, and updating the alternative compliance section to allow more flexibility for other ways of measuring. Number 5, to make measurement data more consistent and usable for decision-making, the proposed update is more prescriptive in terms of data file formats and contents. So when submitting data through CalWaters, there will be templates available for reporters to use and upload to ensure correct formatting. Number 6 is a few other changes. We've clarified points of rediversion in the regulation, and we've also added in a measurement methodology section to explain how diverters are measuring. And this is based on the existing requirements for measurement methods. Number 7, as Pablo mentioned, CalWaters will require an email address. So this is not currently reflected in regulations. We're adding it in. It affects chapters 2 and 2.7 of Title 23 of the California Code of Regulations. And then lastly for this list, for groundwater recordations, we are aligning the reporting period to be with the water year instead of with the calendar year. And this is in response to regulatory or statutory requirements, and it also aligns reporting requirements for all other types of water rights. Next slide, please. So as I mentioned, the restructuring of the regulation is the most obvious change from the existing text. The new structure begins with definitions to clarify key terms, followed by a description of the Delta Water Master's authority. Then in the applicability section, 932, it defines who needs to measure. This is also the section where we describe who is subject to the large diversion requirements, formerly known as telemetry requirements. 933 spells out what diverters need to measure, and 934 gets into how to measure, including things like registering devices and filing that measurement methodology. After that, in 935, it describes what diverters need to submit. This also explains how to format your data correctly. And in 936 and 937, it describes circumstances where diverters can pursue measurement flexibility and temporary exemptions. Section 938 contains language allowing the board to adjust thresholds for different requirements based on the need for data. Section 939 addresses compliance with the revised regulation. And lastly, sections 939.1 through 939.6 discuss the transition period for water year 2025. As we'll discuss in a few slides, we anticipate the revised regulation going into effect this October, so these sections explain how to submit measurement data that was collected this year under the existing regulations requirements. So with that, let's go over a few of the changes in more detail. Next slide, please. So here we're discussing the main ways we've tried to simplify the regulation to make it more understandable and to reduce burdens wherever possible. Starting on the left, we've updated many of the terms and definitions to improve clarity. Notably, we've removed the distinction that currently exists between measuring devices and measurement methods. So now, if a piece of equipment measures or collects data at all, it's called a measuring device. And the overall system of measuring, interpreting that data, compiling that data into your data file, that's called your measurement methodology. So diverters will generally have both, a device that collects data and a methodology for interpreting it. We've also replaced the term telemetry requirements with large diversion requirements. The existing regulation misuses the term telemetry, so we've opted for a different term to alleviate confusion. So while the terminology has changed, the requirement to report data weekly, that remains the same. But we have clarified who is subject to these requirements, what the parameters are, and we've specified data formatting and submission procedures. Namely that instead of posting to any public website, the data will be posted directly to Cal Waters. Another point I want to mention with regard to the large diversion requirements, in an effort to provide additional clarity and to protect vulnerable aquatic species who may be impacted by large diversions, we have revised the applicability criteria to simply apply to diverters who divert more than 10,000 acre-feet per year or more than 30 cubic feet per second at any time. Previously, that 30 cubic feet per second component only applied to diversions between June and September, but this change is expected to affect fewer than 200 water rights. And I want to caveat that that 200 number likely overestimates the number of water rights because it is based on previous reported diversion rates, which after looking into some of these water rights, they are riddled with mistakes or just reporting errors. So in the future, Cal Waters is expected to make it significantly easier to catch these mistakes and correct these errors, and staff are always eager to help make these corrections. On to the middle column here. Wherever possible, we've tried to simplify requirements and reduce regulatory burden. We've updated the applicability to explicitly exclude stock pond certificates, registrations for livestock stock ponds, registrations for domestic use, and registrations for cannabis irrigation. These are small water rights, and the cost of measurement generally outweighs the benefit of the associated data. We have also removed having applicability be based on a shared place of use. Now it is only based on the size of the water right and whether multiple water rights share a reservoir or point of diversion. For small diverters, we have updated frequency requirements such that diverters with smaller water rights do not need to measure as frequently as in the current regulations. And for withdrawals and releases from storage, we further reduce the burden on small diverters by introducing the concept of qualifying reservoirs, which are reservoirs with a capacity greater than 5,000 acre-feet. Diverters only need to measure withdrawals and releases from these large qualifying reservoirs. And in the far right column here, the updated regulations provide more flexibility. Depending on watershed conditions and the need for measurement data, the Deputy Director may adjust some of the frequency requirements of the regulation and whether the regulation overall applies to certain diversions. And this is in order to tailor requirements and meet specific needs. It's intended to better balance the board's need for high-quality, high-resolution diversion data with the effort required of diverters to supply that data. We have also added in flexibility by offering exemptions in certain circumstances, including if diversion or measurement infrastructures are destroyed by natural disaster. And lastly, for this slide, we have expanded eligibility for alternative compliance with the regulation. So now anyone who has a more effective or efficient way of measuring than what is otherwise described in the regulation can propose an alternative compliance plan describing how they plan to measure instead. I do want to point out that this is not a means of avoiding measurement, but it is intended to allow greater flexibility in ensuring reliable measuring occurs. Next slide, please. So this slide shows changes that are intended to improve the usability of data we receive. The revised regulation shifts data collection towards a usable standardized format that will be more ingestible and primed for analysis. Currently, we receive data in over 1,000 different formats. But the use of standardized templates will allow us to more efficiently and effectively incorporate the data into a comprehensive database that can be better used for making water management decisions. We have also clarified points of rediversion. Many diverters already measure their rediversions, so to those people, we're saying thank you, please keep up the good work. And for those that do not, the deputy director may ask them to measure their rediversions if it is found that that rediversion data is necessary to understand diversions and water availability in a particular area. Rediversions must also be identified in measurement data in order to avoid double counting of water, which would otherwise make it look like more water is being diverted and would impact analyses of water availability and demand. As I mentioned earlier, the revised text also includes the concept of measurement methodologies, by which diverters describe how they're measuring and how they interpret the raw output from the measuring devices to determine diversion amounts. This includes how they convert between different measurement units, how they provide quality assurance and quality control of their data, and how they apportion between different water rights. And also in their measurement methodology, they will need to identify where they are measuring. This helps the board relate the data to a particular point of diversion and helps us better understand when, where, and how much water is being diverted. Next slide, please. With the rollout of the new CalWater system, measurement reporting will be integrated into the same system used for all other water rights reporting requirements. Registering with an email address enables users to establish a secure login and enhances the board's ability to communicate with and provide case management for users. Additionally, the proposed revisions adjust the reporting period for groundwater recordations such that annual reports include information from the recent water year, which spans from October to September, as opposed to including information from the recent calendar year. This change aligns requirements for groundwater recordations with requirements for all other types of water rights, which already report according to the water year. It also aligns the regulation with statutory requirements. Next slide, please. So the changes in the revised regulation will be implemented over the next 2 water years, starting this October, assuming that we're on track to have the regulation become effective this October. That is the beginning of water year 2026, and diverters will need to start measuring according to the new requirements. Large diversion data will still be submitted according to the existing requirements, which allow posting to any publicly accessible website. In January 2026, data collected during the current water year will be reported in accordance with the current requirements. So the data submission requirements of the updated regulation will not go into effect quite yet. At this time, diverters are also required to register their measuring devices, and both the email registration requirement and the groundwater recordation updates will go into effect this January. Next October, 2026, diverters will begin submitting large diversion data in accordance with the revised requirements. And finally, in January 2027, diverters will submit water year 2026 measurement data in accordance with the updated revised requirements. At this time, also a measurement methodology and/or an ACP will also need to be on file. And with that, I will pass it back to Lindsay to go over the rulemaking process and next steps.
Thank you, Sierra, for the thorough review of the proposed changes and the implementation schedule. Next slide, please. Earlier, we presented this timeline and described the regulatory milestones leading up to this board meeting. Pending adoption of the proposed resolution today, the final rulemaking documents will be submitted to the Office of Administrative Law with an expected effective date of October 2025. This would align the regulation with the water year and reporting period as just described. There are a couple of supporting materials for the regulation submission that I will highlight for you now before describing next steps. Next slide, please. As noted in the draft resolution, the proposed regulation meets criteria for several categorical exemptions under the California Environmental Quality Act requirements. Proposed reporting requirement revisions, including cases where the installation of new measurement device is necessary, fall under the information collection exemption and one or more of the following additional exemptions: existing facilities, replacement or reconstruction, new construction or conversion of small structures, and minor alterations to land. Next slide, please. As part of this rulemaking, we conducted an economic and fiscal impact analysis to evaluate the effects of the proposed regulation compared to the existing. This analysis can be found in the initial statement of reasons on our website. An updated analysis will be included in the final statement of reasons. The estimates shown here are combined for all of the thousands of diverters who are subject to the regulation, so individual costs are much smaller. For state and local agencies and governments, we estimated one-time cost of approximately $677,000 and $1.8 million for reporting and equipment, respectively, with a recurring cost of $314,000 for operations. For individuals and businesses, the total one-time cost is estimated at about $1.5 million and $637,000 for reporting and equipment, respectively, with a recurring cost of $151,000. We estimated the total statewide impact to be around $6.8 million, which is under the $10 million threshold for a major regulation. This estimate is the present discounted value over 5 years. The largest anticipated costs are limited to the large diverters, those over 10,000 acre-feet. I'd also like to note that we were very conservative when estimating the fiscal impact. Next slide, please. If the board adopts the proposed resolution today, division staff will submit the rulemaking package to the Office of Administrative Law. We plan to request an early effective date of October 1, 2025 to accommodate the email requirement for access to CalWaters. After the regulation is filed with the Secretary of State and added to the California Code of Regulations, the division will launch an outreach campaign that will include workshops, updated guidance materials, and one-on-one compliance assistance meetings. Our goal is to educate diverters on the revised regulation and improve compliance. We are coordinating our outreach efforts with the CalWaters team to ensure the best use of staff resources and maximize impact for the public. We expect this first round of outreach to focus on how the measurement requirements have changed and anticipate doing additional outreach to more outreach next summer and fall to provide guidance on how diverters should report their measurement data in CalWaters. Next slide, please. The division will continue to update our rulemaking page noted at the top of this slide as additional materials become available. The measurement and reporting website noted in the middle of this slide will be updated with new regulation requirements and guidance materials. Staff are also available to assist the public via our email address shown on the screen as well as the phone number. This concludes our presentation, and I'd like to acknowledge the staff that have made today possible. This isn't a large regulation, but it was done at a veritable sprint. We were able to get this done quickly due to the hard work of staff sitting before you today: Pablo Ortiz, Sierra Kennison, and Samantha Olson. Other team members instrumental in this relay race include Ben Trin, Sean Stout, Connie Mitterhofer, Abby Warner, Jesse Jankowski, Kartiki Naik, as well as the board's economist, Pedro Arantana, in the Office of Research, Planning, and Performance, and Dave Rose and Julia Nick in the Office of Chief Counsel. With those acknowledgements, I thank you for your time this morning. We would recommend that the board adopt the proposed resolution after any questions, comments, and discussion. Thank you.
Thank you as well. Incredible thanks to you for your leadership. And again, thanks to the team that made this possible. And importantly, thank you to all the water right holders and folks that engaged in this process. Really appreciated the opportunity to get out into the field a couple of times, to have a number of conversations with folks. And as you said, this work is it's in the weeds for sure when it comes to how we report and track and measure water rights here within the state, but it is so incredibly critical. And just appreciate all the learning that's been done these last years in the division, how that's now reflected in this new regulation. And to the points that have been made, comes at a really critical time as we transition to a new water rights data system. So, I can't help but thank just everyone for a lot of leadership these last years. We're continuing to move in the right direction when it comes to water rights and its administration here in the state. Admittedly, we're a few years behind other Western states when it comes to this work, but just feel like we're quickly catching ground as we continue to make improvements in the system, and just really thankful for this just fundamental work from everybody. So much appreciation and much thanks. Looking to fellow board colleagues for comments, questions, Vice Chair, and we do have a few commenters as well.
Yes, thank you. And I concur in the chair's comments. Thank you for moving quickly, and this needs to be done. And so I'm really looking forward to seeing how this improves things. And definitely, with the email addresses and all that, Cal Waters, I think that we're going to see some significant improvement. Having said that, though, I'm still kind of concerned about messaging on current compliance rates, because the rates are so low. And if you look at by volume, I believe you said it was around 30% by volume for compliance. But as I recall, we've been briefed several times on this issue in the past, and I thought that if you look at by volume, those numbers are higher. And so just really wanting to better understand, is that based on the compliance date only, or throughout the year at some point with those numbers, moving up as additional reminders go out?
Yes, so the volume that we did was based on the water year 2023 reports to us, and that's based on folks if they have submitted a data file to us. So not just that they completed their annual report, but that if they were required to submit data at the if they were required to submit data, that they in fact did submit a data file to us. So
by a date certain, or by the close of the year?
If they were able to submit a file to us. Yeah, so it's not that, 30% by volume had it done by January 31st of that reporting year. We recently looked at the data for water year 23, and this is, now been a while that reports have been due. So it was the most recent data that we were able to collect and grab, not just by that January 31st date.
Okay. All right. And then a couple of questions. One is, it was one of the first few slides where you had the bars and no diversion. It was toward the bottom of the bars on no diversion. What are the requirements if there are no diversions?
Yeah, so currently what we have it as, and staff, please correct me if I misspeak at all, because these tend to be a little, there's lots of nuance to them. The current requirements, if you don't divert, is that our guidance has been to submit a data file to us with zeros. To, just double confirm that it's like, yes, I have diverted nothing, and I'm submitting to you a data file that has, 0 volumes for diversion. In the future, we're moving towards not having that requirement in the coming years. But currently, people are supposed to report to us with zeros for their data files, and many people are not aware of that requirement and or do not submit that to us. But we did want to highlight that chunk because it is such a significant portion of what's happening. So if you take into consideration all these people who are not diverting, but also not explaining to us and sending us a data file, then the compliance picture might look a little bit different.
Right. And it seems it's important to get that information. But in looking at this today, and I didn't think of this when I had my briefing, but a policy consideration for those that do not divert, that have appropriative water rights and, sort of the use it or lose it. And so did you think about any of those policy considerations, I think we want people to divert even if they're coming close to that 5 years of non-use, but they may be reluctant to provide that information out of fear that they would lose their rights. And so just wondering if you thought through these issues.
Yeah, it definitely is a significant number of statements. Folks who are appropriating the water who are, like to have that that date and like to have a paper record of like, yes, I have been submitting my files every single year to, protect this claim that they have. As far as moving towards looking at, non-use, I think I can maybe stare at Eric Ekdahl a little further down here, and whoever our future deputy director is, but I think that's something for the leadership to continue to consider.
Yeah, no, thank you, Lindsay. We did think pretty extensively about that, and that's one of the underlying uncertainties in our water rights system, and especially the data that's reported currently. There are a number of additional issues that this won't resolve, so overlapping claims of right. Sometimes folks will report as both the riparian and a appropriative right or an appropriative right, and they may toggle back and forth between. So if they're not reporting one year, they may report the next year. We don't really have a data system, or we will with Cal Waters. We're just kind of rolling it out, but historically we haven't had a way to easily identify where that's occurring. We'll start to have the tools that will help us do that and to start to clarify this question. Are these in fact just long-term legacy rights that haven't been used for years and years and years? Our general impression after doing some other analysis is that that's not the case, is that you do legitimately have some that are coming in and out. Riparians also don't have the use it or lose it provision. And so you do have riparian rights that may not report for many years at a time. So there's a lot of additional issues, and we have been thinking through. This is one of the steps that will help us clarify that issue down the road.
Great, that's helpful, thank you. And then the last question that I have is related to weekly reporting for smaller diverters. And so we spent some time in my briefing and then afterwards kind of back and forth. And so I just thought that'd be good use of time to open up this discussion. The concern that I have is specifically for those that divert over 30 CFS at any time of year, which would be broader than the current regulation, but including for small diverters overall by volume. And so just want to open up the discussion here. I just don't want us to require reporting if those diversions occur in a brief period of time, but then that requirement continues throughout the year. And so want to hear from you all about how you intend on addressing those issues through alternative compliance.
Absolutely, yes. So we did have this discussion, and we, the previous existing regulation, or the existing regulations have, if you divert 30 CFS during these certain summer months, that you would need to have these weekly reporting requirements in an effort to protect, fish species, other sensitive things happening during the typically high agricultural diversion seasons. We've However, though, that was a confusing thing and difficult to communicate. So instead, the proposed regulations have diverting the 30 CFS at any point throughout the year. Because again, sensitive habitat concerns exist throughout the year, not just during those summer months. As we discussed, this potentially, on paper may capture some folks who divert very small amounts of water. However, doing some analysis of this, not a thorough QA/QC, but doing some analysis, we've found that most of those small diverters, it's been a reporting error. In our current system, if we've changed it from year to year about whether it was gallons per minute, gallons per day, to acre feet, and reporting on your water rights is one of many requirements that you have, one of many burdens that an individual has throughout their year, throughout their life, and people may have not been paying enough attention to what they were reporting. And so a lot of those small diverters appear to have reported in error what their actual diversions were and are likely much smaller, and so would not actually be subject to these regulations. One of them that we found might have been an input error by the division, and so that's something we can clean up on our end in our new system. The new system, CalWaters, will also help us, highlight some of these previous reporting errors. We're eager to work with folks to confirm, how to correct their previous reports so that they are no longer subject to these requirements. And if there are some folks who, again, are small diverters, but truly do divert this very large amount of water, 30 CFS, for just a short amount of time, then we can also work with them on alternative compliance plans, as you mentioned, to figure out how to, report during times of when they are actively diverting a large amount of water, and, have reasonable requirements on them to, maybe report less frequently if, in fact, this is something that benefits both the division and the public need for this data, as well as the diverter.
Yeah, thank you for that. It just seems not necessary to continue to have these weekly reports, no diversion, no diversion. And so I really do, I understand the sort of the conundrum that a lot of those that fall in this category, it's likely due to inaccuracies. So this will certainly get their attention. But looking forward to hearing how this plays out in terms of the outreach and those that fall into the discretionary alternative compliance. Thank you.
Thank you.
Thank you, Vice Chair. Really appreciate those questions and points. Looking to other fellow board colleagues, Board Member McGuire.
Yeah, thank you. Great work all around, and really has been a sprint. I've been watching this regulation update process for the last 6 months, and I've been pretty amazed at how far you've come, and also just the receptiveness, the willingness to listen and incorporate comments and feedback that you've been hearing from stakeholders is, really appreciated. I've seen that here with some of the changes that you've made along the way over the past few months, and it's acknowledged and appreciated. I agree. I mean, we're at a point where we need to move forward. We can't make good, sound, efficient, effective water management decisions without good, sound data. And I think that's been clear over the past few years with the droughts that we've been through, with the challenges that we've had and the need to scramble in some cases to figure out where the water is going and when and by whom. And this is really going to move us forward along with the pairing of the CalWaters rollout. So thank you for the work here and keeping on task. 2 questions for you. So one is, and kind of also, this is all in the weeds, so I'm going to stay to that theme. So CalWaters, just coming out right now. So folks are just starting to see it and understand what's happening. So we have a little bit of a challenge, I feel, in that we've got this brand new system that's being deployed, and we're probably going to have some learning curve, and there's going to be some bumps and bruises along the road just with that new, very large system deploying out to many thousands of water right holders. At the same time, we've got the regulation, and I know you've been very thoughtful in trying to bring those along so they're compatible with each other. But could you just talk about what you anticipate there? Or could there be any challenges in terms of CalWaters maybe informing or providing an insight that we didn't have before about that might impact this regulation?
Absolutely. I think that, to kind of tee off of the discussion we just had with Dee Dee about the 30 CFS, many folks, maybe through, previous reporting issues, the fact that they have a very small diversion are not aware of some of these requirements that they have on them. And our new system, our existing system does not communicate that with them, but the new system will. I think to your point, though, as well, if these are a whole lot of changes happening, and this is a lot that's getting thrown at you. Earlier, Sierra presented the implementation schedule, and we have delayed some of the requirements based off of public feedback and engagement on that. And so we're hoping that with the new system, people will be more aware of their requirements. It'll be more obvious. We'll have these templates available on the new system that will be easy for folks to download. They'll be able to, look through some certain questions and be able to narrow down, okay, this is, based off of, my input of my situation, these are the templates that I need to download and then upload back with data in them. So we're hopeful that the new system, while it, will take a while to get used to, that it will really be a huge enhancement for diverters. They will be more aware of their requirements in the new system, and we will better help them get adjusted to those requirements. I think that it definitely will take some dedication of the division staff to be available to diverters to answer these questions that are going to have these issues. We have however many folks who are very small diverters who fall into this, specific 30 CFS issue, and they're probably going to call us, maybe in a bit of a panic, wondering why the heck am I subject to this requirement? What's going on here? How can I get some relief? So I think, that is going to be a real thing that happens, and we will be here to address those concerns. We'll make sure to have some policies in place, have standardized ways that we can help interact with the public, and make sure to walk them through how to correct their previous data, walk them through other issues with the new system. And as I mentioned as well, we're working on an outreach plan in conjunction with the Upward team. So we are seeing how we can help couple this information together, as well as spread out the outreach over time. So again, this fall, we're really going to be focused on this is how you need to change how you're measuring. This is what you should be doing now, and also this coming diversion irrigation season. And then next summer, next fall, when people have done their new measurements, when they have, been able to harvest their crops and are able to come up for a fresh breath of air, then we'll say, okay, here's some additional outreach materials about this is how you need to submit your data in the new system. So we're making sure to spread out our outreach that's happening over a longer period of time to hopefully target folks towards using their attention in a valuable and specific way so that they can focus on what they need to know now, and for what they need to do in the future, we will inform them about that in the future.
Great. Yeah, lots of moving parts there, and good to hear that. And I think the shifting in the schedule, giving folks a time to transition, was for me really, really helpful to see that change. And I think that will go a long way to getting folks on board and comfortable and understanding of what the new expectations are. And so my last question is kind of a little bit farther along those lines, which is alternative compliance plans. I think we can acknowledge and appreciate that with the existing regulation, it allowed for alternative compliance. I think that's a really important tool for flexibility for folks with unique situations and able to show that they're able to measure in a unique way given their circumstances. I think the challenge has been in providing feedback to those alternative compliance plans and ensuring that they are in fact reflective of, and that water right holders have the confidence that the plans that they're developing and the systems that they're implementing are going to ultimately be accepted by the division. So I know some of the challenge here is that you want to provide folks with time to develop the plan and to then implement it. But on the other hand, that then also throws responsibility into your court in terms of additional work to review those plans and to provide feedback one way or the other. So could you just talk a little bit about what your plans are for that? The ACPs, I know there were a lot that were submitted with the original round of regulations, quite a few, and I would imagine that we're going to have quite a few more here as well.
Yes, it'll be interesting to see what that looks like in the future. We'll see if the ACPs start ticking up or if they remain pretty similar. The existing regulation has a requirement to renew your alternative compliance plan, your ACP, every 5 years. With the proposed regulations, it's that it would remain in perpetuity. If anything changes, let us know, but it doesn't have that same 5-year renewal requirement to allow it to be a more consistent, continuous solution for folks if that's what's needed. I think we haven't set any specific plans within the division, but I believe the goal is to be reviewing those larger diverters and their alternative compliance plans, prioritizing those. We have also engaged with a consultant to help us with reviewing some of the existing alternative compliance plans. And we've worked with some of the staff that were here earlier for the Superior Accomplishment Award to figure out how to review these review the plans, as well as coordinate the outreach with folks, letting people know if their alternative compliance plans are approved, if there's any deficiencies, and figuring out the timing with that with the launch of Cal Waters. And so we can let people know if there are any deficiencies, how to correct them, and here's how to submit the form in the new system. I believe you had another point that I am blanking on right now. So if you could remind me of additional question you had.
I think you're acknowledging the work that's ahead, and I just wanted to point that out. And so I think for me, it'll be I'd welcome a report back and an update on really all of this going forward at the appropriate time. But to just hear how that's going, and maybe in some of your outreach and training that you're proposing to do, you can incorporate some of the thinking on the ACPs and providing some further guidance on that to folks so that everyone's got kind of a clear picture of what might be acceptable, to provide a level playing field as well. Thanks.
Absolutely. Thank you.
Board Member McGuire, if I can add in a little bit, just a little bit more about the current regulation prior to the proposed revision. At present, there is no requirement for the division to respond. So we have about 700 ACPs. I think formally we've reviewed 2 and let people know that this is, we've reviewed and it's approved and so on and so forth. On top of that, there's this existing 5-year renewal requirement. So we started getting questions about 2 years ago. Well, was my old one approved? Why would I renew a new one when I don't know if the old one's approved? A lot of the comments that we got in this iteration of the regulation were focused on, diverters basically asking for some more affirmative response related to the ACP, saying, we need to know if this is approved or not. It's all tied back to that 2015 initial legislation where, frankly, the division never received resources to do that workload. So we're trying to find a pathway forward that acknowledges the diverter's very reasonable request to get some form of acknowledgement or recognition, while at the same time trying to manage the workload that we never frankly got the staff to achieve. And so this proposed step, I think, is a good initial effort to acknowledge that. It removes this 5-year requirement, kind of reduces that ambiguity. It does require that if there is a change to an ACP, that they update us and send us additional information. But it also allows the board to kind of ask, does this make common sense? And looking at whether it's perhaps a hydroelectric facility or a series of hydroelectric facilities or some very rural diversions or a series of ponds, that may work in chain. There's a number of different opportunities for ACPs to come in for board staff to review it. We absolutely are going to start with the larger diverters. We have it's a general rule, but a 90-10 rule where 90% of the water use in a basin is with just the 10% largest diverters. And so looking at those that may submit ACPs, we know that there will be some larger ones. We can start there. We can provide this more rigorous review. The smaller ones, we may get to them over time if it's mission critical, if there's a particular question, but a 10, 11 acre foot diversion may not receive the initial focus of just very limited staff resources.
Board Member McGuire, if I could follow up briefly, because I think this is going to come up in comments, and then along the lines of common sense and resources, we usually approval of an ACP required a finding. You can see that in Water Code Section 1840. This was Sierra's idea, and it's brilliant. It's embedded, the findings embedded in the resolution at number 2, so that we don't have to spend resources on every ACP deciding whether this particular one is infeasible. So we've embedded a global finding into the resolution to accommodate that, so we can spend our time actually reviewing ACPs for efficient and more effective monitoring and reporting.
Thank you for all those responses. Really helpful.
Yeah, really appreciate all those points, and thank you, board member. And we've had updates certainly on reporting on water rights, and touch base on water rights here and there in our hydrologic update. And we'll definitely, especially as we move into implementation of this regulation, the new water rights data system, all of it, we'll have more opportunity to make sure we're checking in and understanding how implementation is going. So appreciate those points. Board member Firestone.
Yeah, and I know I want to hear, obviously, the public comments on this, and just to share broadly, echo what has already been discussed, super helpful. I think just recognizing these are really critical updates that we need to make. It's not going to be perfect. This is not the final destination of where we need to be with these regs. And so I think we're going to need to have everyone's patience and collaboration in figuring out how we continue to get to a place where we can have data that is critical for managing our water rights system and our water rights and our water resources. And we are far from that, frankly. Now, these are a huge, important step forward, but they're not all the way, I think, to the final destination of where we, I think, ultimately will end up. At the same time, it's really hard from a user's perspective to have things continue to change. You need some stability and clarity, and that's at tension. So I think we need to have understanding on all sides as we try to figure this out. But I really look forward to and appreciate the engagement, and eager to hear the more specific comments folks have.
Thank you, board member. Let's go ahead and start hearing from folks. I believe our first commenter here will be Megan Murphy, be followed by Pat New, and then Kyle Knutson, and then Zach Kostanolga Johnson.
Good morning, State Water Board members and staff. I'm Megan Murphy, Senior Regulatory Advocate with the California Municipal Utilities Association, or CMUA. CMUA represents 85 publicly owned electric, gas, water, and wastewater utilities statewide, and together CMUA members provide water service to 75% of Californians. Thank you for the opportunity to comment on the Division of Water Rights revisions to the water measurement and reporting regulations. CMUA actually submitted comment letters on April 23rd and June 6th of 2025 and have met with State Water Board staff to discuss our comments. We want to thank the division for making some of our suggested amendments, especially the removal of the need to determine whether water was stored and or apportioned to individual water rights. We also appreciate the division providing a grace period for the full submission of the requirements to go into effect. While we appreciate many of the updates the division has made, CMUA still has three main concerns, and the first is the frequency of reporting. The regulation requires that large diversion submissions shall be submitted on a weekly basis at minimum, and also requires hourly reporting for large diversions. Weekly submissions of hourly data places a significant burden on CMUA members as it is both time-consuming and resource-intensive. CMUA is concerned that the weekly and hourly reporting requirements for large diversions are impractical, burdensome, and may not yield meaningful benefits relative to the administrative burden and costs. We recommend limiting such high-frequency reporting to periods of extreme drought or other urgent water conditions where the added data granularity would be most justified. Second, we recommend revising Section 936 on an alternative compliance plans to require the division to evaluate and issue a written decision on each alternative compliance plan within a defined time frame, for example, 90 days, using a transparent criteria to ensure adequate oversight and accountability. And I understand that was discussed quite a bit today, but just emphasizing some transparent criteria in the review of those ACPs. And finally, CMUA appreciates the division's early release of the CalWater's reporting system and respectfully requests that there are continued opportunities for water rights holders to provide feedback on the system, including its data and templates. Thank you very much for the opportunity to comment, and we look forward to the continued participation in the rollout of this regulation.
Thank you. I appreciate the engagement from your member agencies, and hear the concerns certainly on the weekly reporting. But I think it'll bring us into an important phase here when it comes to administering water rights in the state, where we are becoming more real time. And but I think either through the alternative compliance plans or just further discussion, definitely want to just make sure how we understand how we ensure that the reporting doesn't come with undue burden and it is reflective ultimately of the cost of it. So just thank you. Much appreciation, Ms. Murphy. Next, I'd like to call up Pat New, be followed by Kyle Knutson.
Good morning, board members. My name is Pat New. I'm a senior engineer with Pacific Gas and Electric Company. I'm responsible for water rights, water management associated with PG&E's hydropower assets. I appreciate the opportunity to provide some final comments and words of caution on the proposed measurement regulations during this meeting. I further appreciate the engagement we've received from both board members and staff on the measurement regulations and opportunities to provide field visits to PG&E hydro facilities. I'm going to speak quickly, so I apologize. I know I'm subject to some time constraints. I'd like to start my comments with reviewing the purpose and intent of the measurement regulations. When originally adopted almost a decade ago, the intent of the measurement regulations was to provide a mechanism for the division to enforce compliance with water rights. This effort came in the aftermath of the 2014-2015 drought, when division realized it lacked the necessary means to enforce curtailments or compliance with water rights. More recently, we have heard sentiments from the division identifying a desire to make data-driven decisions in administering water rights and the availability of water, a worthwhile ambition supported by PG&E. The reason for reflecting on the original purpose and intent of the measurement regulations is to outline where we feel that the proposed measurement regulations depart from a path that serves this purpose. Firstly, the proposed regulations include increased requirements for data collection at reservoirs of more than 5,000 acre-feet. In addition to existing requirements that require gauging the storage in reservoirs, the proposed regs require additional gauging of releases and withdrawals via storage or from storage via stream gauges downstream of the reservoirs. As an expert in water right accounting, I can say with conviction that stream gauges downstream of reservoirs are not required to understand compliance with storage water rights. We have provided extensive comments on this updated requirement to no avail. The justification for this requirement provided by staff is to obtain more granular hydrographic data throughout the state to understand where water is in the system. Leveraging the measurement and reporting regulation to this end seems to be an inappropriate use of regulatory requirements. If there is a need for more granular hydrographic data throughout the state, it should be achieved via a state-sponsored stream gauging program implemented by the Water Board or other agency, not be implemented at the expense of water right holders. To recap, we don't see how the increased measurement requirements applicable to reservoirs provide value in determining water right compliance, and although more granular hydrographic data throughout the state may help the division in making water right or water management decisions, it does not seem appropriate to leverage the measurement and reporting regulations as a mechanism for achieving that end. Secondly, the proposed regulations include requirements for some water right holders, large diversions of more than 10,000 acre-feet or 30 CFS, to provide diversion data to the Water Board on a weekly basis. It is our opinion that useful data suitable for the purposes of water right compliance monitoring and water management decision-making cannot be provided on a weekly basis. Most large diverters that are subject to these weekly data submittal requirements are diverting commingled water that includes direct diversion under various rights, rediversion of previously stored water, and water supplemented by contract deliveries, as well as non-consumptive and consumptive combined use diversions. In order to make use of diversion data recorded by measurement devices, the data must be analyzed and processed to apportion the data to applicable water rights so that it can be attributed to the appropriate hierarchy on the priority system. This reviewed and processed data is then suitable for use in compliance and water management applications. While weekly data submittal requirements may result in additional data becoming accessible to the Water Board, it does not mean the data will be usable or provide utility to the Water Board. Similarly, the 10,000 acre-foot per year or 30 CFS threshold that triggers weekly reporting requirements may be appropriate in smaller watersheds where these are significant amounts relative to the available water supply, but can be relatively small quantities in larger watersheds, thus resulting in excessive amounts of large diverter data submittals that are unlikely to be of much benefit to the Water Board. We believe it would be better to set significantly higher thresholds in larger watersheds where water rights can have high face values in the hundreds of thousands or millions of acre-feet, or have the Water Board identify specific water rights or points of diversion that would actually provide useful data on a weekly basis for its needs rather than collecting data for the sake of completeness. In closing, I would like to briefly highlight a couple other areas of concern. These include the lack of availability of reference materials in the measurement regulations. These include reports of measurement methodology, data file templates, and the process for submitting or transmitting data directly to the Water Board. All of these are referenced in the proposed regulations and have been proposed for adoption without ever having been made publicly available for review or comment. Additionally, the proposed regs further require the submittal of extensive information related to measurement devices, including manufacturers, model numbers, serial numbers, calibration reports, location information, and on and on. Reflecting back on the comment made by Mr. Ekdahl, staff currently only has the availability to review 2 of 700 ACPs that have been reported over the last decade. We question whether or not this information that is being required to be submitted will ever be looked at. Instead, PG&E recommends scaling back on the amount of information required to be submitted and increase field inspections and interaction between water board staff and water right holders. Increased inspections and field verification of compliance with measurement regulations would build trust among water users and the water board. In closing, I believe the common euphemism, "you have to learn to walk before you can run," helps illustrate the final message of these comments. We encourage the water board to work through the already extensive struggles it has experienced in making use of measurement data before grasping at even greater challenges. Specifically, it seems appropriate to first work through how to utilize annual data that will be submitted under the new reporting system prior to requiring submittal of data on a weekly basis that will pose entirely new challenges. It seems reasonable to assume that understanding how to utilize more frequent data submittals will be an easier undertaking once processes have been adopted by water users and the water board to provide useful data on an annual basis versus attempting to dive into both simultaneously. With that, we caution the board in adopting the current regulations as drafted and suggest further edits to address these concerns. Thank you for the opportunity to repeat our comments and concerns on the proposed revisions to the measurement and reporting regulations.
Thank you, Mr. New. Really appreciate the great engagement. Appreciated the tour, and appreciate the concerns, truly. But I think, I'm comfortable at this point. I know, though, that we have opportunity to further refine as we implement, but appreciate the continued engagement. I don't know if folks from the staff wanted to respond to anything in particular at this point from Mr. New, but
I did want to respond a
Please,
little bit,
Mr.
and I will look to colleagues to course correct me if I'm off base, but appreciate the comments from Mr. New, numerous comments from PG&E over the course of the process, including going back to October, November of last year, where we also had an administrative draft and opportunity for comments then. And I think there continues to be persistent misunderstanding about the revisions to the regulations are doing and the intent and purposes. A lot of the issues that were just flagged have been in place since 2016. So we're not fundamentally increasing them. All of those issues about the measurement device type, serial numbers, locations, those have largely been there since 2016. I think entirely been there since 2016. I look to staff, I see nods.
Yes.
The weekly reporting for large diverters, also in place since 2016. What we're doing in this iteration is actually making it substantially easier to calculate those numbers and to actually report them. And you go back to that presentation where we had the bar graphs that showed the compliance. There is a difference between the SB 88 compliance and the annual diversion report compliance. And the annual diversion reports do get close to 95%. That's the yearly submittal. This is how much I diverted. It can be very complicated to calculate that because of all the issues that were raised. There's overlapping commingled water rights, there's contracts, there's all these different things that kind of factor in, and it makes it really difficult to figure out exactly how much was allocated to each individual right. It takes time, and people take a lot of effort and care in putting that together to report it accurately. What SB 88 does, or the metering and measurement, gets to this fundamental question of how much is available right now. And you don't need to parse it out to the individual right in these large diversions to ask that question and to get usable and important information. And so the changes that we're making related to looking at just the volume in a reservoir or tying it to a downstream gauge and doing some very basic mass balance type math make it a lot easier to report. This is how much was kept in the reservoir or point of storage, and this is how much went downstream. And that's kind of the fundamental question, that is the fundamental question that we're pursuing. A fundamental disagreement about 10,000 acre feet not being a lot of water. Just doing some rough math, just because it's a helpful comparison. 10,000 acre feet is how much water goes over Niagara Falls in 5,000 seconds. So about 2 acre feet per second at Niagara Falls. You just have to do a couple math. That's a lot of water. You start to picture it in your head just so you can have a visual representation of what 10,000 acre feet looks like. For reference, 5,000 seconds is 83 minutes, maybe. So that's a lot of water. We do think it's important, even in any watershed, to kind of have that level. There are some places where that number might need to go down over time. We're not making that call here today at this regulatory update. But basically, coming back to my core point, a lot of the provisions have been in place since 2016. We're trying to make it fundamentally easier. We point towards the expansion of the alternative compliance plans to really address a lot of the concerns that were raised here. And we do believe it will be faster, more cost-effective, and more efficient than what's in place now.
Much appreciation for that response, Mr. Ekdahl. And again, Mr. New, I really do appreciate the concerns. I mean, PG&E is probably pretty unique amongst our water right holders insofar as the complexity and scale and size of your projects and the then complexity and scale and size of your reporting. So I think the alternative compliance plan, may be something worthwhile for sure to look at for you all, given the obvious complexity of your water rights and management of significant projects within the state.
Thank you.
Thank you. Really appreciate it. Thank you, Mr. New. Next, I'd like to call Kyle Knudsen, be followed by Zach Castanola Johnson.
Hello, can you hear me?
We can. Thank you.
Thank you. My name is Kyle Knudsen. I'm with MBK Engineers, which represents many water right holders across California. Thank you, Chair Esquivel and fellow board members for this opportunity to provide public comments. We want to pass along our appreciation as well for the division staff's efforts on the SB 88 regulation revisions, including multiple comment periods and workshops. We understand the desire to improve the regulation as the division's use of the information has changed since initial implementation. We are aware of the compliance issues. However, the water user community has spent almost the last 10 years since the implementation of SB 88 purchasing and installing measurement equipment, repairing and replacing measurement equipment, calibrating and certifying this equipment, developing data management protocols, developing water right reporting, accounting processes, inputting this data and details into annual water right reports, and in some cases even developing websites for publicly hosted telemetered data. Based on these experiences, we provided multiple comments during this process. We believe that some of the revisions proposed include practical improvements, but today we provide the following additional recommendations. The revised regulation includes a new requirement of preparing and submitting measurement methodologies for all water users subject to SB 88. While we understand the desire and in some cases need for the division to understand reporting accounting processes, this is a significant new requirement for many water right holders, particularly in situations with complex and/or multiple water rights. The process to document the methodologies, including potential review by boards and legal counsel, will require extensive time. Similarly, it will be an extensive undertaking by division staff to review all of the measurement methodologies, in addition to annual water rate reports, the data files, and alternative compliance plans. Instead, we believe that a focused implementation for this requirement would be better than a blanket requirement for all water users. For example, a measurement methodology could be required for those subject to telemetry or enforcement actions. A more targeted approach would also be more efficient for division staff to review and engage with water users about these methodologies in a meaningful way. It appears that the draft regulation revisions grant an extra year to develop these measurement methodologies. However, this is a major change with the largest impact on water users from the proposed regulation revisions, at a time when there's many other changes also occurring. We recommend limiting or focusing the implementation of this requirement and also extending the time for development and submittal of measurement methodologies. Other items that we commented on and still believe additional workshops and guidance are needed on include telemetry implementation, such as how existing public telemetry websites that were developed by water users to comply with the current version of SB 88 and are currently in use get approved, and how water right holders telemeter their data to Cal Waters, templates and guidance for items such as the measurement methodologies, data file templates, telemetry file templates, etc. Lastly, we provided comments about how this effort is connected to others like Cal Waters and the efforts of the Telemetry Research Unit. We recommend that these groups continue to work closely together on these similar items. We've provided our experience with the participation in the SB 88 revision process to both of these groups, specifically Cal Waters. Through beta testing and recent testing in the soft launch of Cal Waters, we have seen significant effort performed by the division. However, we know that there is still much to be done to improve the functionality of Cal Waters prior to October 1st, if the expectation is that water right holders will complete their water year 2025 reports in Cal Waters prior to the January 31 deadline. Some of these items that still need implementation and/or improvement in Cal Waters include the import of existing information from ERIMS and RMS, such as measurement device information, guidance on how to use Cal Waters, guidance on new questions within the forms in Cal Waters, and the ability to review and share draft and final water rate reports outside of Cal Waters. Once again, we appreciate the opportunity to provide comments as well as the prior opportunities to work with division staff on these revisions, CalWaters, and other related efforts. We're excited about some of the practical revisions to the regulation and the potential we see with the use of CalWaters. However, we urge you to consider these additional recommendations for a successful and efficient transition. Thank you for your time.
Thank you, Mr. Knudsen. I do appreciate the great and continued engagement across this and appreciate the concerns and flags with the ongoing reg. Just want to look to our folks, though, just to make sure we're giving clear information when it comes to CalWaters, its implementation, and when folks would be being asked to report into there. I think we've been pretty clear when it comes to these changes to the reporting requirements and the water year that they would then need to be submitted in, which isn't until next year, essentially. But looking just to make sure we're clear on when it comes to CalWaters and moving to that platform, when folks would be started to report into it.
Yes, it's my understanding that folks will submit their water rights reports for this next year in CalWaters, and that is moving ahead. I'm not sure if Mr. Ekdahl wanted to contribute anything else. I also did have a comment about the methodologies once Mr. Ekdahl is finished commenting.
Yeah, no, thank you. In terms of reporting, the deadline for the water year 2025 reports, which ends September 30th of this year, would be January 31st of 2026. But as was flagged in the presentation, that is still using the old requirements. So the new update to the regulation will not take effect for that first reporting period. You just report like you have been doing. It's the following year where you have to update and accommodate and make the proposed changes. In terms of other CalWaters implementation, I do think it's worth maybe just running through at a high level. I know this is not a CalWaters meeting, but just to flag that there will be extensive CalWaters outreach and engagement really kicking off in September, but then running through October, November, and if we need to go into December as well, we can continue to do that. And there will be a whole rollout and a kind of additional public information at a future board meeting, as well as on our website. And if there are questions, there is a CalWaters help email. Please use that help email, and someone will get back to you and respond pretty quickly. The other thing I think it's important to highlight, and this kind of goes back to the previous comment about, a lot of these things were already in place in 2016. A lot of questions about what capabilities need to be in CalWaters going forward, recognizing that none of these were in place in ERIMS or RMS to begin with. So we are looking to try and add as much functionality as we can, but already compared to where we were, the functionality is improved by leaps and bounds. And so, yes, we want to be as accommodating as we possibly can, but the tools that are already available right now are going to be pretty substantially improved. The methodology, and Lindsay, maybe this is something that you were going to get into as well. For the vast majority of reporters, the methodology will require essentially zero work or update. It's basically going to say, this is what I was doing. This is how you make these calculations. Describe to us how you come up with these volumes. One of the things that we were seeing when we did get data and could look at it was it was kind of incomprehensible. You couldn't figure out if there were commingled water supplies, water rights, overlapping water rights, what went to which, where was a point of reversion, all these different factors that make water rights really complicated in accounting. And so the methodology is an opportunity for people just to explain, this is how this works. It doesn't have to be overly rigorous or detailed, but just enough so that people can read it and say, I can understand how to parse this out. Lindsay, please go ahead if I misstated anything.
Exactly. Yes. Thank you for making that point. That's exactly what I was going to say. These are meant to be very easy ways to communicate what exactly people have done. Say it's like, I use this device to translate it this way to get at this data. We often will say, this is the show your math portion. We're not asking for people to go into legal agreements, to go into any kind of description of, historical needs or anything like that. It's really meant to be a basic way of saying, I take this measurement data, I convert it, use this way, and then get this volume. Because a lot of times people are not measuring the volume directly, they're indirectly measuring it. So just clarifying that for us. we definitely, don't anticipate that these methodologies are going to, go through extensive legal reviews. That isn't part of it. It's, that's not the goal of this, is to create a legal adjudication or anything related to that about their water rights. It's literally just show us your math, explain to us how you're getting from your device to your volume calculation.
Appreciate that. And I know for folks, when you're reading regs or you're reading the work that we may do, they want to, worst case scenario has to be kept in mind because that's what they're looking to avoid. I just really encourage water right holders and others as they go to implement to just reach out if there's questions. You'll find we're actually trying to be far more reasonable than sometimes interpretation of words on a page may seem. We're trying to be clear and just appreciate, again, the concerns from folks. And again, there's an opportunity to make sure checking in with staff, clarifying, and making sure that the ask that we're having before you is reasonable. So thank you. Okay, we have our last commenter. I'd like to now call up Zach Castanella Johnson.
Water right holders throughout California, including several that operate reservoirs that fall within the revised regulations definition of large diversions. Along with my colleague Ryan Becerra, I have submitted multiple rounds of comments on these proposed regulations. And we have very, very much appreciated the board staff's attention to written comments that our firm, our clients, and others have submitted on the multiple drafts of these regulations. The edits to the draft regulations that the staff has made in response to comments have been very helpful. Today, I have a few comments on some remaining edits that we think are necessary to avoid confusion in how these pretty complicated regulations will work in practice. Those edits are related to the reporting of diversions of water collected to storage and the feasibility of measurement of transfer water. So first, we suggest that two minor modifications be made to section 933 to eliminate confusion created by the text, and those changes are reflected on the slide. As written, the language suggests that the regulation requires real-time measurement of storage operations. But real-time measurement of storage operations is not possible. As under the board's regulations at sections 657 and 658, water must be held for 30 days to be deemed stored. While we agree with the overall objective of section 933, we believe that the significance of using the word storage is misunderstood and the word is being misused, confusingly implying that storage of water, which is a process that can only occur after the passage of 30 days, can occur and be measured at an hourly time step. So to eliminate this confusion, we would change the language of subdivision 933A3 to read as it appears on the slide, volume and rate of water diverted to or collected at a storage facility, instead of the current language as revised, which reads volume and rate of water diverted to or collected to storage. We would also change the language of subdivision 933A4 to read volume and rate of water withdrawn from a qualifying reservoir instead of the current language as revised, which reads volume and rate of water withdrawn from storage in any qualifying reservoir. Second, we believe that the definitions of point of diversion and rediversion remain problematic and should be edited. Next slide, please. We appreciate board staff's prior edits to the definition of point of diversion, but we do not think that it solves the problem because the definition at subdivision 931.0 and on the slide here still includes the highlighted phrase points of rediversion of previously diverted or stored water. Because the final revised regulations use the phrase point of diversion 43 times by our count, we think that the inclusion of rediversions in the definition of points of diversion may cause significant confusion. This could be especially problematic with water transfers because transferors generally do not have control over the points at which transferees redivert transfer water. To address this problem, we propose adding an additional subdivision to the end of section 932. Next slide, please. The new subdivision 932D would read as follows. D, transfer water. For transfers authorized under the Water Code, the transferee shall be responsible for measuring and reporting the physical diversion of transfer water at the transferor's point of rediversion through which the transfer is authorized. That concludes BKS Law Firm's comments. Thank you again for the chance to provide input today on these draft revised regulations and for your time.
Appreciate your time as well and for the comments here. Much appreciation. Looking to Lindsay and folks around these recommendations around language. Just
I'm actually going
get
to
your-
pass this one over to Sierra and Sam Olson to provide further guidance. Thank you.
Thank you.
Thank you. So I'll start with the discussion of storage. To start, in the authorizing statute, it does say that people need to measure direct diversions to storage, and withdrawals and releases. Second, there are only two types of water rights: direct diversions and diversions to storage. So by saying, I believe it's item 1 of the cited section here, that would be volume and rate of water directly diverted. Is it? Oh, it's item 2, my mistake. So by already parsing the volume and rate of water directly diverted, the only other option is volume and rate of water diverted to storage. And then for the withdrawal issue also, that's following along. It's diverted from storage and then it's withdrawn from storage. For releases, we've defined releases as water leaving the reservoir. So that could be water not put to beneficial use. It could include bypass water, abandoned water. So that we agree does not need the from storage qualifier, and we have crafted the regulations to specify that. But for withdrawals, since that is water being put to beneficial use, that does need the from storage component. And this is to avoid double counting with direct diversions.
And I'll add, I think, correct me if I'm wrong, Sierra, that this is for the annual report. And we heard the comments that it is impossible to figure out and delineate water stored on a real-time basis. And so that was removed. So the reporting comes afterwards when you're able to account for those curves and rules in the regs. And I will also add that this reg does not codify the licensing rules in the Code of Regulations at 657 and 658.
Really appreciate all those responses and still appreciate the recommendation for language nonetheless from folks and to continue to work with us. Vice Chair.
Yeah, I agree. I think I'd like to spend a little more time on this. I'm not following, though. Are you saying that this recommendation would result in double counting?
Yes, because if you're already separating direct diversions and then you're saying diverted to a reservoir instead of diverted to storage, that could be water that would be considered direct diversion. And so you've already counted for that and it's being counted again.
I'll jump in a little bit more. The diversion to storage question was something that we discussed at length over the course of, frankly, the last year, trying to address exactly the issue that was raised about 30 days before it's considered storage. The way that the language has been crafted is specifically done to avoid that issue and instead requires, and please correct me, I don't remember the full text exactly, but we really instead focus on, instead of diversions from storage at a real-time basis, on a real-time we require diversions from the reservoir. And that then specifically avoids the issue that was raised here and does not require you to do that specific counting of what's been held for 30 days or what hasn't. It really is looking in a real time of what's coming in, what's coming out. And that's ultimately what we believe the language directs and provides for.
Appreciate all that. Many thanks. And thank you again.
Thank you.
All right, that brings us to the end of our commenters. And again, appreciate everyone's comments and engagement, continued engagement with this. Again, depending on how the board goes here, but if we choose to adopt, there'll be a lot more engagement certainly as we implement and opportunity to unpack if folks are finding challenges. But looking to fellow board colleagues, if they have any other comment, question, or anything they'd like to have addressed, and then otherwise maybe prepared for a motion.
Well, I think we're at a point where we need to be decisive and acknowledging that there's clearly some nuance to all of this and areas where I think there's going to be ongoing discussion and consideration, especially with Cal Waters and the rollout of this regulation, the development of guidance, the real world implementation of this, and the consideration of how alternative compliance plans fit into this whole scheme. I think will be informative going forward. So that report back, I think, is going to be very helpful for everyone, just to get a sense for how we're doing. And for me, I think I'm reflecting on Board Member Firestone's comment, actually, that this isn't necessarily perfect, but for me, it's a huge step in the right direction. So I think we're at a pencils down point in my mind, in that we do need to move forward today. So I'd be comfortable making a motion if the other board members are good with that. So with that, I will move to adopt the resolution under item number 3.
Thank you, Board Member. Okay, yeah.
Okay. Yeah, and I agree with what's been said, and I'll second, but
Thank you both.
open to
And
discussion.
look to the Vice Chair for some discussion here before we go to vote.
So I was prepared to support this, but in the last discussion, I'm just pausing. And so I'd like to have a little more discussion on it, it's hopefully to increase my comfort level, because I'm supportive otherwise. So on the issue of diversion to storage, I'm trying to better understand why the continuing concern if you change the language in order to address that. And I'm tracking what you're saying about double counting, but those that oppose that language don't seem to be concerned about double counting. So I just want to make sure I understand this and how this concern could continue to be addressed in the future.
Yeah, and I'll start, and Sam and others, please jump in. The main question, or I think the main area of confusion, is what's required under the annual report versus what's required under SB 88 reporting. And under the annual report, we do want the volume or diverted to storage, right? So that triggers this 30-day, you have to hold it for 30 days before it's considered storage rule. But that comes in once a year. You figure that out, and that gives people time to do all those calculations. I think the comments about not being able to calculate storage on a real-time basis are correct. And the draft regulation was written to accommodate that by removing the term storage in that requirement. So instead of saying how much you diverted to storage or release from storage, it's volume going into a reservoir, volume leaving a reservoir. We avoid that storage component and just look for the volume going in, volume going out, which you can report on a real-time or weekly basis. So the issue about that was just raised about, well, we need to change these terminologies because of the storage issue, don't apply to the SB 88 reporting requirements. That was a comment more directed towards the annual report requirements. Is that fair?
Yes.
Okay, so is there a concern as to water coming out of storage where it's specified, and that if it hadn't been there 30 days, that it's technically not coming out of storage?
I think that is the issue or concern that was being raised, that people are reading the proposed regulation as saying, well, you're going to have to report water that we technically didn't store. Maybe we held it for 28 days. And then you're going to do some math behind the scenes, and you're going to accuse us of exceeding our water right allowance. And that is not the case. That's not what the language requires. It's not how the regulation was constructed. What the regulation allows us to do is look at the amount of water that came in and the amount of water that goes out, and much more easily do that comparison internally. Was there water that was kind of held back for some period of time or not? It's a simple mass balance equation as opposed to this very convoluted 30 days in, combined water rights, et cetera. It's just a very point analysis, kind of, if that makes sense.
Yeah, that helps. What about the concerns by those that think that we might do something with that information? Can you point to anything in the resolution or in the regulation that would alleviate those concerns? Because it sounds like it's not our intention anyway.
Correct. And I think, I don't know if there's anything in the regulation language itself. I can point to past practice, and I'll use perhaps Clear Lake and Merced as examples. Under the old regulation, both were the subject of SB 88 compliance enforcement actions over the last 3 years or so. And I'm not going to get the numbers quite right, but in Merced, for example, there were several dozen folks that were not SB 88 compliant. We initiated enforcement actions. Enforcement actions is a very broad term. It really doesn't mean that we're going to start fining people. It's really a request to come into compliance. And of those several dozen, I think there was only 2 that ended up not taking the actions that were required. Clear Lake was about the similar level of compliance. So even though we may go out and talk to people, we may say, hey, can you update your information? Very, very rarely does that actually result in an enforcement action to the point where we actually have to take some sort of civil liability penalty. And that's only with conspicuous non-response and non-compliance. The vast majority of our efforts are to bring people into compliance and work with them to do so. I don't know, I looked to staff to see if there's any specific language that might alleviate concerns. I don't believe there's anything acknowledging that directly in the.
But just to add to that, in terms of enforcement, not just non-compliance with the reg, but for potentially holding the water longer than 30 days, correct? That's a concern as well that some might have.
So from the SB 88 data, I don't believe that would be an initial concern because you'd be allowed to rectify that data at your annual reporting compliance. And so one of the things that the resolution and the proposed regulation does do is allow for provisional data. We did get a lot of comments up front about, we go back and we correct our data over time, and those are very real and legitimate concerns. Equipment goes down or you have something that happens. So we're not looking to use the weekly data as an immediate point of enforcement that triggers something automatic. There's a lot of complicated math that will have to go on in the background. There's still the opportunity as part of your annual reporting to rectify any potential volume discrepancy. If in part of your annual reports you do turn out to have violated your water right or exceeded your water right, that may trigger a enforcement action. Most likely it wouldn't, but that wouldn't be the SB 88 revisions that we're talking about today that would do that.
Yeah, it's the requirement for not longer than the 30 days. Yep. Did you have anything, Ms. Olson?
Yeah, staff would just add that the original authorizing statute, Water Code Section 1840, provides for any water diverter over 10 acre-feet or more shall install and maintain a device or employ a method capable of measuring direct diversion, rate of collection to storage, rate of withdrawal, release from storage. In addition, that language is also found in the existing regulation.
Mm-hmm. Okay. All right. Well, thank you for the indulgence here. I think this conversation was good, especially marrying up the annual. So I'll vote in favor. Thank you.
Appreciate those clarifications and the discussion, Vice Chair. Much appreciated. Tyler, I think we're prepared for roll call vote.
Board Member McGuire?
Aye.
Board Member Firestone?
Aye.
Vice Chair Diadamo?
Aye.
And Chair Esquivel?
Aye.
Thank you.
Thank you as well. The regulation is adopted, and again, appreciate everyone's feedback, input, and look forward to implementation.
The resolution was adopted?
Resolution, yes. Yeah.
Excellent.
Yeah.
Thank you.
Thank you. And with that, let me quickly note, we're at about 11:30 nearly here. We have our intended use plan for the Clean Water State Revolving Fund. We also then have a copper Region 8 copper TMDL item. That item, obviously, at this point, we won't have until after lunch. I want to go ahead and move to the SRF item. We may have to take lunch somewhere in the middle, depending how long that goes. But let's go ahead and give ourselves, a 10-ish minute break really quick. Transition to intended use plan. And again, for folks that are here for the TMDL, That will be held till after lunch. So we'll be taking a lunch before the TMDL discussion. Let's go ahead and bring ourselves back here at 11:33, and we'll continue on to our next item. Thank you, everyone. All right, we're at 11:36. We can bring ourselves back. Appreciate the opportunity for a quick break. All right, everyone. We are now on item number 4 of our agenda, which is an item from the Division of Financial Assistance and presentation on this year's Clean Water State Revolving Fund Intended Use Plan. Many thanks. Good to see you.
Not on. Good morning. Good morning, Chair Esquivel, and good morning, members of the board. As Chair Esquivel had said, we're here today for the fiscal year 25-26 Clean Water SRF Intended Use Plan. My name is Lisa Hong. I oversee our Clean Water SRF, Drinking Water SRF, and our Water Recycling Funding Program. And with me today, we have Mike Downey, who is our Assistant Deputy Director, and our attorney, Matt Wilson. Next slide, please. We'll start the presentation today with some retrospective statistics looking backwards at fiscal year 24-25, and then we'll look forward towards fiscal year 25-26 at the funding availability as well as the application demand that's in-house. The meat of the presentation today will focus on public comments that we have received for the draft IUP, as well as what they mean for proposals for various programs. Next slide, please. So starting with the retrospective, I believe it was at the Drinking Water IUP workshop, the board asked us to take a look at performance metrics and give you an update. So the more detailed metrics do take some time to go through data cleanup and data analysis, but we do have some overall stats to share with you today. For the funding sources that run through the IUP, last year we executed 49 new funding agreements, totaling over $1 billion. We have also done 92 amendments, so those are projects that have received agreements in the past and are under planning or construction. The amendments can be for various reasons. One of them can be for funding increase, and we did about $90 million in funding increase amendments last year. You can see a more detailed breakdown by programs on this slide. It's not the most intuitive because we do co-fund between programs. So for example, a project can get water recycling grant and clean water SRF loan, but we try to break it down the best we can for all of you. And DFA as a whole is also working on some retrospective for fiscal year 24-25 in general, not just limited to the funding source in the IUP, but overall for all funding sources and all funding programs. And those information will be coming soon as well. In addition to the statistics that you're seeing here, there are also 172 projects that have a funding agreement that are under planning or under construction right now that our staff are also managing. And those 172 projects make up about $2.4 billion in funding that still remain to be dispersed. Next slide, please. Now looking forward towards the application demand we have in-house and the funding availability. Again, there's quite a bit of co-funding. Feel like these tables are never the most intuitive. The highlight here is that we have 140 applications in-house, some complete, some not complete, and requesting for $3.8 billion in total. This year, based on the various funding pots we anticipate to be available, we think we have the financial capacity to handle about $1.7 billion. That being said, what is not shown here is staffing constraints. There is 1.5 unit for small community wastewater in DFA, 1 unit for clean water SRF loan, 1 unit for water recycling, and 1 unit for stormwater. So if we're thinking about all the projects that are ongoing, have a financing agreement, trying to move towards construction, on top of all the new applications that we're working with, it is quite a bit of demand within DFA. also dependent on our applicant. We do depend on our applicant to submit application material that are needed for our eligibility review. We want to move all these projects as quickly as we can. So we do rely on our applicants to work with us and submit material timely and to answer questions timely if we have some clarifying questions as well. Next slide, please. New Prop 4 funding. So Prop 4 was passed last year. The actual appropriation is part of the annual state budget. The enacted 2025 state budget doesn't include Prop 4 appropriations. Instead, the administration is working with the legislature, hoping to come up with a comprehensive Prop 4 expenditure plan later this summer. What does that mean for DFA? Well, we do need to adopt an IUP to kickstart the new fiscal year. And also the IUP is part of our application to our federal grant to US EPA. So in the IUP, we did include anticipated Prop 4 amounts based on May revised budget we had previously, assuming that we will get the full authorization and full appropriation as previously proposed. And if that does not happen, we will likely see the biggest impact to water recycling projects. And we'll talk about what these impacts look like in a later slide. Next slide, please. This slide shows the Clean Water IUP milestones. And a lot of those are actually federal milestones or more along the lines of federal budget, more so than state budget. And the IUP has both. It has both the federal budget, federal allotments, as well as the state budget and state appropriations. So for the federal Clean Water SRF allotments, EPA released the allotment in mid-May, and we released a draft IUP for public comments at the end of May, which incorporates both the official federal allotment as well as the May revised part of the state budget. Shortly after, State Board submitted our grant award application to US EPA for our Clean Water SRF award this year. And about a week later, the board held a public workshop to hear public comments, followed by a deadline to submit written comments at the end of June. After considering written and oral comments, we are bringing the IUP back to you today for your consideration of adoption. Once the IUP is adopted, the final IUP will be submitted to US EPA, and typically the award timeline is about mid-August through late September. Next slide, please. This slide shows the public comments that we have received on the Clean Water IUP. So thank you to everyone who has submitted public comments and continuing to engage with us. I'm going to quote my boss, Mike, here. Mike always says that there are some states where no one shows up to their IUP meetings, and we're very, very fortunate to have so many entities who are interested in what we offer. So thank you for everyone's engagement. Next slide, please. Okay, from this slide on, we'll dive into the program proposals, the public comments we received, and what they mean for the proposal we're bringing to you today. Starting with the loan. Next slide. In the initial IUP that we put out, we proposed to add 11 new loan projects onto the fundable list, and I won't repeat all the reasoning, everything you heard at the workshop, but that was our proposal. And next slide, please. We received general support for the proposals through the public comments. We received one comment from CASA and water reuse asking for scenario E, which will add one more project for the town of Windsor onto the fundable list. We did look into it. Windsor has a complete application with us, and they could have made the fundable list under the new scoring criteria, which won't be effective until next year. So with that in mind, we feel comfortable with revising our proposal to add the town of Windsor. So next slide, please. So our revised proposal is scenario E, which will add 12 projects onto the fundable list for loans. Next slide, please. For water recycling funding programs. Next slide. This slide shows the anticipated water recycling funding available in the upcoming fiscal year. The highlight here is the big yellow bar in the middle, that is Prop 4 funds. So $150 million is anticipated to be appropriated through Prop 4 this fiscal year, and that make up the majority of water recycling funds we have available. Those are all construction grant funds, which is by far our most popular option. There is some construction loans available, but 90 to 95% of the water recycling applications we get are for that construction grant. So we're pretty heavily reliant on Prop 4 coming in this year for our water recycling program and all the projects that are on the fundable list for water recycling grant. Next slide, please. A refresher of the funding proposal. We are proposing a grant maximum of $15 million per project for construction grant, assuming that we get appropriation authority for Prop 4 as expected. For large scale projects, we are proposing $15 million max per phase. And some of you might remember that over the last few years, we've had a bit of budget back and forth, particularly with regards to general fund. So there were some projects that were impacted. They might have been on the fundable list at one point for $15 million max and had to decrease the grant maximum in the middle of the year due to funding being clawed back. So we are proposing that we essentially restore the projects that have had their funding being reduced before up to $15 million max. Next slide, please. From the public comments we received, a lot of general support for the proposals in the IUP. We received one comment from Metropolitan and LACSD asking for an increase of large-scale grant maximum to $30 million per phase and asking for some clarifications on planning and design eligibility. We currently do not have an application in-house, but we did reach out to Metropolitan and LACSD staff and had an initial meeting with them to understand their project and also to explain our current eligibility. We thought the best way to move forward is to work with them to get an application in-house, and then we can work with them through the eligibilities and further evaluation. The board can always make a different decision next year based on the applications that are in-house at that time. But at this time, we're not proposing any changes to the water recycling funding programs. Next slide, please. For small community wastewater, next slide. The proposal in the IUP is for small DACs either addressing a violation or septic to sewer projects are eligible for $50 million maximum in grant with some per connection limits depending on the project type. And for secondary priority projects, basically all other projects types eligible for 50% of the project cost up to $25 million. Again, there is a per connection limit here as well. And next slide. Based on the public comments that we have received, there is general support for the grant and principal forgiveness limits that are being proposed. We received one comment from Wheatland and Olivehurst requesting allocation of full $75 million in grant funding to a regional consolidation project. And the project is currently on the list for $75 million. From Community Water Center, we received a comment to prioritize funding for districts under receivership. And we believe that districts in receivership are likely in violation of some sort and would qualify under the compliance category, which is 100% grant for up to $50 million. for technical assistance, received a comment requesting for additional technical assistance funding, including funding from Clean Water SRF administrative allowance and 10% of Proposition 4 appropriations. So the Clean Water SRF administrative allowance, which is part of our federal award, is currently being used for state board staffing. And the 10% of Prop 4 wastewater is already being proposed to be used for technical assistance this year. So that is in the intended use plan. I believe our small community wastewater staff also did some additional outreach with folks who submitted comments to provide some of these clarifications. There was also a comment for additional tracking and dashboard, and we'll continue to engage with our stakeholders outside of this IUP decision. So do want to speak for our small community wastewater staff. The staff who are doing the tracking dashboard are also the same staff who are processing the applications. So if we ever ask to pare down a request, it's not because we don't want to provide great customer service. It's not because we don't want to be transparent. It's because we also want to focus on moving the money and getting applications funded, which is ultimately what we think our applicants want too. Next slide, please. And lastly, for stormwater and emerging contaminants. Next slide. The IUP proposes to allot $20 million to stormwater from Clean Water SRF principal forgiveness. The comment we receive is generally in support and suggesting issuing a call for stormwater concept proposals and a more tailored application process for stormwater projects. I know our stormwater unit is gearing up for a separate solicitation process for Prop 4 stormwater funds that will be administered separately from the IUP. And that separate process will allow for more tailoring, allow for more targeted outreach. Next slide, please. Lastly, for emerging contaminant, proposing to transfer this year's emerging contaminant allotment, which is $15 million, to drinking water SRF based on our existing demand. We have received one comment recommending retaining those funds within Clean Water SRF. However, all the project demands are currently shown on the drinking water SRF side, and we do need to show demand in order to apply for our federal capitalization grant. However, we did also check with US EPA, and it is administratively possible to transfer the funds back to Clean Water SRF if projects do materialize down the line. So this year, we're continuing with our proposal of transferring the EC funds to Drinking Water SRF. But if there is a project down the line that could be eligible for Clean Water SRF, I want to apply through that route, we can always work with US EPA and transfer remaining funds back. Next slide, please. And that concludes the presentation for today. Hopefully not too long, just in time for lunch. And we'll take any questions and comments.
Just long enough, and really appreciative, truly, of just all the receptiveness and engagement that's continued to go on. I know, as we've stated, it's a complex funding landscape right now, given where the feds are, this kind of limbo on Prop 4 bond dollars with the legislature. And so just appreciate all the work that's gone on to create as much contingency as possible to get as much money as we can out to benefit Californians and communities through the Clean Water SRF and these sundry pots that we have. So just hats off. It's very balanced, and appreciate, on the Clean Water SRF and emerging contaminants pot, the transfer over to the Division of Drinking Water. Glad that we were able to connect with US EPA staff. I was a little concerned in case there are projects out there, knowing that, we have wastewater facilities obviously also managing and trying to address PFAS in their flows and effluent. Concerned that, there may be projects that don't necessarily get funded if we do this transfer. So glad to hear that if folks have projects out there, have, emerging contaminant thoughts around their clean water facilities, get applications in. there is opportunity there. But again, we're trying to maximize the dollars we're receiving, and so appreciate and think that the transfer is definitely worthwhile. Looking to fellow board colleagues if they have questions or comments off the bat. We have about 12 commenters, and we can start to get to those if none. Okay. First, I'd like to call up Eric Oriana, be followed by Sarah Schaefer, and then Michael Casey.
Thank you,
Mr.
Chairman.
Oriana, good to see you.
Likewise, Chairman and board members, thank you for the opportunity to share comments in response to the Clean Water SRF intended use plan. And I want to just appreciate the work that staff has done to engage stakeholders in the discussion and the development of this plan. I wanted to start off my comments by expressing appreciation to the board for their work to increase maximum grant and principal forgiveness amounts for small communities, which is critical for making investment in communities that have not been invested in the past, primarily types of projects that will be eligible or be able to take leverage these types of funds are septic to sewer projects. I also wanted to uplift the work that the board and the state has been doing to develop the wastewater needs assessment, and wanted to highlight a number of takeaways from a recent report of the wastewater needs assessment. And one of the things that I found really intriguing from the wastewater needs assessment was, or at least phase 1B of the needs assessment, was that 67% of respondents identified septic system maintenance as one of the most significant issues that they're facing. And they also recognize, the respondents mentioned that about 22% of the respondents expressed a need for support with technical assistance for projects. And, I get one last, I think, takeaway was that it indicates that sanitation issues primarily exist in disadvantaged communities, which is, I think, something we probably all have a conception of, but just good to see that outlined in the report. So a lot of great work that's been there, and I think it highlights and complements the work that the state has done to invest in septic to sewer projects across the state of California. In discussions with the Division of Financial Assistance, I've learned that the state has invested more than $200 million in recent years, and that's thanks to the prioritization of the board for these types of projects. And still, there is a great need to have more septic to sewer projects across the state of California. We know in our work that many rural communities and mobile home parks live with septic tanks and inadequate sanitation. And many of these communities have to live in these areas that are further away from the city because they can't afford other housing alternatives. So it's a matter of affordability. It's a matter of prioritizing low-income communities. And we recognize that the board has recognized how important and how related it is to equity by prioritizing these septic to sewer projects. So commend the board and appreciate the work that's been done there. And one of the recommendations that Community Water Center and our partners identified in our letter was asking the board to continue to fund technical assistance for septic to sewer communities. We're asking the board to make it an option to use the administrative set aside for technical assistance before adopting this plan. And I think just to substantiate that recommendation, recognize that wastewater technical assistance is very minimal when compared to the investment into technical assistance on the drinking water side. And the board has an opportunity right now to increase this year's technical assistance allocation by nearly 30% by using the administrative set aside. And, we're not, we recognize that the board is committing to the 10% allowed by Prop 4 for TA. But, and we appreciate that and also recognize that that's not enough to meet the technical assistance needs across the state. And so as a drinking water technical assistance provider, Community Water Center engages domestic well communities. And one of the first things that we hear from these communities is how can they connect to sanitation services. It's one of the most pressing needs for households, farm working communities across the Central Valley and in rural communities. It's just the one thing that is always at the top of their mind. And so the board can meet the needs of these communities today by using the administrative set aside for technical assistance. I think one of the things that was mentioned in the presentation is that the board is using the admin set aside to cover its staff costs, and we recognize the real value that the staff provide to applicants and the state of California by supporting the work that the SRF program does. But we're not asking you not to fund staff. We're just asking you to replace those funds with a different through a different way. And so it would just be doing some administrative moving around. We could use a TA from the administrative side aside, and what would happen was the staffing costs would be funded through interest accrued by the loan servicing of the program, and recognize that it would be a minimal impact to the Clean Water SRF loan capacity, given just how big and larger the loan capacity is of the Clean Water SRF program compared to the Drinking Water SRF program. And so in closing, would recommend that before you adopt this plan, that you make it an option that staff pursue this opportunity to fund technical assistance, particularly for septic to sewer projects, by expanding the administrative set aside for that purpose. And just make that an option today. And if it's not possible within this next year, that you use your it for your original purposes. But I would just caution you to not close that door to those communities that really need this technical assistance. With that, I'll thank you for the opportunity to comment and hope to see this change. Thank you.
Thank you, Mr. Oriana. Appreciate your continued engagement and advocacy, certainly in all of this. I think at this point, I'm comfortable. Obviously, the set aside is being used for staff resources right now. There is no, I think, easy available alternative when it comes to funding those staff. I don't think at this point we're able to, and I don't know, I'd look to Mr. Downey to clarify for me, but I don't think we're able to simply, shave off interest from existing loans to pay for staff currently. I don't know if that is an option, but it's something certainly I'd be interested in talking about further over the course of the next year, just to better understand, the opportunity. The unfortunate thing is that it's all the same pie, whether and not how you kind of divvy it up, but understand and hear. Certainly, the board understands the need to ensure that we have appropriate technical assistance in communities so that they have projects that are shovel-ready that they can come to the program. But I think at this juncture, I'm not supportive of making a change for this year, but certainly open to discussing it further. And Mr. Downey, I don't know if you have any notes on our current limitations on how easy it is to find replacement funding for those staff.
Sure, yeah. Thanks for the question, Board Member Esquivel. So it is correct that we use, it's a little different terminology, but we have an allowance from our federal capitalization grants on Clean Water SRF that can be used for admin. And there's 2% that can be used for technical assistance. And like Mr. Oriana said, we're using that technical assistance is being provided by State Water Board staff as project managers and staff getting these applications complete, and also providing disbursements and funding agreements. So what we also do is we charge a fee in lieu of interest on our loans, and that fee can be used for administrative purposes. So at the moment, that's per California Water Code, the only way we can charge fees. And so if we wanted to increase the amount of admin we have, we are changing out limited to 1%, I believe. Doesn't have an impact on the recipients, but we're converting their repayment interest into that fee. So it's also not an immediate, we can go out and charge fees and have a new pot of funding this year. This is a long-term approach, and that we've managed the program accordingly. Another thing that we are thinking about right now is the administration's proposal or direction to eliminate the SRF programs. The SRF programs do need to operate in perpetuity, And so we are required to find a way to come up with that administrative revenue to continue operating the program in perpetuity. So that is something we're grappling with as well. And so, as we continue to get clarity on what the next federal fiscal budget year may look like and beyond, we are not concerned, but wanting to make sure we have the appropriate flexibilities and tools to be able to commit to operating the SRF program. And so part of that is making sure we're able to build up that administrative capacity. And we'll admit that it's a bit limiting in our options to do that at the moment.
Really appreciate that response. And again, Mr. Rodian, I appreciate the suggestion and concern. And I think, as Mr. Downey said, it's also part of a larger discussion that we are going to need to continue to have here around the SRF programs generally and how we maximize funding out of it. So much appreciation. Again, appreciate the comments, Mr. Ordeana. Yes, Board Member Firestone.
Just to follow up on that, thanks, because as the chair has already said, it's critical that we invest in technical assistance. We've seen how important that is on the drinking water side with the wastewater needs assessment. We don't need to wait for that project to be entirely finished. But I think we already know that there's a huge need, and there's already communities identified that need support. And so I fully support that we need to continue to fund our staff program. We need to get this money out the door effectively, and there's a big list of projects that are ready to go, and we need to get that money out to them as well. So can you just, I guess, so I think this will be something I'd really like us to continue to dig into and come up with some proposals next year, or even within this year, depending on, things change. We don't know outcomes of different things. And so, hopefully Prop 4 will help with some infusion there, and hopefully things don't go wrong at the federal level. But I do think there's creative thinking needed to figure out how we can, balance these needs of continuing to invest in developing projects through technical assistance so that when funds are there, those communities can get it, and also getting money out the door for communities that are already there. And we haven't figured that out as well yet. We have different tools on the clean water side than we do on the drinking water side. Certainly, I think we need more tools on the clean water side than we have today. But I think, as you said, there's some unique tools with the fee in lieu of interest and the small community wastewater grant program that is different than the drinking water side. So I just encourage us to dig into that, and maybe we can circle back, certainly with the technical assistance providers and different groups that have been raising this, and see if we can come up with something that could work for not to delay adoption of this year.
Thank you, Board Member Firestone. Much appreciation and agree. Okay, next I'd like to call up Sarah Schaefer, be followed by Michael Casey, then Isaiah Williams, and Jeff Conti. Thank you. Good afternoon.
Hi, my name is Sarah Schaefer. I've met some of you before. Thank you for allowing me to come and speak on behalf of Quartz Valley Tribe. I'm the environmental director for the Quartz Valley Indian Reservation. Today I'm here with members of the Business Council. And we want to thank the board for considering funding the Scott River Headwaters project through the Clean Water State Revolving Fund. QVIR has stewarded this land since time immemorial, and in recent years has combined cultural and scientific expertise to lead restoration and monitoring efforts across Scott Valley, including on this very property. Following the acquisition, we will develop a forest management plan and non-point source management program to guide restoration, forest stewardship, and salmonid recovery. Our strategies include widening riparian buffers, improving or decommissioning roads, restoring meadows for water storage, and enhancing in-stream habitat. Under tribal ownership, QVIR will return the land to more natural forest patterns, including longer rotations between harvest, increased species diversity, which will strengthen the forest resistance to fire, disease, erosion, all while perfecting cultural values. QVIR is a fix the world tribe, and this acquisition would enable the tribe to be able to do that. The project will improve water quality and security for our tribe and neighboring communities by reducing sedimentation, nutrient pollution, and bacterial contamination from activities that are currently ongoing, like trespass grazing. We can protect these water sources. The project will bolster QVIR's recent investments in developing a new community water delivery system, replacing aging individual wells with centralized reliable infrastructure. To meet the landowner's tight timeline, QVIR has applied for funding with the intention of repaying it through revenue from a pre-existing carbon project on the property, which we will assume upon acquisition. While this is a promising pathway, we respectfully ask the board to consider granting a meaningful loan forgiveness. Doing so would reduce our financial risk and allow us to dedicate more capacity and resources to restoration, stewardship, and community benefits that this project is designed to deliver. Our management goals include improving water quality for drinking and habitat, supporting ecological forestry and sustainable forestry for fire resilience, cultural and protecting cultural and tribal beneficial uses and community access and use, increasing ecological diversity and resilience, reducing sedimentation through improved road systems and riparian buffers, enhancing stream and meadow restoration, water quality monitoring, and salmonid surveys. And of all these activities, they're currently being enacted right now, actually. Managing trespass grazing that has caused erosion and E. coli contamination affecting local communities' water sources, including Quartz Valley tribal members. The project advances numerous state, tribal, and federal strategies to restore water quality, salmon populations, and watershed resilience. These include, but are not limited to, the California 2020 through 2025 non-point source program implementation plan, Scott River sediment and temperature TMDL, which we are actually monitoring that. We have that contract. Implementation action plans and final North Coast Water Quality Basin Plan, as well as NOAA's final recovery plan for the Southern Oregon, Northern California Coast Evolutionary Significant Unit of coho salmon, California Department of Fish and Wildlife Salmon Recovery Strategy, the State of California's Salmon Strategy for a Hotter, Drier Future. It also supports QVIR's own environmental and water plans, including the Water Quality Control Plan, the Wetland Program Plan, the Drought Contingency Plan, and the Water Quality Monitoring Strategy. Our work advances not just QVIR's environmental vision, but California's broader commitments to salmon recovery, forest resilience, and equitable watershed management. QVIR has the experience, staff, and capacity to manage and restore this landscape. Our environmental department has a very comprehensive water quality and quantity monitoring strategy throughout Scott Valley Basin as it stands. We have a fire department with engines, trained staff, full equipment. We have a basin-wide water quality monitoring program that will expand to cover newly acquired lands. And in fact, our water quality data is already contributing to the California's 2026 integrated report. I can also say that we just received our certificate for treatment as similar as the state, and we have developed our own water quality standards that we will be able to use resolutions to support our standards. This is a rare opportunity to protect sacred lands, restore ecological health, and safeguard clean water. QVIR are prepared and committed to lead. Thank you for consideration of this project. This is huge for the tribe, huge for the tribe. Thank you.
It really is, and thank you for your advocacy and leadership, Ms. Schaefer, and for all the work that the Quartz Valley Indian Reservation is doing in the community. It's really seen and appreciated, so thank you. Next, I'd like to call up Michael Casey, be followed by Isaiah Williams, Jeff Conti, and then Jared Voskel.
Ayuki. Hello, my name is Michael Casey. I serve on Quartz Valley Indian Reservation's Tribal Council. I come to you in a good way. It's my honor and privilege to stand here before you guys today to thank the board for considering funding the Scott River Headwaters project via the Clean Water State Revolving Fund. These lands are sacred to our people. They hold stories, responsibilities, and life ways that cannot be replaced. Our people have maintained an unbroken relationship with these landscapes since the time immemorial. With support from the Clean Water State Revolving Fund, this project provides an opportunity to return stewardship to our tribe and ensure that the land is managed with our cultural ways for benefit of watershed health, wildlife, climate resilience, and the broader community. By assuming stewardship of the property, the Quartz Valley Indian Reservation will once again be able to care for the land and water in our cultural landscape at a scale that can make meaningful difference for our tribe and surrounding local communities on issues like regional water security, wildfire risk, salmon recovery, and habitat restoration. The Quartz Valley Indian Reservation has long protected and enhanced the forest, water, salmon streams, and habitat in our ancestral homelands. With decades of extractive logging and recent wildfire damage, this land needs restoration, rooted in indigenous knowledge and science. Our team is prepared and experienced, and we are ready. The project will allow us to protect and enhance water sources for our tribe, fish and wildlife, and other downstream communities. The creeks on this land once supported thriving salmon runs that fed our families and sustained our culture. Those salmon are in crisis. With this acquisition, we can reverse the trend by addressing the root causes of habitat degradation and implementing a culturally informed, science-based recovery plan. This work will also reinforce the border effects of the Klamath Basin tribes to begin salmon home by bringing salmon home by protecting and restoring tributaries of statewide significance. It's impossible to fully put into words what it would mean to our tribe to acquire these lands and waters. I've always been told, heal the water, water heals the land heals the people, and our people are in desperate need of healing. We are not only tied to these lands by our ancestors, but also spiritually. To reacquire this land, nearly 40,000 acres of ancestral homeland, would be transformative. It would strengthen the sovereignty, vitality, and self-determination of the Quartz Valley Indian Reservation. It would allow our people to protect tribal beneficial uses, expand access to cultural practices, and create new opportunities for education, jobs, and well-being. This land would once again be a place of gathering, teaching, and future-making for tribal members. This funding is likely the only path forward for our tribe to reacquire this land, given the purchase price and timing. Quartz Valley Indian Reservation is very grateful to the board for acquiring funding or considering funding our tribe and helping us fulfill our vision of acquiring and stewarding these lands and waters. We encourage you to issue a meaningful forgiveness of this fund. That support would allow the Quartz Valley Indian Reservation to dedicate more resources to long-term stewardship, restoration, and community benefits. So please partner with Quartz Valley Indian Reservation in this historic moment in time. Your decision will affect generations to come. Yotwa. Thank you again for your consideration.
Thank you, Councilmember Casey. Really appreciate you taking the time and traveling here to the board to address us this morning, and for the leadership and continued work of the tribe. Really, really appreciate it. Thank you.
Thank you.
Next, I'd like to call up Isaiah Williams, be followed by Jeff Conti, Jared Voskuhl, and then David Ken.
Good morning. Well, I guess afternoon now. You'll have to forgive me. I'm pretty tired. We drove down here from the top of California. Ayuki, my name is Isaiah Williams. I serve on the Quartz Valley Indian Reservation's Tribal Council. I first want to thank you, the board, for considering the Scott River Headwaters project for a Clean Water State Revolving Fund loan. This project represents an unparalleled opportunity to further Quartz Valley's vision of acquiring cultural important lands within the tribe's ancestral territory. The project will protect and enhance nearly 40,000 acres of ecologically and culturally significant watersheds, wetlands, and resilient landscapes benefiting the tribe, fish, wildlife, and local communities. By assuming stewardship of this property, the Quartz Valley Indian Reservation will be able to care for the land and water in the tribe's cultural landscape at a scale that can make a difference for the tribe and surrounding local communities. Acquiring these vital ancestral lands and waters adjacent to the tribe's reservation will strengthen and reinforce the tribe's self-determination, sovereignty, and cultural resilience. After the project is completed in the fall of 2026, the Quartz Valley Indian Reservation stewardship of the property will result in many important outcomes, including enhanced salmon habitat and populations, improved water quality, sustained biodiversity, protected streams and watersheds, increased community fire resilience, expanded cultural and educational programs and tribal beneficial uses, creations of jobs and economic opportunities for the Quartz Valley Indian Reservation and local communities. The Quartz Valley Indian Reservation tribal ownership and stewardship of this property will allow for protection and expansion of tribal beneficial uses, including hunting, fishing, gathering, burning, as well as educational, environmental, cultural, career, recreational, and economic opportunities for the tribe. The Quartz Valley Indian Reservation is committed to this project. We are prepared to invest our time, our energy, to ensure the property is protected, restored, and cared for in perpetuity. We respectfully request that the board consider funding this project with a meaningful loan forgiveness to enable the tribe to dedicate further funds to support the stewardship and help to accomplish our shared water quality goals. Thank you for your time and your thoughtful consideration. Yotwa.
Thank you so much, Mr. Williams. I know it's a long trek from up north, and so truly appreciate you being here before the board and advocating for this project. And again, there's the leadership of the tribe. It means a lot, so thank you.
Thank you.
Next, I'd like to call up Jeff Conti, be followed by Jared Voskuhl, David Ken, and then Gina Dorrington.
Good afternoon. My name is Jeff Conti, North Coast Project Manager with Trust for Public Land. I'm here today with representatives from the Quartz Valley Indian Reservation to thank the board for considering funding the Scott River Headwaters project through the Clean Water State Revolving Fund. We respectfully request also that a meaningful part of this loan be granted as forgiveness. The Scott River Headwaters project represents a unique and powerful partnership between QVIR and the Trust for Public Land to acquire and protect nearly 40,000 acres along the western edge of the Scott River Valley, ancestral lands of the tribe that are ecologically vital and culturally irreplaceable. This land contains 10 salmon-bearing tributaries to the Scott River, a major tributary to the Klamath River, as you all know, and one of California's most important salmon streams. These tributaries identified as critical in CDFW's recovery strategy for California coho salmon. The property also supports over 270 miles of cold water streams and over 700 acres of wetlands, resources that supply drinking water for communities in the Scott Valley, including QVIR, Etna, Greenview, and others. Land protection and restoration are widely known to be among the most cost-effective ways to improve water quality. This project also directly advances California's salmon strategy for a hotter, drier future by safeguarding critical salmon habitat and protecting flows and water quality in a high-priority watershed. By preserving headwaters and cold water streams vital to coho salmon, this effort supports one of the strategy's core priorities, restoring and expanding habitat to sustain salmon recovery in the face of climate change. Trust for Public Land is proud to stand along the tribe in supporting their efforts to return stewardship of these lands to their rightful caretakers. Our role is to support QVIR's leadership in securing and restoring these lands using their knowledge and vision for healthy, thriving watersheds. This project also reflects the State Water Board's own commitments, as outlined in Resolution Number 2021-0050, to advance racial equity, environmental justice, and stronger government-to-government relationships with California Native American tribes. The resolution affirms the State Water Board's duty to improve engagement with tribes, recognize and protect tribal beneficial uses, and support projects that return stewardship of ancestral lands to Indigenous communities. Supporting this project would turn those commitments into tangible action. If this acquisition is successful, it will represent one of the largest single transaction tribal land return projects in California's history, an extraordinary opportunity to align clean water, salmon recovery, climate resilience, and Indigenous stewardship at scale. But time is short. The current landowner has provided QVIR with a limited window to complete the transaction. If the tribe is unable to act swiftly, this once-in-a-generation opportunity may be lost, and the land that will be sold to interests whose practices such as intensive timber harvesting and road construction, which historically caused sedimentation and temperature increases in the Scott River and led to its listing as an impaired stream under Section 303D of the Clean Water Act. This project represents nearly 8% of the entire Scott River watershed. The long-term benefits of tribal-led conservation and restoration on this scale are immense. We respectfully urge the board to approve the loan and provide meaningful forgiveness to the tribe's financial burden. Doing so would allow more resources to be directed toward long-term restoration, stewardship, and community benefit, and demonstrate the state's commitment to clean water, state-tribal relationships, and climate-smart conservation. Thank you for your leadership in advancing clean water, tribal partnerships, and resilient ecosystems. Grateful for your time and consideration.
Grateful for yours as well, Mr. Conti. Really appreciate the work that Trust for Public Lands has done to work with Quartz Valley to bring this to fruition here and provide an opportunity for potential support from the board. So much appreciation. Thank you also for traveling out. Thanks for the leadership.
Thank you very much.
Thank you. Yes, Board Member Firestone.
Thanks. Well, echo that. Thank you for the leadership and stewardship and for bringing forward this incredible project. I think it's really a model of the kinds of projects we would love to help be a partner in and invest in, vital for our state. And I'm interested in just if staff can just clarify what the process is, or if there's any barriers within the IUP for being able to consider principal forgiveness or some meaningful principal forgiveness for this kind of project. I don't know if you can speak I don't know that it's appropriate to talk about a specific project, but if it is, that's great. You can answer that, but otherwise, just more generally.
Yeah, probably more helpful to speak generally. But generally speaking, there's very few projects this unique. And as you know, we fund predominantly publicly owned treatment works projects. There's 11 eligibilities through the Clean Water SRF program, and almost all of the funding we provide is through that first eligibility. And so as we've talked with Quartz Valley Indian Reservation and Trust for Public Lands quite a bit, and more than maybe we normally would because of the uniqueness of the project. And so there are still, I guess to your question of eligibility and principal forgiveness, eligibility in general, I think is still an open question, and we're working to see how our own policies, whether the policy or the IUP documents, fit for this project. However, there's a general assumption that it would be eligible largely under the federal guidance from EPA. So whether we have exactly what we need in the existing policy in this IUP, that's not quite clear yet. I think the repayment method to secure a loan is also going to be a challenge. And so that's something else we're working through. So it's the type of project that could require further board action. And so, this might be something that we would need to come back to you for. And so that part's not clear. And so as far as is it currently eligible for principal forgiveness through the IUP, I would say also not super clean cut because of the uniqueness. So that's my non-answer for you today, but hopefully gives you some things to think about.
That's super helpful. And, I'll just say, I think this is a great example of how we need to continue to reflect and improve our programs to be able to accommodate, I think, really critical types of projects that advance our goals, but maybe don't necessarily fit into what the usual project is. So just really appreciate staff putting in the time to work with the tribe and partners and figuring out how we can either make it work with our existing, what we'll be adopting here today, or if needed, maybe I certainly would want to see us be able to consider any changes or approvals that we would need if needed beyond what we end up adopting today.
I'll add that we included it on the fundable list as a 100% loan because sometimes it gets misconstrued what we're promising on the fundable list in the IUP. However, those are all estimated amounts within the IUP. So that, that delineation in itself is not a limit to the principal forgiveness, but like I said, much more eligibility considerations that I think we're still working through.
Okay. Yeah. Great.
I could chime in. What we're asking the board to adopt today is the intended use plan, which includes the fundable list. The fundable list is what DFA is committing to prioritizing this year for eligibility review and for working with our applicants. It is not a funding commitment. It is not a clearance that's saying all eligibility review have been passed, whether it's wastewater projects or other special project types. So a funding agreement is DFA's commitment once we have done the eligibility review, which is not what we're asking you to adopt today.
Yeah. Thank you. Thanks for that clarification. And, again, I really appreciate that we're affirming the importance of staff continuing to work on that with the tribe. And I hope that we're able to figure out pathway forward here. It seems like a really innovative and critical project for our goals, shared goals. So thank you.
Agree, board member, and thank you. Appreciate those comments. All right, next I'd like to call up Jared Voskuhl, be followed by David Ken, and then Gina Dorrington.
Hi, good afternoon. Jared Voskuhl, Director of Regulatory Affairs for the California Association of Sanitation Agencies, or CASA. CASA represents over 140 agencies across California, and we are pleased to provide comment today on the adoption of the IUP. First, we just want to recognize the long morning here and for the staff for the great presentation that they provided summarizing all the funding and investment and financing they're putting out around the state. Really reiterates that DFA is the backbone for ensuring California's clean water future, and really appreciative of everyone on the team there, from Joe to Mike to Lisa to Matt and everyone else there who's, we only interact with indirectly. Want to thank the team for adding on Windsor, that scenario E, and getting them their funding. This is going to be a great project for that community and has water recycling implications, so really providing resiliency to the town. And with that, just close with the remarks to thank the team for all the work that's going on. And I know next year is going to be a different IUP with different scoring standards, and we're going to be monitoring and tracking that, but in the interim, working through the stakeholder advisory group processes to continue enhancing and helping the fund become even more mature. With that, I hope everyone has a great rest of their summer, and we'll see you in the fall. Thanks.
Much appreciation. Thank you for your continued contributions in all of this, Mr. Voskuhl, and continuing to herd our publicly owned wastewater treatment plants in this process. It's appreciated. So thank you. Next, I'd like to call up David Ken, be followed by Gina Dorrington, then Andy Carey.
Good afternoon, board members. Chair Esquivel, my name is David Keene with the City of Chico, and I'm here to support staff's recommendation to adopt the 25-26 SWRCB IUP. And the priorities listed in the IUP will benefit many communities across California, including the City of Chico. And so today I'm going to describe the nexus between those priorities and the City of Chico septic to sewer regionalization project. Next slide. The City of Chico is home to around 100,000 people located in Northern California within Butte County, home to the iconic Sierra Nevada Brewery, Chico State University, and the beautiful Bidwell Park, but also, like many communities around California, home to thousands of septic systems, which have led to groundwater contamination over the years and a prohibition order, which I'll discuss later. Next slide. Here's a Venn diagram summarizing the priorities of the intended use plan, addressing a violation, a disadvantaged community, and septic to sewer regionalization project. The City of Chico hits all those marks along with many communities. Next slide. So back to the prohibition order. Throughout the 1970s and 1980s, significant independent or individual septic systems caused groundwater contamination, which led to the prohibition order by the Central Valley Regional Water Quality Control Board, order number 90-126, which prohibits the installation of new septic systems within the Chico urban area. This had a significant impact on the community. And one of the main components of the prohibition is that if your septic system fails and you are within 250 feet of a public sewer system, you are required to connect. As you can imagine, that is a significant financial and administrative burden on residents. And while good intention, it does have consequences to the residents. So for reference, in Chico, we have approximately 29,000 parcels. Of that, approximately 7,600 are still not connected to the public sewer system. So about a quarter of the city is still not connected. So we've got a long ways to go, which is one of the reasons we're here today supporting the intended use plan. Next slide. So here's a snip from the disadvantaged community mapping tool by the state. These are the 5 communities in which the City of Chico is championing. One of the reasons I wanted to include this slide is because of how engaged these communities have been. From the beginning, from site visits to monthly meetings, helping us create the plan of study and helping us create the application materials to go for the grant. As you can see, they're located all within the disadvantaged communities. Next. So here's a summary of the project. There's 5 communities that we'll be submitting to include in this project. As you can see, there's one age-restricted community in there, a mobile home park, for a total of 480 homes, and this would remove 114 septic systems out of the ground and connecting those people to a public sewer system. Next slide. So back to the Venn diagram, addressing a violation. Chico has a prohibition order. If you want to do a new septic system, you're not allowed. If your septic system fails, you must connect. So they are addressing a violation and converting 114 septic systems to a public system, or to a public sewer system. This is a direct local investment. These communities are disadvantaged. So I talked about the financial hardship. As you can imagine, these may not be possible without grant funding. Some of these communities are age restricted, as I mentioned, on fixed incomes, and so supporting a project like this would be economically infeasible for them. And then lastly, septic to sewer regionalization. Getting these people off of a septic system and connected to a regional system not only benefits those communities directly, but it benefits all of Chico as a whole because we are a groundwater reliant city. So ensuring that we have less septic systems and more people connected to the community system is better. Next slide. And with that, I'd like to thank staff for a comprehensive and well-written IUP, and I'd like to thank the board for the opportunity to speak today. Thank you very much.
Thank you, Mr. Ken. Appreciate you addressing the board and the engagement on this and the advocacy for the community here. Much appreciated. Thank you. Good to see you. Next, I'd like to call up Gina Dorrington. She'll be followed by Andy Carey, then Bill Zanoni.
All right. Thank you, Chair Esquivel and members of the board. I am Gina Dorrington. I am the General Manager for Ventura Water, which is the City of Ventura's water and wastewater utility. Ventura is a coastal city between 2 rivers, the Ventura River and the Santa Clara River, where we are dependent solely on local climate-influenced water sources. Environmental stewardship has become a balance between efficiently using these water supplies and removing our wastewater discharge from the Santa Clara River estuary. Since the call for conservation, the city has achieved extraordinary reduction in demand, meeting our monthly average of over 28% in reduction since 2013. Yet still, we have a need to expand our water supply portfolio. For over 10 years now, the city of Ventura has been planning its Ventura Water Pure program that will meet the wastewater diversion requirements and provide the city up to 20% of water supply with new, resilient water utilizing indirect potable reuse. Funding from the State Revolving Fund is critical for projects such as the Ventura Water Pure program to provide multi-benefit solutions to water supply and reduction in discharges. We would like to thank your staff for their knowledgeable and helpful advice as we navigated through the application and submittal processes. And we'd like to thank the board for continuing consideration of funding these programs and for the opportunity for communities such as Ventura to keep these projects moving forward to completion. Time and money are extremely tight right now, and your support to continue to fund these programs is greatly appreciated.
Thank you so much, Ms. Dorrington. It's really good to see you, and I'm glad to see this project still here before us. I know there's been a lot of sometimes back and forth on eligibility and how the project might be able to move forward, and I know there's a lot of local circumstances that also drive projects, but just really appreciate your leadership and sticking through it and working with us here as well, and just appreciate the continued advocacy and your leadership across all of this. It's really appreciated. Thank you, Ms. Dorrington. Next, I'd like to call up Andy Carey, be followed by Bill Zanoni, and then Charmaine Rose.
Hi, this is Andy Carey. I'm president of Monolith Properties, and I represent 2 of the 5 communities in Chico that were mentioned previously. I'll be brief, just wanted to comment very positively, again, on behalf of over half of the homeowners that were represented in that budget slide I think you saw earlier. I just wanted to speak in support of the board's adoption of the proposed 2025 to 2026 IUP, and specifically the small community wastewater funding. We've worked for a really long time with a diverse group, multi-agency, private, public team on the application for the funding for the city. And it's been a great Herculean effort by a number of folks. Can't thank them all enough. And like was mentioned earlier, the communities represented there are very engaged, and we look forward to hopefully your adoption of the proposed budget. So thank you for hearing me out, and thanks to the team's great effort as well.
Thank you as well, Mr. Carey. Really appreciate your participation here. Next, I'd like to call up Bill Zanoni, be followed by Charmaine Rose, Bethel Hasso, and then our last commenter will be Robert Meading. Good to see you again, Mr. Zanoni.
And still city manager for City of Wheatland. I wanted to thank you for including our regional wastewater project in your 25-26 intended use plan. As I've indicated in past meetings, this project will result in a regional wastewater system in South Yuba County, which will connect and directly benefit 2 disadvantaged communities, that being Wheatland and Olivehurst. If the draft intended use plan is approved today, we hope to have a funding agreement executed within the next 3 to 4 months, and that is due significantly to the diligence and ongoing communication of your staff. I think specifically James Garcia, who is still here, or still in the audience, and Gabriel Berzamina. They have just been helpful walking us through this process. Our project today is ready to go to construction. We are finalizing our bid documents right now. Our goal is to have a functioning regional wastewater system operational by mid-2028. So we will definitely make good use of these funds if the IUP is approved, and I just want to thank you for your support of our project.
Thank you as well. Again, all these projects take an incredible amount of leadership at the local level to get through. And so appreciate the acknowledgement of our staff and our folks at DFA. I think as Mr. Voskuil said, truly these programs are just core to ensuring access to sanitation and drinking water on the drinking water side in the state, and very much a workhorse. And at a time when a lot of folks are very focused on affordability, these programs have been contributing to affordability mightily in communities and making generational investments. So just thank you, Mr. Zanoni. Next, I'd like to call up Charmaine Rose. I know you will speak as necessary, and then Bethel Hasso, and then Robert Meading.
Good afternoon, Chair and members of the board. I'm with Sacramento Area Sewer District, and I would like to start out by saying that we strongly support the Clean Water State Revolving Fund IUP for 2025-2026. Sac Sewer provides sewage collection, treatment, and resource recovery to a significant portion of the Sacramento region. We serve more than 1.6 million people every day, and the State Revolving Fund has been an exceptionally important program to clean water agencies throughout California in helping them implement critical infrastructure work. The SRF has supported Sac Sewer's essential upgrades to our treatment plant, enabled multiple septic to sewer conversion projects within our region, and most recently provided for a water recycling funding program grant supporting the landmark Harvest Water Recycled Water and Habitat program. All these projects further our mission to protect the environment and human health, while also supporting our local thriving agricultural communities and the economy of the greater Sacramento region. Sac Sewer appreciates the incredible work of the State Water Board staff and your board in balancing competing needs with limited funding each year. We support this year's proposed IUP, including the following specific elements. Restoring the Water Recycling Funding Program construction grant cap to $15 million, and implementing the large-scale water recycling element that was created with Prop 4. And we support comments provided by Water Reuse California, CASA, and Civiqua. And we thank you again for supporting this year's IUP, and thank you for all the staff work.
Thank you as well, Ms. Rose. Appreciate the support and engagement across all this, and just much appreciation. Next, Bethel Hasso. Good to see you. Good afternoon.
Good to see you too, Mr. Chair. Members, Beth Olasso on behalf of Water Reuse California. Thank you for powering through so we can get done before lunch. Very quickly on the IUP, as Mr. Voskuil stated, we really thank staff. We have such a great relationship to kind of work through these issues throughout the year, and so we can have great collaboration, and appreciate your support of those efforts. A couple things, really appreciate adding the town of Windsor. They are thrilled and send their thanks. It's a great project. And as I mentioned, when we had the workshop, they had just instituted a rate increase. So we think, it's a great partnership. They're doing their part. The state is able to come in and help with that. Second, on the emerging contaminants funding, our original letter had asked for that transfer to not happen. Our follow-up after further discussions kind of backed away from that, and we think there's this elegant solution that if we find some projects that could use it, we can transfer some funds back. So we appreciate that change and that acknowledgement. And if we get more EC money ever from the federal government, we'll work on getting some more projects in on the clean water side. Finally, on the water recycling funding program, I think the work we need to do on that right now is making sure we get the funding allocated from the legislature. We are hearing that there is, there's a lot to be done in the 3 long weeks, 4 short weeks that they are going to be back. So your support pushing the administration to make sure that those Prop 4 allocations actually happen. I don't think it's a done deal, just Prop 4 in general, not water recycling, but we really need some help on that. I'm going to be pushing on that. I already am in the building on that. So thank you. We love to get those projects out. We all know how important it is, and we look forward to the next round of IUP. Start the clock all over again. Thank you so much.
Haven't adopted this one yet, but I was going to make similar remarks. So just much appreciation on your leadership as well and engaging with the legislature. We're certainly prepared either way. And again, appreciate all the work that's gone into prepare us to maximize whatever we maybe get this year. So thanks for the advocacy. It means a lot, Ms. Solhasa. Next, I'd like to call up, and this is our final commenter, Robert Meeting, for this item at least.
I was wondering if that would be me. It's actually Robert McDonald.
Oh, yeah.
Must
For
have.
some reason, your last name is on here as Meeting. Apologies, Mr. McDonald. Good to see you or hear from you.
Let me turn on my video here. All right. Well, thank you for having me and for comments. I'm the general manager from Carpenter Valley Water District, and I want to express my appreciation for the board and staff's hard work on the 2025-26 IUP. CVWD supports the 25-26 Clean Water SRF IUP, including restoring the water recycling funding program construction cap to 15 million and providing additional funding for previously approved projects that had funding reductions. Grant funding for projects like the Carpenter Advanced Purification Project, a community project that will provide reliable water supply to Carpinteria for the next 50 years, depends on these grant funds. CVWD understands that there are financial constraints, but respectfully requests that the backfilling of reduced funds allowed in the IUP be prioritized as the funding is critical for the CAP project. Thank you.
Thank you, Mr. McDonald. I know it's been a long morning, so thanks for holding on and providing your comments here, and just appreciate your advocacy. Thank you. All right, that brings us to the end of our commenters. Just a tremendous amount of appreciation for folks at the Division of Financial Assistance and for all the applicants out there and others that continue to just help us refine and make sure we're maximizing these incredible and important resources for the state. So just huge nod of thanks to everybody. Looking, though, to fellow board colleagues, if they have any further comments and or questions, and if not, we may be prepared for a motion.
I'll move to adopt. Second.
Thank you both. Ms. Tyler, can you please call a roll call vote?
Chair, it's
please.
worth noting there's a change.
Oh,
Sorry,
there's a
with the change
Sorry.
sheet.
Thanks.
Sorry, thank you.
Thanks for helping there, Mr. Wilson.
Appreciate it. With the change sheet.
Okay.
Thank you. Board
All
Member
right.
Firestone,
Aye.
Vice Chair Diadamo,
Aye.
Board Member McGuire,
Aye.
and Chair Esquivel.
Aye.
Thank you.
Thank you all. The resolution with the change sheet is adopted, and now starts the clock for next year's intended use plan. Thank you all again for the work, and look forward to being able to get these dollars out in the next year. And again, thanks for the advocacy and support. All right, let's go ahead and give ourselves a late lunch here. Looking to fellow board colleagues, if we want to do 45 minutes or an hour. 45 sounds good. Then we'll reconvene here. We'll give ourselves 50. How's that? And we'll find ourselves here back at 1:45, and we will then be moving on to item number 5, which is the Santa Ana Regional Water Quality Control Board, Newport Bay Copper TMDL. That will be the final item for today's agenda after that, and we have a 2-day agenda. So we'll see everyone here in about 50 minutes at 1:45. Thanks, everyone. Much appreciation. All right, everyone, we're at 1:45. I hope everyone had a good lunch. And we're back here now on item number 5, which again is an item from our Santa Ana Regional Water Quality Control Board on Newport Bay Copper TMDL. I'll hand it over to folks to provide presentation. Good to see you all this afternoon.
Good afternoon. I hope everybody had a good lunch. My name's Terry Reeder. I'm with the Santa Ana Regional Water Quality Control Board. I'm a senior engineering geologist, and we're going to report on the copper TMDLs. We're here to ask for your approval of these TMDLs, and I'd like to begin. So I'm going to run you through, first of all, I want to talk about the impairment in Newport Bay. So our problem statement, Newport Bay does exceed the California Toxics Rule, chronic and acute criterion for copper. It's been impaired under the Clean Water Act and 303D list since 2006, and so TMDLs are required. The copper TMDLs were adopted by the Santa Ana Water Board on December 2nd, 2022, and so our proposed action is to ask for your approval of that resolution. Next slide. I'm just going to give you a brief overview of the presentation. We're going to talk about the context and background, give you a location map, talk about the beneficial uses for Upper and Lower Bay. We'll talk about other copper TMDLs in Southern California that have been adopted, give you a brief history on the regulatory background. Then we're going to talk about the technical basis, the actual impairment assessment, the numeric targets, sources and loads, marinas and moorings in Newport Bay, to give you an illustration of how those are spread out, mostly in lower Newport Bay with a little bit in the lower end of Upper Bay. We're talking about the implementation on our public process, the implementation and schedule, public outreach and public comment periods that have been conducted over the years, and the key issues that have been raised before the State Water Board during the comment period. And then again, we'll reiterate our staff recommendation. Next slide. So the Newport Bay, we have Upper Newport Bay, which is primarily an ecological reserve. Lower Newport Bay is also called Newport Harbor, is home to numerous marinas, private and commercial slips and moorings. While Upper Bay is 2/3 of it is the ecological reserve, the lower 1/3 consists of some private docks and residences and the Dunes Resort and Marina. The largest freshwater contributor to Newport Bay is San Diego Creek. That accounts for about 85% of the freshwater inputs to the bay. Next is the Santa Ana Delhi Channel, and then to the east is Big Canyon Wash. Next slide, please. So as I said, Upper Newport Bay is an ecological reserve. Beneficials are multiple. It includes biological habitats of special significance, estuarine habitats, wildlife, rare, threatened, and endangered species, spawning, marine ecosystems, commercial, shellfish harvesting, and Rec 1 contact and Rec 2 non-contact recreation. We have several rare, threatened, and endangered species or species of special concern within Upper Bay. It includes the California least tern, Ridgway's rail, formerly known as the light-footed clapper rail, the snowy plover, least Bell's vireo, and the California gnatcatcher. We also have one endangered aquatic plant species, the salt marsh birdsbeak, which is considered a critical species within the bay's estuarine habitat. Next slide. Lower Newport Bay, they have some of the similar beneficial use designations. They have one that we don't have for Upper Bay, which is navigation. As many of you may know, there's a major navigational channel that is periodically dredged and maintained by the U.S. Army Corps of Engineers, which helps improve the flow of water through the bay and allows some of the larger ships to be able to come into the bay. It's the largest pleasure boat harbor in the United States. It supports residential, commercial, and some light industrial uses, but its biggest draw is the plethora of recreational options such as dinner and night cruises, fishing, swimming, sailing, paddleboarding for people that are living in or visiting Lower Newport Bay. So it's a quite popular recreation area. Next slide, please. So I want to address some of the statewide efforts in Southern California in adopting copper TMDLs. The first one to be adopted was the San Diego region, adopted a dissolved copper and Shelter Island TMDL in 2005. Also in 2005, the LA Regional Board adopted a TMDL for sediment copper, as well as other toxic constituents from Marina Del Rey Harbor. In 2014, LA also added dissolved copper in Marina Del Rey. And then 2022, we adopted copper TMDLs for Newport Beach. In all of these cases, the major source of copper has been found to be copper anti-fouling paints on recreational and small commercial boats. Next slide, please. So how did we get to our TMDLs for copper? In 1997, there was a consent decree brought by the National Resource Defense Council and Defend the Bay that ultimately required US EPA to develop technical TMDLs. Those were developed in 2002. EPA identified copper impairment in both upper and lower Newport Bay, but technical TMDLs do not include an implementation plan, and they also had several recommendations for additional monitoring and studies that they felt needed to be conducted to really fully get on board with a really good impairment assessment for copper. California Department of Pesticide Regulation, or CDPR, guidance for copper on paints, that was Assembly Bill 425. There was a memorandum issued on January 30th, 2014, and it became effective on July 1st, 2018. It resulted in a maximum leach rate of 9.5 micrograms per centimeter squared per day. This, however, assumed compliance at marinas with less than 1,270 boats. Newport Bay has about 500 boat slips that are occupied at any one point in time. And they also recommended a series of management measures that are actually part of the lower leach rate recommendation. And that requires things such as BMPs during hull cleaning, less frequent BMPs, diver and boater education, diver certification, and the potential use of non-copper paints. Next slide, please. So staff took the information from EPA, conducted several studies, site-specific studies within Newport Bay over multiple years, and developed their own impairment assessment. They confirmed that dissolved copper concentrations exceed the CTR criteria in both upper and lower bay, both acute and chronic, with the measured dissolved copper range of anywhere from less than 1. And we're talking about certain areas in upper Newport Bay and obviously in the Newport Bay channel entrance where you get the tidal inflow, so you're getting diluent effects, up to 11 micrograms per liter. The sediment lower bay copper levels exceeded the NOAA's effects range median guidelines of 270 micrograms per liter, but there were no exceedances of copper tissue and muscle or fish tissue guidelines for human or wildlife health. Just as an aside to that, additional data was collected by the City of Newport Beach and the Department of Pesticide Regulation in 2019 and in 2023. These also indicate water column impairment for dissolved copper in Newport Bay. And DPR's monitoring report said there was an increase in dissolved copper concentrations from 2019 to 2013 in Newport Bay. Next slide, please. So the numeric and narrative targets for copper TMDLs include the CTR criteria, as we mentioned previously, a sediment copper criterion based on NOAA's 2008 effects range low sediment guideline, which is 34. This is what EPA recommends versus using the higher effects range median concentration. But we've also added an alternative sediment quality objective that's based on the biological condition, and that biological condition is the target of unimpacted or likely unimpacted. Next slide, please. So as I mentioned previously, primary source of copper is copper-based anti-fouling paints. We have an estimated annual load of 18,000 pounds per year. That's 81% of the total inputs to copper. Other sources include tributary runoff, and that's about 3,000 pounds per year in a wet year. Storm drain runoff, about 300 pounds per year, and atmospheric deposition of 100 pounds per year. Next slide. So what are the reductions that we need to meet the TMDLs? Currently, the tributary and storm drain runoff are meeting the waste load allocations. So the largest remaining source of copper is recreational and small commercial vessels that are less than 79 feet in length. So we have a phased schedule. We're asking for a 20% reduction in 4 years, a 40% in 8 years, and a 60% reduction in 12 years, with 12 years being the entire implementation schedule period and compliance period. As usual, we want compliance as soon as possible, but they have 12 years within the effective date, which is when EPA approves these TMDLs. However, we have a caveat that if the TMDLs are considered to be achieved, if we reach the CTR criterion, or if site-specific objectives are adopted instead, if those are met before the waste load allocation reductions are met, then they're considered to be achieving the TMDLs, because that's really what's important. Next slide, please. This is just an illustration of both. So PCH, which you can see there in the center, the Pacific Coast Highway, Highway 1, is the dividing line between Upper Bay and Lower Bay. So Upper Newport Bay Ecological Reserve kind of starts at the upper end, the north end there. And all the white areas are marinas or moorings that are in Newport Bay. Most of these are within the jurisdiction of the city of Newport Beach. There are some private HOAs and some private docks and moorings in the area. As I said, there are about 5,000 boat slips or moorings occupied at any time within the bay. Next slide, please. So what are our recommended strategies? We're basically taking those management measures that DPR recommends and using them as recommended implementation strategies in these TMDLs. So that includes boater and boatyard education programs, promoting alternatives such as boat lifts, boat floats, slip liners, trailering, or dry docking to keep the boats out of the water so they're not in the water all the time leaching copper. Diver training and certification programs to ensure that proper use of best management practices. We want to implement BMPs for hull cleaning, including soft cleaning tools and/or filter systems to possibly capture debris. There have been some attempts at finding other ways to prevent all of the particulates from getting into the bay that carry copper, both dissolved and particulate copper with them. And to offer incentives to adopt and implement BMPs and/or possibly the use of non-biocide paints if necessary. Next slide, please. One of the methods that are being used in Huntington Harbor are floating dry docks. These keep your boat dry and clean out of the water. These devices are different than boat lifts as they operate without physically lifting the boat out of the water. There are also some new inflatable versions on the market that use a pump to remove the water from the slip once it's been inflated so that the boat stays dry. Typical dry dock systems, such as the one shown in the photos, can cost anywhere from $5,000 up to $30,000, depending on the size of the boat. In Newport Harbor, of course, permits are required, but there are also restrictions on their use. The location restrictions are that floating dry docks are generally only allowed in waters bayward of commercial, manufacturing, or unclassified zones and are not allowed bayward of residential areas. Next slide, please. There have been a lot of questions raised about the lower leach rate copper AFPs that are currently in use within the bay and non-biocide AFPs. Now, the TMDLs do not require the use of non-biocide anti-fouling paints. But there are a few that are being currently used in Newport Bay shipyards. We talked to 4 different shipyards that do boat painting within Newport Bay. South Coast Shipyard also uses non-biocide paints for the LA Harbor for use in the Marina Del Rey area. And then there's another one, Basin Marine, who has a tugboat that's painted with a non-biocide paint. But in general, they're not in high use in Southern California. I did talk to some paint manufacturing representatives. They've said that they have had some success in conversions with non-biocide paints in New Jersey and in Florida. But a lot of these paints have not been tested extensively in Southern California waters. There have been a fair amount of conversions done in the UK, other areas of Europe, but you're usually talking about colder waters, and the warmer the water, usually the more biofouling. So there's really a need for these tests to be done. There, however, was a recent Washington State review of non-biocide paints. This happened in 2024. It's outside of the administrative record, but we expect it potentially to be brought up in comments. I was made aware of this by the LA Regional Board who notified me of this. Basically, it's the same thing they said in 2019. The non-biocidal paints have not reached the technological maturity and need for more further development, especially for recreational boats. However, this report to the legislature quotes a technical study that we're not in agreement with. It's not been peer reviewed. It's not gone through any process, so it's not really guidance that we feel is applicable to anyone to use. It's simply a report and the opinion of their staff to the legislature. So while we appreciate the efforts that Washington has made, that doesn't mean that their guidance would be applicable to Southern California. The lower leach rate copper AFPs have contributed to reductions in dissolved copper in the Shelter Island Yacht Basin, which we'll talk about more. And as I said, the TMDLs don't require the use of these non-biocide paints. They're only one of several potential implementation strategies, and the 12-year compliance schedule allows dischargers to evaluate the use or effectiveness of alternatives to copper AFPs. All right, next slide, please. So what are our potential regulatory and compliance tools? For the regional board, we would more likely adopt waste discharge requirements or conditional waivers of waste discharge requirements. And these would apply to the city of Newport Beach and the county, who are state land grantees for the submerged lands and tide lands, which we'll discuss shortly, and for marina owners and operators, and potentially any even individual boat owners. For the ports and harbors, the in-water hull cleaning ordinance has been adopted by the Port of San Diego. They implemented the use of the Department of Pesticide regulations, recommended management strategies. It was through the Port of San Diego's ordinance number 1035, adopted in 2021. LA County, Marina Del Rey also adopted an ordinance in 2018, that's 2018-0021. The Port of San Diego charges a permit fee of $250 a year. They also take enforcement actions as needed to ensure that in-water hull cleaning is being conducted properly and appropriately. For Marina Del Rey, they have enforcement by the LA Department of Beaches and Harbors, an up to $250 fine for 2 violations, and more than 2 violations are considered a misdemeanor. Next slide, please. So the implementation strategy and schedule includes a suite of recommended implementation actions. It empowers the dischargers to design site-specific implementation plans. It supports flexibility through multiple compliance pathways, establishes a phased timeline for reducing copper discharges from boats, and also provides time to evaluate whether site-specific water quality objectives, such as using the water effects ratio or an alternative method, are appropriate for these water bodies. Next slide. So we wanted to go over some of the public engagement and outreach activities. We held back in 2015, when we started trying to get these TMDLs to our board, we had 2 sequoscoping meetings on July 2015. We held workshops, regional board workshop on October 2016 and September 2021. On May 9th and 10th in 2019, we had public workshops held in Newport Beach. We had 3 technical work group meetings that were held in the fall of 2021, and we also performed tribal coordination under AB 52. For the State Water Board, there was additional public outreach required because AB 2108 was adopted in January of 2023. We conducted that and outreach by also reaching out to tribes, but also reaching out to disadvantaged communities and having documents translated into the 2 major languages, which was traditional Chinese, or Mandarin, and Spanish. Then there were public comment period occurred from June 29th to August 30th, 2021. And the State Water Board public comment period was June 16th to July 17th, 2023. We're finally able to bring these to you after we have, I think, hopefully dotted our I's, crossed our T's, and checked all the boxes. Next slide, please. One of the comments raised was jurisdictional concerns were raised before the water boards during the state water board public comment period, as well as during the regional board public comment period. As I said, the responsible parties identified for implementing the TMDLs are the City of Newport Beach, the County of Orange, marina owners, operators, and individual boat owners. We expect that the city and county to take the lead on this because the County of Orange and City of Newport Beach while they assert they are not responsible for mitigating copper discharges from boats, both entities retain management authority over non-private tidelands and submerged lands where most marinas and moorings are situated in the bay. Both lease lands to marina owners, operators, and to individual recreational boat owners to moor boats or provide boat slips. So therefore, the city and county can implement or require the implementation of BMPs and provide incentives to boat owners to implement those BMPs. Straightforward strategies such as BMPs, certification education programs are available and being implemented in other areas such as San Diego and the Shelter Island Yacht Basin, and in Los Angeles and the Marina del Rey Harbor. While there are some private tidelands in lower portions of Upper Newport Bay and some within Lower Newport Bay, such as Linda Isle, these are minor contributors compared to those that are over the city and county's tidelands. Next slide, please. On January 28th, 2022, after the 3 technical meetings were concluded, the city and county submitted an alternative implementation plan. This was rejected by the Santa Ana Water Board because it assumed that the county and city are not responsible parties. It relied on state agency actions outside the board's jurisdiction, such as actions by the Department of Motor Vehicles and the Department of Boatings and Waterways. And others. The implementation method was not feasible or clearly defined, and there's no reasonable assurance of reducing copper impairment in the bay. Next slide, please. One of the issues that was raised at the regional board hearing and brought up again during the state board public comment period is concerns for PFAS and non-biocide hull paints. They are stating that there was limited or insufficient environmental review for the substitute environmental document on alternative non-biocide antifouling paints that may contain PFAS compounds. While we acknowledge there are potential PFAS presence in some alternative paints, currently there's insufficient data on PFAS as to how much, what types of PFAS, or whether these can even leach from paints. As you know, they're made to stick and have things slide off them. So we really don't know what that, there's been no studies done of leach rates for those. The 12-year compliance schedule allows time for dischargers to evaluate the environmental impacts of alternative AFPs and develop project-specific CEQA. There are several paint manufacturers, including Hempel, CJET, Ceramcoat, Pettit, and others that offer non-biocide AFPs that are reportedly free of PFAS compounds. And copper's toxicity is well known, and the effects on aquatic life are well documented, which necessitates the adoption of TMDLs. The SCD acknowledges this. It also includes a statement of overriding considerations included in the SCD that weigh the environmental benefits of reducing copper overrides the concerns of potential PFAS and non-biocide paints. As I've said multiple times previously, we do not require the use of these paints. They're one tool in the toolbox. Next slide, please. The other issue that has been brought up is the failure of Shelter Island to meet its the CTR during the compliance timeframe, which was the end of this year. We also are seeing the same thing happen in Marina del Rey. So they're saying because they did not meet the final compliance date or CTR-based numeric targets, we do not feel that that doesn't suggest that Newport Bay will fail to meet those targets. They don't negate the necessity of the Newport Bay TMDLs. Shelter Island achieved 45% and 68% reductions in their first 2 compliance deadlines. The Newport Bay Copper TMDLs only requires a reduction of 60%. The Port of San Diego implemented many of the same best management practices recommended for Newport Bay. There's no documentation of the City of Newport Beach of any BMP implementation or copper reduction efforts. And in addition, there are some major differences in hydrodynamics, retention times, number of boats or boat density between Shelter Island and Marina Del Rey compared to Newport Bay. Those are specific marinas or a small harbor with a high density of boats, very low retention times and flushing. Our TMDLs apply to both Upper and Newport Bay and Lower Newport Bay. They're not being applied to specific marinas. Our concern is for the overall health of the bay itself. We know some marinas will likely not be able to meet the CTR, but if the bay as a whole does, then we've accomplished what we need to do to protect aquatic life. Next slide, please. As I said, Newport Bay is significantly larger with more extensive marina and mooring areas. Shelter Island is a much smaller enclosed basin within the larger San Diego Bay. Has concentrated marinas and mooring fields, so these densities and flushing likely affect copper TMDL outcomes. In addition, as I mentioned, the navigational channel, that's quite efficient in moving water around and through Lower Newport Bay and provides a lot of flushing that the Shelter Island and Marina Del Rey don't have access to. Next slide, please. So what's our legal authority? Legal claims raised by the city and county are that Newport Bay TMDLs conflict with federal and state laws. The Vessel Incidental Discharge Act, or VITA, is one of the ones they say it conflicts with. This is a regulation that U.S. EPA and U.S. Coast Guard will be regulating vessels that are greater or equal to 79 feet in length. As I mentioned previously, the TMDLs only apply to small commercial vessels less than 79 feet in length and recreational boats. Also say it conflicts with the Clean Boating Act, which governs small commercial and recreational vessel discharges. Clean Up Boating Act allows more stringent state or local measures to be taken. And Food and Ag Code 11501.1, which restricts local agencies from regulating pesticide impacts. However, the California Attorney General has affirmed states' rights under Food and Ag Code 11501.1. And that was California Ag Opinion number 211001, which stated that although Los Angeles County lacks power to ban copper anti-fouling paint entirely, it retains power to address the local environmental effects. Next slide, please. So in conclusion, we feel these copper TMDLs offer flexible compliance pathways, a phased implementation schedule, which supports gradual copper reductions, the application of site-specific objectives or other alternatives to the standard CTR criteria using the water effects ratio allowed under the CTR or an alternative method, the use of sediment quality objectives to allow flexibility in assessing benthic impacts. The dischargers may develop tailored implementation plans based on local conditions, and it incorporates the Department of Pesticide Regulations recommended management practices for enhanced feasibility. We feel that these provisions support achievable water quality improvements, and we believe that potentially even with just BMPs alone, we may be able to meet the CTR criteria and our timelines. It's also an iterative process. If there's additional information that comes out in the future that shows there are concerns with some of these non-biocide paints, we have the ability to revise these TMDLs as necessary as we move forward. As usual, we're going to implement adaptive management, and we assume there will be future time frames when this TMDL will need to be brought back to the regional board. So our next slide. We therefore recommend that the State Water Board approve the Santa Ana Water Board's copper TMDLs. Please let me know if you have any questions. Thank you.
Thank you, Ms. Reeder. I appreciate the good work of you, your team, and the region on this project, and the engagement from city, county, and voters and others that may have disagreements, certainly. But I feel, looking at the timelines here, this wasn't a rushed job. I don't think anyone rushed to adopt these at the region and hear them before the state board. So I feel there's been a lot of consideration and flexibility built in here. I do appreciate also covering what's happened in San Diego and LA as just a kind of, this isn't the first harbor or bay to contemplate copper TMDL, and so helpful to see how things have carried on in those other communities. I know we have a number of commenters, and so I look forward to hearing their feedbacks here still yet and concerns, but just want to thank the process here because I think it has been responsive to a lot that's been heard, even if there's still some fundamental disagreements, obviously, in the pursuit of it. So thank you for that. Vice Chair.
I just have a couple of questions. So I appreciate just right before the last slide, you said that, Ms. Reeder, that the schedule you believe could be met. It's quite possible that it could be met through just use of BMPs. Do you have any additional information or analysis that could, explain why you've come to that conclusion?
I think it's basically based on the fact that Shelter Island Yacht Basin managed to meet their first two interim reductions. One was a 48%, and the other one I think was 60. I forget what it was, 64%. I'll have to go back and look at my notes for the exact numbers. But the 60% reductions we think are necessary based on the information we have should be met in Newport Bay. If they got those reductions, they keep saying we're close to meeting the CTR. We have to talk, the average is about 2.5 micrograms per liter in the Bay, but as you know, we have to use the state listing policy for determining that, so impairment is still assessed under that. But if those are implemented, I have high hopes that they could meet it, at least in most locations, and certainly meet it underneath the listing policy. Upper Bay is already fairly close to being able to be delisted. Lower Newport Bay, because that's where the concentration of boats are, that's a little further away. But there was a study done by my former staff member, Dr. Linda Candelaria, which did a project where they actually bagged a boat and they removed the particulates. So they cleaned the boat in the bag and then they filtered out the particulates, and they found that 70% of dissolved copper and over 90% of particulates was removed by that process. Now, it's a lot more expensive than your typical in-water hole cleaning, but anything to reduce particulate and dissolved copper concentrations would come off during the boats during cleaning should have a net positive effect.
Great. And then the other question is, of course, not knowing what the cost is, and you may have that information, but just to get a sense of the incentive that the industry would have, well, not the industry, boaters would have to seek out, kind of collectively up and down the coast of California where these measures have been imposed, to, join together to seek out further development for upgraded paints. So any sense on that? And of course, if you can meet it through BMPs, but it depends on how costly those BMPs are as to whether or not there'd be that desire.
Well, those BMPs that I mentioned yes, it's more cost, but San Diego the Port of San Diego has been able to implement it with quite a bit of success, as well as Marina Del Rey. So I don't think that's the big thing. The big question is the non-biocide paints. I think it's going to have to take time. There needs to probably more studies, because one of the concerns as well, some of these other studies have been done in colder waters or areas that are not Southern California. We do have a little bit of a unique environment here. Are the biofouling rates the same? Are they going to be equally effective? We know they're effective on large commercial vessels. There has been success on some recreational vessels, but it's just not as wide known or widespread. And I understand the boaters like their copper paints. They've been very effective. And so those costs are something that we'll have to take into account and consideration, just like we do with any of the state policies that are adopted. Those are things that we may not know at the time, but they need to be taken into consideration as we move forward with these TMDLs.
Thank you, Vice Chair. Thank you, Ms. Reeder. Looking to other colleagues, if there's any comment or question now. Board Member McGuire.
Yes, thank you. Thank you for the presentation and all the work that's gone behind this. I can see that it's been quite extensive.
Well, I want to give a shout out to my former staff, Dr. Linda Candelaria, and my former environmental program manager, Joanne Snyder. They are the ones that really carried this project until after it got adopted by the regional board, and I've just been more heavily involved in it since then, so I have some pretty big shoulders to ride on.
Good, yeah. It's a team effort always.
Yes.
Yes. My question is, one of your bullets, or a couple times in the presentation, you mentioned the potential for site-specific objectives at some point, if appropriate. Could you talk a little bit more about that? And also, are some of the other harbors? I bring this up because we're looking at it, as I'm sure you know, on a statewide level, at least for inland waters, being able to use other tools to develop site-specific objectives for copper.
Yeah.
So could you just talk a little bit about the applicability here, and are other harbor areas looking at that similar type of approach?
Yeah, Marina Del Rey did do a water effects ratio approach, and they did come up with higher numbers, slightly higher. I don't remember exactly what they are, but they're not able to meet those either. But again, that's a very enclosed basin with very highest density of boats. I think it's even higher than Shelter Island Yacht Basin, and pretty poor retention times. Pretty long retention times, especially as you move into the back parts of the basin over there. For freshwater, EPA has adopted a biotic ligand model, and that some people have been implementing that. They also had a draft saltwater biotic ligand model, but that's never been finalized. But there could possibly be a way of picking up that work maybe and moving forward with it. That it takes into account, I think, a little more of the environmentally site-specific factors than just the water effects ratio calculation. But who knows what the future holds? There may be some other, methods that become developed. I mean, just because this copper TMDL has been delayed so much, it's like every time we thought we were done with it, something new came out that had to be addressed. So I fully expect that to continue, because copper in harbors and bays is a worldwide problem. It's not just Southern California.
I appreciate that, and I agree. Yeah, at some point we have to use the best available science at the moment to make an informed decision. And what's important is the willingness to adapt as new information comes to light. And you're signaling here that the board has a willingness and an interest in doing that if new tools and approaches become available.
All of our TMDLs, we do that. I mean, it's the technology and scientific advances that just happen all the time, and you have to be able to have adaptive management and be willing to reopen a TMDL if needed and revise it.
Yeah, very much agree. Thank you, Ms. Reeder. Thank you, board member. Seeing nothing currently from the dais further, let's get to start hearing from folks. I'd like to call up our first commenter, who will be Tom Biscoff, followed by Chris Miller, John Kapler, and then Shelley Ankura.
All right. Thank you very much for allowing me time to comment on the Newport Bay TMDL. My name is Tom Bischoff, and I'm the Director of Global Regulatory Affairs at American Chemical Corporation, which is a manufacturer of cuprous oxide, which is the main ingredient, the main active ingredient in copper-based anti-fouling paints. First of all, I appreciate the efforts, and the presentation appears to be a very pragmatic approach with a lot of openness to hearing new technologies and new science. I just want to really encourage the Regional Water Control Board to strongly consider moving away from the numeric assessment of copper concentration, kind of what we were just talking about, and focusing on assessing the holistic biological health of the marina. To my understanding, this is the approach currently being evaluated in Shelter Island Yacht Basin to understand the true impact of copper and not just the copper concentration. This is mainly due to the dissolved copper and copper concentration not being equal to the bioavailable copper. Copper must be in the form of the cupric ion to have potential toxicity. Typically in water bodies, a lot of the cupric ions that leach out of the coating are bound to either dissolved organic carbon or other ligands, like we were discussing the biotic ligand model, which then render them non-bioavailable and non-toxic. There have been some studies in marinas that have indicated as much as 60 to 70% of the dissolved copper can be non-bioavailable and then non-toxic. So I want to focus on the emphasis on, I'll go away from just numeric values of copper, and that may lead to overregulation and attempting to reduce the copper levels beyond what's required. We mentioned the WEIR study that was done in Marina Del Rey. They found that the WEIR value, the water effects ratio, was 1.32, which then reduced their target copper reduction from 85% down to 57%. So a similar study here would probably be very beneficial and result in more realistic reduction targets that would still be protective of the water body. And then finally, we talked a little bit about the study that was done in the state of Washington. I know the mention was it wasn't applicable and wasn't peer reviewed, but it was a study that came to the conclusion that the alternative to copper-based anti-fouling paints could be worse than what we know right now based on toxicity and the unknowns of the alternative coatings and moving large number of vessels to those coatings, as well as the efficacy in preventing invasive species from coming into the area. So basically what they found is that the known is safer than the unknown in that instance. So I encourage at least consideration of that in your region as well. So that's all I had. Thank you for your time.
Thank you as well. Appreciate the engagement, Mr. Biscoff. Next, I'd like to call up Chris Miller, be followed by John Kepler, then Shelley and Hera.
Good afternoon. My name is Chris Miller. I'm the Public Works Manager for the City of Newport Beach, and I'm joined virtually by my colleagues, John Kapler, a Senior Engineer with Public Works, Dr. Shelley Angara, Principal Scientist, Viviana Hager, and Amanda Carr, who is our Deputy Director with the County of Orange. So they'll be following me, and if there's any questions afterwards, that's the team. And since we're on the receiving end, I figured we'd be happy to help and answer questions. As an aside, staff has given us 15 minutes as a team to present. We'll do our best to stay within that 15. If we go a little bit over, I ask that we can at least finish our presentation. Thank you.
That's fair.
Region staff did a good job presenting their case. To me, however, the single most compelling point of their presentation was the acknowledgement of a direct correlation between state-approved anti-fouling paint and the copper levels in Newport Harbor. The state of California, through one sister agency, permits the type of paint that can be legally sold at shipyards statewide. On the other hand, another sister agency, the Water Board, controls the level of copper in the water. To me, both agencies should decide either to correct the formulation of paint, whether copper-based or alternative anti-fouling paints, or both agencies should decide the acceptable levels of copper in the water column. To me, these two agencies must be in sync, and it is clear that they are not. And we would ask that the Water Board question as to why. Next slide, please. This is a summary slide of what we'll be covering. We'll touch upon the following points. The state's authority, not the city, to regulate and approve paints and appropriate leach rates. 2, the city's programs and deep history of doing what's right for water quality. 3, the minor copper exceedances in various pockets of Newport Harbor that have not shown impairment to aquatic life. Next, concerns with alternative paints and their unintended consequences, including PFAS. And lastly, the lessons learned from 2 other identical programs in San Diego and Marina del Rey, and, contrary to staff's assertion, have not proven successful. Next slide, please. Staff did a good job of emphasizing the size of Newport Harbor, both upper and lower bay. It's 2.2 square miles, and it is comprised of city tidelands, county tidelands, but what was not mentioned in degree were the private tidelands that are also, private waterways that are also within Newport Harbor. And it does represent a significant number of boats. Many hundreds of boats are in those private waterways. To emphasize, this is not a giant marina. And indeed, it is the largest recreational harbor in the western U.S. And indeed, we do have a large or significant number of commercial vessels. And lastly, it is worth repeating that local government cannot regulate the sale and use of registered pesticides, i.e. anti-fouling paint, in the state. This is a job of state agencies. Next slide, please. Now I'll turn it over to John Kapler, Senior Engineer of Public Works for the City of Newport Beach.
Thank you, Chris. John Kapler, City of Newport Beach Public Works Department. You can go to the next slide, please. I'd like to expand a little bit on Mr. Miller and Ms. Reeder's points and specifically address the BMP implementation, public education, and just in the next few slides. The Regional Board Staff Report identifies best management practices such as diver boater education programs. They also mentioned the lower leach rate paints and the alternative anti-fouling paints. You'll hear more about this later in the presentation. The city of Newport Beach does have a public education program. We have an enforcement program and an inspection program. It's implemented mainly by the city's harbor department and the code enforcement division. A summary of these activities is submitted to the regional board annually in our NPDS report. The lower leach rate paints, which you'll hear a lot about, are currently being implemented in accordance with DPR's schedule. But as a reminder, and you've heard this before, Newport Harbor has a large number of commercial vessels, including a Coast Guard cutter, and the lower leach rate paints don't apply. Additionally, the city has tried in the past to convert boats to non-copper based paints. We've worked with a local environmental group. We did outreach to the public for boater conversions. We even converted a number of city boats, and our harbor master converted his private vessel. Unfortunately, the paints didn't work, and we had to convert all the boats back. So we have tried the non-copper paints. 2 points, and then I'll kind of wrap things up. As you've heard, the city has partnered with DPR, and I do see a few DPR colleagues in the virtual meeting here. And they're studying Newport Harbor, which is one of 8 marinas up and down the coast that they're studying. DPR only had limited funding for Newport Harbor, and they had 17 sampling sites. So the city of Newport Beach and the county stepped up. We put in some time and we put in some money. We're currently sampling 47 sites. And for the group's benefit, our next round of sampling with DPR is scheduled in 2 weeks from tomorrow, I believe. Next slide, please. Kind of wrapping things up, lastly, in addition to public education in these BMPs, the city has spent tremendous time and funding to dredge Newport Harbor. We've removed 400,000 cubic yards of contaminated material and an additional 1.4 million cubic yards. As Ms. Reeder mentions, these projects remove contaminants, including copper, increases tidal flushing, and improves water quality. A little plug to the Newport Beach City Council is dredging of Newport Bay is actually a responsibility of the Corps of Engineers. However, our city and our city council has stepped up to the plate and appropriated $15 million to this effort. With that, I'll thank you, and I'll turn over the presentation to Dr. Shelley Angara.
Hi, my name is Shelley Angara. I wanted to, if you could please go to the next slide. I wanted to just share with you a little bit of a summary of the data and what it looks like in Newport Bay. This is an example of the DPR data set that is shared with the city and DPR. You can see here, this figure summarizes the red dots are samples that are in excess of the CTR, the 3.1 parts per billion value. The blue dots are below. The average concentration is near 2.5 parts per billion. This is much lower than the concentrations observed at Shelter Island and Marina del Rey Harbor, which tend to be 2 to 3 times this average. This figure also illustrates where the elevated copper is most commonly observed. It's in areas with the least amount of flushing. Many of these restricted areas are private and not under the city's Tidelands Trust. This is also the data set where we performed multiple toxicity tests on the 3 highest dissolved copper concentration samples. We used the most sensitive test species available, the Middleist development test, and no toxicity was observed with concentrations that were near 9 and 10 parts per billion. Please advance to the next slide. One more slide, please. Thank you. We are pleased to see the staff present concerns regarding the alternative non-copper anti-fouling paints. We have continued to bring forward our concerns regarding their effectiveness and the environmental safety. It is well documented that no single alternative anti-fouling paint works for all vessels and all types of environments, and the formulations are constantly changing, which is making it difficult to build boater confidence. To that end, the safety of the non-biocidal paints for human health and the environment still has not been confirmed due to the nature of the business. Many of these compounds are not disclosed, they're proprietary ingredients, and the lack of the non-biocide regulations prevent the testing. The city has participated in these studies and using some of the most commonly alternative non-copper paints, we found the presence of PFAS and PFOA. So, and as stated earlier, the impacts of these leach rates from these paints has not been studied, and we want to make sure that we do not introduce a new concern. Most of the published studies on alternative paints have been generated by the state of Washington's Department of Ecology. They have concluded that there are no feasible, reasonable, and readily available alternatives to copper anti-fouling paints, to copper-based anti-fouling paints. They have therefore delayed the halting of their copper-based anti-fouling paint rule until 2029 to allow further development of these toxicity studies and establishing new alternatives in the future. The one last point that we would like to bring forward is we would like the regional board in the implementation plan to consider the increased risks associated with the potential of introducing invasive species. This may be accompanied with the reduction of the more protective, well-known copper-based anti-fouling paints. Please advance the slide to the next speaker. Thank you. Viviana Hedger.
Ms. Hager, you should be unmuted at this moment, but maybe having some challenges.
Yes, Mr. Chairman.
Oh, there you are. There you are. We can hear
Good
you now.
afternoon.
Thank you.
I trust everyone can hear me, although you cannot see me yet, but I'll press this button and you'll be able to. So thank you very much for giving us this opportunity this afternoon. I will speak to some legal concerns raised by the various technical issues that we have covered. Next slide, please. So we have various legal concerns, but this afternoon I'm only going to focus on one, and that is the presence of PFAS in the alternative paints that are a major strategy to this copper TMDL. I think what's most telling here is that when the copper TMDL came before the Santa Ana Regional Water Quality Control Board, Chair Chris Murray voted against the adoption of the TMDL, precisely and consistently with the comments that we raised. And to summarize it very, very plainly, her concern and our concern, and the evidence supports this, is that if you introduce alternative paints that don't have copper, you're removing copper and you're introducing PFAS with regard to the paints that we tested. Now, CEQA requires analysis of these issues now, and the substitute environmental document instead defers and delays that analysis until the project level analysis, and we disagree with that. The substitute environmental document not only did not evaluate PFAS, but it didn't evaluate invasive species, which will increase. It mentioned it, but it didn't evaluate it. Another item that's not evaluated at all is the likely increase in greenhouse gases, because as the alternative paints are not successful, more invasive species accumulate, and that drags the boat, consumes more fuel, and increases greenhouse gases. As a result, our position continues to be that the statement of overriding consideration is completely unsupported. Next slide. At the hearing in December 2022, we wanted to bring, and we did bring, an expert, toxicologist Meg Whitaker, and she provided testimony similar to the speaker couple of speakers ago, which is that right now, the incrementally safer alternative to continue using are the copper-based paints. Now, we raised that issue. It warranted further investigation by the regional board, but rather than analyzing the issue, they pointed to certain technical deficiencies in the testimony that Dr. Whitaker provided. And then surprisingly to us, they also found that it was premature to decide the potential level of PFAS, which of course it isn't because we have evidence on the record. And then they pointed to the fact that PFAS is present in thousands of projects, and it's difficult to determine that contribution. And plus, there's 12 years to figure it out. Well, 12 years doesn't really help the stakeholders because the city has no control over the consumer products that voters use. So to sum up very, very quickly, we ask that the state board should require CEQA compliance from the regional board so that they use the best efforts to find and disclose all that they reasonably can at this stage, not at the project level stage. Next slide.
All right, thank you, Bibi. And I'm the next speaker on the panel for the county and the city. My name's Amanda Carr, and I'm Deputy Director for OC Environmental Resources in Orange County Public Works. As has been mentioned, the county is a tidelands operator. We have a small marina at the lower end of Upper Newport Bay called the Dunes Marina that is under county tidelands. Could you go to the next slide, please? Thank you. As Terry outlined really helpfully for us, this has been a complex and long regulatory process, and the county agrees that the 2002 EPA TMDL does need to be updated. However, as has been expressed by some of the previous commenters, and I'd like to go into a little more detail, we're concerned that the current TMDL does not include an appropriate and feasible implementation plan based on findings that have come out of the Shelter Island Yacht Basin and Marina Del Rey TMDLs, and it currently does not include an achievable compliance pathway. I appreciated Terry's summary of the findings from the other two TMDLs, but I don't feel that we went into enough detail of recent findings that have occurred, unfortunately, since this TMDL has been within its approval process. So there have been several developments that, through poor regulatory timing, really have not been brought into consideration in what has been proposed. And I fear that adopting this TMDL as proposed sets us on a course for non-compliance, as the identified implementation tasks have not been shown not to result in achievement of numeric water quality standards at the two other locations. And we really do have the opportunity now to learn both from Shelter Island and Marina Del Rey and provide an achievable compliance pathway. Since the Santa Ana board has finalized its TMDL documents, both the LA board and the San Diego boards have concluded that the CTR will not be achieved through education and diver certification processes and the boat paint conversion efforts that have proven unsuccessful. Both diver education programs and diver certification processes have been lauded. Both of those programs have been successful in educating the public and providing significant outreach to the diver community. Unfortunately, those efforts, while they can be shown through load calculations to meet load reduction targets, they do not result in water column reductions of dissolved copper. If you can go on to the next slide, please. Notably, E.O. Gibson from the San Diego board has indicated in his October 2022 letter to the responsible parties in the Shelter Island Yacht Basin that after 17 years of implementation, the 3.1 standard will not be met despite the significant efforts of the Port of San Diego and its partners to educate, engage the public, incentivize the use of alternative coatings, standardize and improve in-water hull cleaning, and test the use of natural and engineered technologies to reduce loadings or effects on copper. While load reduction calculations using the TMDL model assumptions were documented, these efforts did not result in actual water column reductions of copper concentrations. Can you go on to the next slide, please? I think it's also really important to take note of the hull cleaning and diver certification process, as well as a very important study that Shelter Island conducted, where they instituted an 8-week complete cessation of hull cleaning within the yacht basin. And that complete cessation of cleaning, not just cleaning with BMPs, was insufficient to reduce basin-wide dissolved copper levels. If you look at the data shown in this slide, the report talks about how in the ramp up to the cessation of hull cleaning, they saw an increased amount of cleaning activity, which makes sense. People knew they weren't going to be able to clean their boats for 2 weeks. So in the weeks leading up to the cessation, they saw a higher level of diver activity. Then there was a period of 8 weeks where there was no diver activity and no documented hull cleaning going on. And then there was a post-pause period that you see in the last column of the chart. And I'd really like to call your attention to the lowest values across the screen there. From the pre-pause throughout the pause into the post-pause, it never dropped below that baseline level. So they were not, while they saw increases due to increased cleaning activity, they saw that decrease of those higher levels during the pause, but then again, in the post-pause activity, before cleaning really started to ramp up again, we aren't seeing those levels drop below the low values from the pre-pause period. So what this shows is because there are so many boats that are utilizing the passive leaching in copper-based paints, that there's just a basic carrying level that is not affected by changes in hull cleaning. If you can move on to the next slide, please. Additionally, the Los Angeles board recently in 2024, again, after the Santa Ana board adopted this proposed TMDL and before that this TMDL was brought before the state board, as we're discussing today, Marina del Rey adopted a water effects ratio site-specific objective that was developed by the Los Angeles Department of Public Works. Per the state implementation policy for a site-specific objective study, the LA Regional Board had to make the finding that there had been a demonstration that the discharger cannot be assured of achieving the criterion or objective through reasonable treatment, source control, and pollution prevention measures. So in essence, in order to accept the site-specific objective study and to move forward with this, the LA board had to determine that the implementation plans that were included as part of the TMDL were not going to result in the achievement of the CTR standard. Specifically, they did note that the public education and outreach and ordinance activities of the Department of Beaches and Boats in the city of LA went above and beyond and actually exceeded their expectations of implementation of those programs. But unfortunately, those activities are not resulting in a change in water column concentration, which ultimately is the compliance target for these TMDLs. If you could advance to the next slide, please. As I mentioned, up in Marina del Rey, they implemented many of the same BMPs that are being recommended within the current TMDL, as well as those BMPs that mirror those that were going on in Shelter Island Yacht Basin. And, you know, I know in both locations, the boater education and the in-water hull cleaning in particular have been cited as successes and have been very effective. While those programs were effective in reaching and educating the public, they were not effective in reducing water column concentrations. If we can move on to our next slide, please. So we'd really like to discuss implementing and bringing these lessons learned into our TMDL here and hopefully charting a more successful path forward. As John and Chris mentioned, the city and the county are supporting and expanding the ongoing monitoring by Department of Pesticide Regulation. We're also conducting SQO monitoring through our NPDES permit. And we do that regularly throughout Upper and Lower Bay through work done both by my monitoring team as well as our partnerships and BITE work through SWRCB. The city has committed to harbor dredging activities that will include improved circulation and tidal flushing, providing water quality benefits throughout Newport Bay. And while strategic public education initiatives can be further implemented and continued, because as John mentioned, these activities are already ongoing within Newport Bay, we believe that compliance in this manner should be activity-based and recognize that the conversion of paints can only be encouraged, not compelled or required by municipalities or marina owners. So these activities require or rely on the voluntary compliance of boat owners throughout the harbor in order to make any potential changes. If you can go to the next slide, please. So based on the lessons learned at Shelter Island and in Marina Del Rey, both of those regional boards are looking at more holistic measures of ecological health beyond just the water column concentration. We would recommend either not adopting this basin plan amendment today, but directing the regional board staff to work with stakeholders on a revised implementation plan and BMP or activity-based compliance that recognizes the lessons learned both in Shelter Island and Marina Del Rey, or we would request that findings language be included that direct a BMP-based compliance pathways to be included in future implementation actions, such as waste discharge requirements and/or waivers when they are adopted by the Santa Ana Board. And we believe that those implementation plans should include the lessons learned from Shelter Island Yacht Basin and Marina Del Rey, and the actions that have been taken by both of those boards and the findings by both of those boards that have occurred since the adoption of this TMDL by the Santa Ana Board. We really feel that so much work has gone on in multiple locations. We just don't want to be set down the same pathway that has proven to be unsuccessful at 2 other locations. And then lastly, I'd just like to leave you with the thought of instead of adopting a TMDL today, what you were judging was a discharger coming forward with a compliance plan to meet a numeric target. And if that discharger told you, well, I'm going to do the same thing that 2 other locations have followed, but it didn't result in their compliance, and the way that I'm going to get to numeric compliance is through public education and the voluntary efforts of the public, I'm not certain that that compliance plan would be adopted. So happy to answer any questions or have further discussion if you need any clarification on the information that I've provided. Thank you.
Thank you as well. I appreciate the presentation from folks here. Actually, a question for you, Ms. Carr. When it comes to the lessons learned that you feel have not been incorporated in here, is it just generally the lesson that you feel these are unachievable and so we should really be rethinking our strategy? Or is there something specific, I guess, from those previous projects that are an identifiable lesson that we somehow should have within the current proposal? Just trying to tease out a little more clearly what it is that folks want to see in there incorporated lesson-wise that isn't necessarily, again, kind of walking away and saying, it wasn't achievable in these 2 harbors or marinas, waterways. But yeah, I just kind of wonder what the finer point is on what you feel should be incorporated.
Yeah, no, I appreciate that question and thank you for allowing me to clarify. So I think what we're concerned with is that the assumption that public education and diver certification and BMPs with regarding to hull cleaning is going to lead to compliance with the CTR. That has been shown not to be the case. Load reductions have been able to be calculated. Load reductions aren't measured. And so what we're saying is that the implementation plan steps that have been laid out don't result in numeric water quality compliance with the concentration. They are successful in educating boaters, and they are successful in changing diver cleaning patterns. But those aren't resulting in the level of reductions that is needed to meet the numeric water quality standards. And that's what our concern is, because that's our ultimate compliance metric.
Thank you, Ms. Carr. Board Member Firestone.
Thanks. I just, maybe this is just back to you, Ms. Reeder. I wanted to just understand the disconnect for me. It sounded like you were saying that although, these other harbors weren't able to meet the level, their compliance level, they were able to see reductions. And then it seemed like this presentation was saying there were no reductions at all, but like, were they looking at different metrics? Can you just help tease out why the two statements seem to be conflicting in my mind, or what I'm missing?
No, I mean, if you looked at the graph or chart that Amanda showed, they did get some reductions. What they didn't get to was the CTR criterion. As I mentioned before, we are applying ours to the entire bay. We're not applying it to individual specific marinas, which is what both regions 4 and 9 have done. Those marinas have a much higher boat density, and I'm not really surprised that they're not able to meet the CTR. They don't have the tidal flushing that Newport Bay has, and none of these activities have taken place. There have been no BMP diver certification process. There has been some limited boater outreach. There was some cooperation from the city early on, but that waned fairly quickly and has been in opposition to our first trying to get these TMDLs adopted in, I think, 2016. I also want to point out that dredging does have an initial benefit in lowering copper concentrations, but because it's the boats that are sitting in the water, they're passively leaching, that goes away and it soon regains into the same levels that were there previously. I mean, I laud all the city's efforts. As you can see, there are areas in the bay that are doing quite well, but we still have these problem areas that do have a lack of tidal flushing, and a lot of those are where we have a greater concentration of boats. So I do think that the Port of San Diego has done a fabulous job, as has LA Harbor, but they've got a lot harder road than I think we do in Newport Bay, simply because of how those marinas are constructed, the density of the boats, and the lack of sufficient tidal flushing into those marinas. Maybe I'm being overly optimistic, but I think in the 12 years we have, and let me remind you, that includes also having to go through OAL and EPA before they're in effect, so it may be another 11 or 13 years. Sorry, accidentally turned off my mic. I have to learn not to gesture. So I do think it can be done, and I do think in that time frame there are a lot of advances being made with alternatives to copper paints. But as Amanda pointed out, things are, and it's changing so rapidly, it's very difficult to keep up. And as you know, regulations are usually kind of behind the 8 ball when it comes to technical advances. So I think we have options. If we need to extend it, need to change the path we're on, adapt, that's the whole purpose of the TMDL.
Thank you. And just to put a finer point on it, just for my own following. So what is the metric that you're referring to in terms of reductions that have been able to be achieved? Is it in the water column, or is it of a discharge, or,
It has been measured on load reductions, and Amanda is correct, it's a calculation, but that's how we calculate loads.
Right, okay.
So, I mean, I think the fact that they did get reductions even in the loading is significant. And I think it's something we haven't done in Newport Bay to see, at least try it and see what happens.
Thanks. Yeah, that's really helpful. Thank you.
Yeah, thank you, Ms. Reeder. Thank you, board member. All right, seeing no further questions for the panel, thank you again for that. Next, I'd like to go to Raymond Heimstra, who will be followed by Mary Courtours and Alexandria Breen.
Is it on?
Yeah, it should
Okay.
be on.
Good afternoon, Chair Esquivel and board members. My name is Ray Heimstra, and I'm the Associate Director at Orange County Coastkeeper. Next slide, please. So you're all aware of the keepers. You know, we're all about clean water. I've been working on this issue for 19 years. I've been with Coastkeeper for 25, so I've been working on this longer than anybody in the room or online. What I wanted to do is provide some context for what you've heard. First of all, I want to thank the staff for a very excellent presentation and really they've left no stone unturned, and like I said, I've been watching this for a long time. Next slide, please. Okay, so there wasn't always this, opposition to this issue. So this is a 2010 resolution from the city of Newport Beach, where they, say that there's a problem with copper in Newport Bay. Most of the copper is coming from boats. We need to take advantage of opportunities to use other methods to do that. So this was when we were all working together, and it was a team effort. And I'd like to go to the next slide, please. So we did a lot of work as the regional board talked. So starting in 2007, Coastkeeper, and these are just studies that I worked on and ran, the Newport Bay Marina Metals Study, where we studied the concentrations in sediment and water in different marinas. Newport Bay Storm Drain, so we identified that. We looked at the sediment study in 2014. That was post-dredging. So we were looking at I had a lot of talk about dredging. That was already done. Still got copper problems. And then we ran the Newport Bay Copper Reduction Project, which was a opportunity to educate boaters and offer them an incentive to switch over to non-biocide paints. Let me tell you, the boaters were very interested in this when we talked to them. They wanted options. They were interested in that. When they got to the boatyard, they hit a stone wall. Now, I do want to give Basin Marine credit for their help with this. They actually identified an option that they were happy with, didn't end up working too well, but we were able to convert some boats and at least try that option. But what we realized is that a voluntary basis on this just wasn't going to fly. So next slide, please. So there were some other options tried. So in 2011, the Port of San Diego, along with help from Orange County Coastkeeper and others, we tried legislation to go ahead and ban copper bottom paint. Didn't work. So then Department of Pesticide regulation came along. That's been successful. We have lower leach rates paints, which are great. They're helping a little bit. Hasn't solved the problem in Newport Bay. It's never meant to solve the problem in these specific areas. It was statewide. And then most recently, and this is really a show of where, people are at in the city of Newport Beach. Assembly Bill 7073, which would have gutted all copper regulations on copper paint, and that was defeated. So next slide, please. So alternatives to copper paint. So non-biocide paint alternatives are available in Newport Beach today. I was just checking the website. So Basin Marine, Balboa Yard, they'll put them on. The Port of San Diego study, an earlier one, showed that non-biocide paints outperformed, were more cost-effective than copper. And then because everybody's cherry-picking quotes from the Washington study, I'll go ahead and do the same thing. And on page 29 of the Washington study, it says that the non-biocide paints perform just as well as the biocide paints. And then boat lifts and dry docks. So, in Orange County, we have more than one harbor, so we see a lot of those. So there's different options. And in fact, Orange County Coastkeeper has a boat, and ours is on, we put it on our trailer and put it away. So next, please. So the challenges and the pushback. So resistance from the city of Newport Beach and County of Orange to regulate, you've heard all this stuff. The idea that they can't regulate a legal product, let's see, plastics, tobacco, you can just go on and on. The concept that you can't regulate those is just absurd. And, if there's a boater education program going on in Newport Bay? I haven't seen it. I mean, we got a boat. We're down there all the time. In fact, in 2015, we sat down and had a meeting with the city, and they were like, well, how about we postpone this TMDL for about 5 years? We can get a better grip on it. We said, we can consider that, but what we would want to see is a boater education program, and then also a diver certification program. They said, we'll get back to you on it. Well, we haven't heard anything about that since then. In 2020, I worked with Newport Beach staff on a proposal, a 319H grant for diver certification. And that, that actually, we got the paperwork going. It went pretty well. When that got up to senior level, got killed. So unfortunately, what we've got is a situation where there was just a change of attitude. There's a change in staff, change in council. They aren't buying it. As you can just hear from what you're hearing, they don't want to do it, and that's their opinion. It's a shame, but that's where we're at. And then opposition from the boatyards. I can actually see that because this is just new. They've been rolling on this copper paint since 1988 when Tribunal 10 was banned. This is 1980s technology, and it's fast. You come in, you roll it off, you get the boat out real quick. With the other stuff, you need new equipment, you need training, it takes some more yard time. It's called progress. It's change. Everything, we have change all the time, and we shouldn't be using 1980s technology, and it's really hurting our environment. And then you just have, statewide organizations like the RBOC have gotten involved because Newport is seen as the last line. San Diego got by them, and then Marina del Rey, damn it, it's going to stop here. And that's kind of where we're at. Next one, please. So there's been progress. As you heard, the Port of San Diego reduced copper concentrations. I got the number wrong, as Terry mentioned, is 64%. Now, the estimated requirement for Newport Bay is 60%. So if they've already achieved 64%, then I think Newport can do it too. We need, the in-water hole cleaning regulations. There's none in Newport Bay. And then Marina del Rey, I talked to my buddy at LA Waterkeeper. They're really working their butt off over there. Yeah, they're making adjustments. They got a site-specific objective. You could do that here. They could have done that 10 years ago. In fact, the math has kind of already been done, and the site-specific objectives looks worse than what they have right now. So there's really not a reason to do that. And then in-water docking systems. So next one, please. So that's it, and I would be glad to answer any questions or anything you have. Thank you.
Thank you, Mr. Heimstra. Really appreciate your participation here in that presentation. Thank you. And on this long and ongoing project. Next, I'd like to call up Mary Courtourez. Apologies, butchering your last name. And then Alexandria Breen.
Hello. Hello, everyone, State Water Board and everyone in attendance. My name is Mary Courtourez, and I am an Orange County resident. Thank you so much for letting me speak today. I strongly believe that the city of Newport Beach should serve everyone who lives at and visits Newport Bay, which also includes the plant and animal inhabitants. The Port of Marina del Rey and the Port of San Diego have already implemented TMDLs for copper and have made significant reductions of the contaminant in their waters. A set TMDL level for copper Newport Bay will encourage systematic regulations and plans that will positively improve our waters and marine species over the following years. Please approve this TMD today to protect Newport Bay from copper pollution. Thank you so much.
Thank you, Ms. Couture. Next, I'd like to call up Alexandria Breen, be followed by Lay Youssef. Okay. Thank you, Clerk. And I believe Ms. Breen is on the platform. So next we'll go to Leah Youssef.
Hello, board. Thank you for letting me speak today. I am a resident of Newport Beach, of Balboa Peninsula. So I live right next to the harbor, and I walk along it every day. I use boats and such. And sorry, one moment. As we've seen, the data is clear that the copper levels in our marina still exceed safe limits, and voluntary programs haven't worked. Boaters are willing to switch to safer alternatives, but without boatyard support and clear regulations, progress is too slow. We need a strong TMDL implementation plan with enforceable deadlines and support for non-toxic alternatives. Our harbor is a shared resource, and it is very important to protect it and prevent further pollution. And we can't afford to delay this action any longer. Thank you.
Thank you, Ms. Youssef. Really appreciate your participation here in the discussion and your advocacy. Thank you. Next, I call up Jim Hausner, be followed by Jerry Desmond, and I believe our last commenter will be Bo Biller.
Good afternoon, Jim Hausner, and I'm the Executive Director of the California Marine Affairs and Navigation Conference, a recreational boater, and I'm vexed by this whole TMDL issue. Having been a boat owner and having stripped boats down, I can't figure out exactly what the facts are. I recall I was running a marine in the 1980s when your staff person, Nancy Jo Richard, led the fight against tributyl tin. And we could understand that because we knew that a few parts per billion actually made a difference to the benthic organisms. And there were pictures of it, and we believed in it, and we worked together in order to do it. Currently, we're in a quandary of this is the California toxic rule, something EPA forced upon us. It's a number, and does it mean anything to the benthic organisms and to the ecosystem services that were being provided? I want to comment a little bit about one of the things I worked on was I was a reviewer for Dr. Lee Taylor Johnson back in the 1990s. She was with Sea Grant and was doing work on how do we eliminate copper-based paints back in those days. So getting rid of copper-based paints is something that we've been working on for a long time. We need something that kills animals, unfortunately. And that's part of the problem with us is what do we do in order to do that? And there have been talks about some ablative things. There have been talks about self-polishing things, but those don't necessarily work for, say, a sailboat that maximizes 6 miles an hour as you're moving along and sailing through. And I'm going to quickly go through my notes rather than follow through and exactly what I had to do. There was a talk about the biotic ligand model. CMANC actually met several times back in 2014-15 with Dr. Sutherland with EPA headquarters. And we actually got her to elevate that criteria so we could determine whether it works. Well, the draft numbers came back and it says, well, because we don't have the sort of sediments, in other words, fine-grained sediment, it's not going to work for us. And for those who don't recall, Dr. Sutherland resigned or retired very publicly in March of 2018, and nobody has picked up that mantle ever since those days. So the question is, will the alleged copper impairments be corrected by this TMDL? And I would argue, based upon what we're now seeing in Shelter Island and in Marina del Rey, that that's not going to be the case. Now, yes, we're a different sort of water body in Newport Beach, and maybe that has something, but is there any scientific basis that will indicate that that makes a difference? Have we done some studies, and is it just an idea like, oh, that's a great idea, and we want to move this one forward, so we're going to say that at this moment. Some of the things that showed up in the staff report response to comments was like Marina del Rey has a 38% reduction. Well, as Dr. Angara talked about, that was penciled out. In other words, we got a 20% reduction over here because we're doing the diver program. We got an 18% reduction over here because we're doing the different bottom paints on it. Well, Department of DPR, California Department of Pesticide Regulations, and I've worked with them back in the 90s as well, they came out with a report this March. They studied in Marina del Rey in 2019, 2022, and 2023 and 24. They came out and said their 2019 results were similar to historical concentrations. And this was, if you recall the presentation about 2018, is when bottom paints changed to meet the new criteria. Well, the mean in 2019 was 6.64. In 2022, the mean went up to 9.02. And then in 23-24, it was 8.75. So even though the bottom paints have changed, even though we're having diver programs and education and BMPs, we're not getting there to the numerical number. Same sort of thing takes place over in Shelter Island. Indicated in the response to comments, there was a 68% reduction in dissolved copper. Not sure that shows. I saw reports that indicated the data was closer to 45%. What has been indicating, though, is that the same report that came out showed that copper load has been relatively consistent over the past 6 years. In fact, I referenced the DPR report. They studied Shelter Island. 86% of the Shelter Island samples exceeded the acute criterion. And that's based on DPR. And I don't know what that means exactly, but I figure it's bad when you look at it based on a sediment. Well, that's part of why the San Diego board has shifted from a numerical standard over to an ecosystem services as they recognize, what are we doing here? And we've done a presentation, they did a presentation to CMANC, and they're talking about, okay, instead of numerical numbering in Shelter Island, why don't we take a look at essential fish habitat, eelgrass around it, and what are we doing there? Let's take a look and measure how we're deciding what ecological services are there. Are we talking about how we're going to ameliorate for sea level rise? Are we talking about the blue environment where we're changing how we're creating concrete in order to protect stuff in San Diego Bay? So there's a lot of information going on that I don't think all showed up to you. It's out there, it's publicly available. It's coming from other state agencies. So what I'm encouraging the board to do is go back to the Santa Ana board and say, hey, let's go ahead and take a look at what San Diego's doing, and why don't we start working on a biological system where we take a look at what do we really need to protect the environment, rather than taking something EPA forced down our throat and said this is a numerical standard. So I think the real question is, what are the ecosystem services, and are they being hindered by the dissolved copper concentration or not? Thank you very much for your time.
And thank you for yours, Mr. Hausner. You bring up a lot of great points. And then to my mind, it's really a matter of, does adoption today of this TMDL preclude the ability to continue to unpack all that and adjust as we need? And I think largely no. But I do appreciate your points here, and I look to the Vice Chair.
Yeah, I just wanted to thank you as well. I think you made a lot of good points, but it's my understanding of this process is that the number is intended to meet the TMDL, and that the regional board is indicating, it's an iterative process going forward. There's also flexibility on management practices and also site-specific. So you've made a lot of really good points, and I hope you continue to be engaged with us and with the regional board. Thank you so much.
Thank you, Vice Chair, and thank you again for the good comments. Next, I'd like to call up Jerry Desmond, and again, I believe at that point, our final commenter will be Bo Biller. Good to see you. Thanks for hanging in. I know it's been a long day.
Thank you, Chair and members. Jerry Desmond, and I'm with Recreational Boaters of California. We're a nonprofit advocacy group, been around for 58 years. I've been involved in the copper issue for over 2 decades. A number of our directors are from San Diego, Orange County, Marina Del Rey, and we've been involved on each step of the way with each of the regional boards, as well as the Department of Pesticide Regulation on low nitrate paints. And I think our message today to the board is not to say, no, this is not our last stand. This is the let's get it right. This is a let's get it right kind of situation. And we agree with City of Newport Beach and the analysis that they've done and the suggestions they're making. And I'll highlight a few. One is that boaters do want to boat in safe and clean waterways. And so we have a common objective. The second is that anti-fouling surfaces are critical not only to a boat being able to efficiently go through the water and not burn more fuel, but also to keep critters off the boat whole. And we're finding increasingly that invasive species are coming in. Most likely they're coming from commercial ballast water, but they're not always. The second is that we believe that, and we have encouraged each of these issues and each of the regional boards' consideration of their basin plan amendments, and one of them is the site-specific studies. We think that it would benefit everybody, whatever the finding is. Let's get the facts for that particular impaired body of water, and let's develop a plan that works there. It sounds like after a decade or two of experiences with San Diego and Shelter Island and in Marina Del Rey, we might get to those kind. But a direction in the in the decision being made today, not just to have the flexibility to adopt a site-specific outcomes, objectives, but actually a direction to do that. And we know it takes money. Third would be that even though it's a process that's iterative and we're told it could reopen, and San Diego had not reopened it for 15 years. We tried immediately to get it reopened, to look at site-specific models or buy a Ligon model, or to look at how the actual data was not supporting progress towards their objective. And what we were told is, well, we're each time we've adopted that, we've got that behind us. We have higher priorities to get to now. So we think the idea of this will develop over time needs to be very clear and stronger than just verbal commitments, that are here today, that are well intentioned as well. And then we'll just also add that. What are the lessons learned? What is the objective? We saw the recommendations of the city of Newport, but if you're a boater, we want to have safe paint that works. Our motto has been for 20 years, we will go to non-copper-based anti-fouling surfaces if they're effective, available, and affordable. And we're not there yet. The example of, well, we don't need to look at PFAS now. It's new. It's come from 2022. There are situations that you folks, as part of the multidisciplinary governmental entity looking at PFAS with the sampling orders to look at where they're at, there are some industries that were mandated to use PFAS that are being sampled for the presence of PFAS that they were mandated to use for fume suppressants on plating baths. So there's a potential liability to the boaters if it said we have to start using non-copper-based paints and find there's PFAS in it, the responsibility will be on the boater. So one of our takeaways from the lessons learned is that let's get to safe anti-fouling surfaces quicker. We've participated in DPR to support, establish a standard, have it work. We participate in the regulatory process, but that's what needs to be expedited. It's an alternative that works. Different boaters, very interested. Education, that's great, but they have to be convinced it's available, affordable, and effective. And that's where I would put the resources. And I think our organization would support that. And we will continue to be involved with each of the regional boards, but let's get it right this time, the third time. Thank you.
Thank you, Mr. Desmond. Next, Bo Biller.
Thank you, Mr. Chair, members. Bo Biller on behalf of the Marine Recreation Association. We are 150 of your marine operators throughout the state. Essentially, Jerry's folks are our customers. We are the gateway to recreation on the water in the state. Jerry said it all, so I will liken our comments with the RBOC. And in 2020, we did submit detailed comments, and if you want to refer back to those, that goes into all of the issues about anti-fouling paint, affordable, available, effective, and all the comments that Jerry just made. So I'll leave it with Misters Hausner, Miller, and Desmond, and liken our comments with them. Thank you.
Thank you as well. Really appreciate all our commenters and all the engagement on this. Really appreciate it as we figure out how best to support what is important work in reducing copper loading in our waterways, in particular our marine waterways. Looking to fellow board colleagues, if there is any further questions, comments around what was heard, feelings, glad to hear them. Vice Chair.
I'm in support, but I would like the region to respond to the last couple of concerns about ongoing work with the region. I looked through the resolution. I didn't see anything there in terms of a commitment, but I suspect either through your staff report or some documents that you have, you might be able to respond to that with respect to the ongoing work with the stakeholders and the science, collecting the information, and the iterative process.
We definitely commit to that. If necessary, we can put something in the resolution, but it certainly is discussed in the staff report. We, nor the stakeholders, can do this alone. I mean, we all need to work together on it. It includes the city, the county, Coastkeeper, RBOC, whoever is interested in assisting. We can commit as much as we can commit. Our resources, as you know, right now are limited, but we attended 3 technical meetings requested back in 2021 by the county and the city, and tried to reach consensus. And we did think we made progress, but the work product that came out of it was not what we anticipated. We can commit to continuing to do that. I think you know that the Santa Ana Water Board has committed to working with our stakeholders. We prefer to try and work with them rather than be in opposition to them. I guess we can't obviously make everyone happy no matter what we do. Maybe that means we've done our job, but we do the very best we can. And I especially am open to an iterative, adaptive management process. I know that word gets overused, but I think that's the only way to move forward with something like this that is changing so fast. I certainly agree with the ecological services. I think there is to be more work done there. But again, at this point, we are required by the Clean Water Act to adopt TMDLs for a known toxic constituent, which is copper.
Yeah, I'm very comfortable with that. I'm just looking to, so it seems to me, based on your presentation, I think you're going to be successful. But then the concerns being raised about whether or not it's going to make a difference. And that those seem valid concerns. And I can't imagine, knowing what I know as the liaison for Region 8, you all really are one of the top examples about collaboration with stakeholders, with all stakeholders. So as we go down the line here, maybe think along with OCC about maybe some level of commitment, another technical meeting. I don't want to be overly prescriptive, but to, at the appropriate time, sort of a check-in for, not necessarily for us, but for you all at the region.
Yeah, I support that, Vice Chair. If there's something that's helpful there to just, emphasize the intent here, which I know we continue to hear from the region, and I believe them that this is an iterative process, and there'll be more opportunity to make sure we're collectively learning as we implement, along with other regions, I think can be helpful.
That's
Reader,
really
please.
why we designed these to be phased. So we've got check-in periods at 4 years, 8 years, and then the 12 years. I think certainly by 8 years, we should know if we're going down the right track or not. And if we aren't, that would be a time then to reconvene and say, okay, maybe we need to reconsider this. Maybe you need to reopen these TMDLs and come up with another pathway.
Appreciate that, Ms. Reader. Mr. Lawford, did you have any comment there?
Well, I was going to point out that it's a fairly flexible implementation plan, and as pointed out by Ms. Reader, there are check-ins with the regional board. It could be that rather than any resolution language, the motions should encourage the ongoing engagement by the regional board staff and regional board executive management with the regulated entities and the cities and the boating community to help ensure that those milestones are effective and that the actions are that they're meaningful for the board themselves when they do the check-in, that they will have had that engagement during those periods instead of it just being an action item that comes back to the board at those regular check-ins.
And I would just add, technical meetings as appropriate. That way there's plenty of discretion as to the appropriate time.
Yeah, and look to the Zoom platform. Mr. Lindberg, did you want to make a comment?
Yeah, good afternoon, Mr. Chairman. Madam Vice Chair, I do appreciate your comments and questions regarding how we would go about implementation and adaptive management. Allow me to introduce myself. I'm Eric Lindberg. I'm the Executive Officer here at the Santa Ana Water Board. I've only been in the chair for 4 days now. But let me tell you, as a way of expressing our commitment, that the board members unanimously made it very clear to me that the collaborative approach in our watershed is their highest priority. We're part of the community that we regulate, and I am personally committed to make sure that our staff work with the affected stakeholders, members of the public, and come to a pragmatic solution. I can certainly commit staff to working with the stakeholders as described, by Michael and my staff. And if it makes you feel any better, I'm not directly opposed to some of the suggestions that Ms. Carr made in her presentation about BMP and activity-based compliance pathways. We're not closing the door on anything. But I can personally express my commitment to the board and to everybody who's here today for this matter, that we do want to find a solution that incorporates what's best for everybody.
Really appreciate those comments, Mr. Lindberg, and good to see you. And yes, congratulations on the official start of your work here with us. So thank you. Really appreciate it. Or in your new capacity as EO, at least. Thank you for that. And that was helpful. And thank you, Vice Chair. Other board colleagues?
Yeah, I'll
Firestone.
Thanks. Thank you. I think this was helpful. This is a long time coming. This is a really important area of the state, and both for the folks that use it and for the ecosystems and all kinds of users. I think this is a really important step that we take. I think it's a flexible one. It seems to me like moving forward on requiring BMPs is critical and not a step that we would regret. I think figuring out how that continues to adapt, continuing to assess what is this making the progress we need it to in this specific place? How do we make those adjustments? I'm hearing that's the intent, that's the flexibility and check-ins and milestones built in to allow that. I think this is the right approach. So I really support moving forward. And I also have seen, how regulatory programs and setting these goals will help the whole industry drive towards better products. Now, better options, better practices, and more knowledge and understanding about what works and what doesn't. So we may not have all the answers now, but I do think we have enough to say, this is the direction we're on, this is the next steps, and we're going to be setting forward these check-in posts to continue to assess progress and work together on that. So I really support, and I'll let other discussion before motions.
Thank you, board member. And I completely agree. I know that so much of the work we do is ultimately a balance, but the certainty or direction that we provide here in our regulatory programs helps folks innovate in the private sector because it provides those opportunities to figure out how we address this challenge and remove copper from anti-fouling, but do so in a way that makes sure we don't harm ourselves in other ways when it comes to invasive species and the need or increased fuel consumption for boats. So I agree, board member, and feel that we have a balanced proposal. Board member McGuire.
Yeah, I'll just echo my colleagues' remarks. I too am supportive. I think this is a step in the right direction, and especially with the understanding of the flexibility and the intent for a collaborative approach here going forward. 12 years sounds like a long time, but I also know how quickly that can go by at the same. So just leaning into that willingness to adapt and make course corrections along the way as we learn more, I think will be critical. So I appreciate that commitment. I also want to raise sort of an observation here, and that is a lot of the challenges that we find in waters associated with discharges are due to sources. So you have a source control challenge in our state, in our global environment that is daunting. And I think we look at PFAS as kind of the poster child of that at the moment, but there's a lot of issues. Copper is one. And it's hard. I think we heard from commenters about how difficult it is to understand what those impacts are. But there's so many contaminants in our environment and challenges there. So just hearing the conversation about the anti-fouling paints and the need for better research, science, and applicable materials, I think this is really a state level opportunity for us to say, it's not just Newport Bay, right? I'm hearing several regional boards who are engaged with this issue. There may be others, other harbors, other bays along the coastline that have similar challenges. I don't know. But I look at this as an opportunity for us to continue our engagement with Department of Pesticide Regulation and others at a state level to help support movement in that direction of identifying useful alternatives here to support this TMDL, but also other areas around the state that could use it.
Yeah, appreciate that, board member, and agree. And we'll just note, I know one of the questions that was posed earlier, are we talking with the Department of Pesticide Regulation? Are we coordinating? And we do. We coordinate quite extensively with our sister agencies, not just here under the Cali PA umbrella, but across the state. And so know that we are here doing our best to use our authorities across our various agencies, and agree, board member, that we can continue to focus on that and figure out how we do our part in trying to address what we can on the state level as we work with folks at the local level to achieve these reductions. So thank you. All right, I think we may be prepared for a motion, Vice Chair.
Okay, great. So just again, thank you all. Thank all the stakeholders and for the really terrific work at the region. And with that, I will make a motion that includes our encouragement that the regional board continue its collaborative processes with all stakeholders. So that would be the regulated communities, cities, counties, environmental groups, and that as you move forward with your check-in periods, that you consider as appropriate a technological review on implementation, as well as continuing discussions with at the state level, our board, our sister agencies, and the regional boards, as hopefully ongoing work is done on different alternatives. So with that, I will move adoption of the resolution.
Thank you, Vice Chair.
I'll second.
Thank you, board member. Ms. Tyler, can you please call a roll call vote?
Vice Chair Diadamo?
Aye.
Board Member Firestone?
Aye.
Board Member McGuire?
Aye.
And Chair Esquivel?
Aye.
Thank you.
Thank you as well. The vote is unanimous and the resolution is adopted. Thank you all again for the engagement. Look forward to hearing how things are going at the regional board on this item. And just thank you. Much appreciation, everyone, for the good work here. All right, that concludes item number 5 today and brings us to the end of today's agenda. This is a 2-day board meeting, so we will be in recess then until tomorrow at 9 a.m., where we will pick back up. And I think our first item is regarding PFAS. So to the extent folks' appetite was whetted today with PFAS discussion, we'll have a lot more tomorrow. So thank you all. Much appreciated. Have a great evening, and we will see you tomorrow morning at 9 a.m. We're in recess until then. Thank you. Be safe. Be well.